all mentioning list to my court officer. Only I will take the matter with regard to any
Only one matter.
whatever it is, it may be given to my court officer. Only I will hear if there is an urgency in the unlisted motion.
Lordship, only one matter Lordship had allowed by mentioning on the last occasion regarding the stoppage of treatment. But when also the matter has treatment for IVF, Lordship remembers that Lordship has passed similar order. Lordship had inquired on the last occasion. I had mentioned Lordship had allowed. Lordship, any date, but the date was not fixed, so it has not come up, Lordship. Any date this week, if this matter.
You mentioned that.
Yes, Lordship. I have this order is
Lordship,
there. The
Lordship, may I get
order is
may I get your Lordship kind to move on urgent tender matter, Lordship?
Only I will take unlisted. Whatever the mentioning, you give the mentioning list to my court officer.
Matter, Lordship, what happened, Lordship?
Kurada.
In 2000,
What is your unlisted?
Lordship,
Yes.
Lordship, what happened, Lordship? In 2025, my tender was set.
Huh?
In 2025, Lordship, my tender was rejected. I have
Ah.
work order was issued, so the Honorable Court directed the authority that if extension is given to the existing contractor, then my case has to be considered.
Ah.
Lordship, they are going to extend the case, work order, Lordship, without considering my case. Lordship, I have made the representation, they are not considering. Lordship, specifically Thursday, Friday.
So already there is an order of consideration. What the
Lordship,
court
one
will
year
do now?
They are not considering. That is
So
why
what the court will do?
Lordship, the last kindly that
Where is the fresh cause of action?
Lordship, they are giving extension, Lordship.
They have given extension. When given?
And they are going to give extension, Lordship. So I have made representation on the basis of the High Court's order, Lordship. They had kept the tide over the issue, Lordship. Kindly, Lordship, take up the matter any day, Lordship. Thursday, Friday, any day, Lordship.
Look at 23.
My Lord, may I be permitted to?
23 within 10 minutes.
My Lord, may I be permitted to?
The mentioning you, I will not hear. Yes, call the list.
My Lord, may I be permitted? My Lord, saying some these, my Lord. My Lord, SR application, my Lord.
I will not take.
Lordship, petitioner is
My Lord, shall we? My Lord, shall we file, my Lord?
Yes, Calcutta file.
Lordship is suffering from
Extension of interim order.
Lordship, interim order is
Item number 1, who is appearing? Item number 1.
interim order is expiring today, Lordship.
Lordship will allow me.
Lordship.
Lordship will allow me to mention my
Renal disease. Well, his
Interim order is going to expire.
interim order is refused. The respondents are directed to file affidavit in opposition 3 weeks. Reply within 2 weeks. Please the matter on 26th August.
Lordship, interim order is going to expire today, Lordship.
Lordship, petitioner is suffering from end-stage renal disease under compelling circumstances. I am praying for leave to file this application. Lordship, petitioner is suffering from end-stage disease.
That's all. Order हो गया. Call it.
Failed to release a matter due to lack of jurisdiction of this honorable court.
Yes. Who is for the item number 8? So भी भेजो correction करना है मत देना. Who is for that? Item number 7, interim order refused.
Item number 8, my lord.
Yes.
I'm for the writ petitioner, my lord. Here, what has happened, my lord? Petitioner has participated in one e-auction agreement, my lord. And as per the
Who is for the respondent?
my lord, respondent is already appearing, my lord, and I have served notice upon them. Previous occasion also the matter appeared on Friday, but they took time. This is my affidavit of service. My lord, the composition of the train, my lord, as per the railway board policy, after conversion, only permits. My lord, Mr. Shonojit Ghosh is appearing. My lord, I have a tremendous urgency because tender will going to be open on 12th. My lord, initially what has happened?
Yeah, what is the matter?
The matter is this, my lord. In respect of one train, my lord, a policy decision has been taken that after rake conversation, there will be one brake van at the front and one brake van at the rear. Now, my lord, after such conversion took place, Eastern Railway floated one tender. And I participated, I became the highest bidder. Accordingly, my lord, I was entrusted with a contract to operate for 3 years. Now, my lord, The e-auction agreement is at page 19. Now, my lord, as per the railway board policy guidelines and as per the conversion policy, only one brake van can be accommodated in the front of the said railway, said train. My lord, railway knowing fully well that there is no other scope of attachment of second brake van. They have illegally floated another tender, which I have impugned here. If your lordship sees once the rake conversion policy, which is at page 75, which came on 2nd of June 2000. Kindly see, this is very important, my lord. This is rake conversion policy, which has been floated on 2nd of June 2026. Kindly mark this date. My lord, kindly see the tabular portion which has been stated. Initially, the composition of the train was 19. Now, the composition of the train has been reduced to 17 coaches. So, 2 brake vans gets out automatically. 2 remains, 1 at the front, 1 at the rear. I have been allotted with the e-auction so far as first compartment, first brake van is concerned. Now, railway knowing fully well that there is no other space to accommodate any other person, have floated another tender which I have impugned. My lord, which is that?
No, this is the conversion dated 2nd June 2026.
Yes, my lord.
This is the latest one.
Yes, latest
Correct.
one.
Yeah.
Tender has been floated as per my, where I have participated, is of 19th of June. That is after 15 days. Lordship,
Where is
kindly
that?
come to page 19 first. Kindly see what the illegality, perverse illegality they have done. Page 19.
Page?
Page 19, 19, my lord. Kindly see.
This is of 23rd June.
Yes. My lord, kindly see.
This is the latest one.
This is the this is where I have participated. I emerged as the highest bidder. I was granted with the agreement to operate for 3 years. Kindly see the contract start date, 3rd of July 2026, and it operates till 2nd of July 2029. Thereafter, lordship, kindly see the mode of allotment. Tender was floated on 19th of June 2026. Lordship has found. So this is after the conversion. Railways were aware.
How it can be? You are telling that this has been issued on 23rd of June 2026 and mode of allotment e-auction 19. How it can be?
No. Rate conversion is of 2nd of June 2026.
So just you are tell that rate conversion is 23rd June.
No, my lord, 2nd of June. My lord, page 75 at the top. It is stated.
Sir, I put the question to you. You're putting the page number 19.
19 is the agreement which has been executed pursuant to my e-auction participation.
Where is your e-auction?
E-auction is at page. My lord, e-auction is at page 88. Page 88. My lord, 3 columns under AA3, train number 13105. Lordship has found. Once kindly see the parcel space, front SLR in part trip SLR license fee 19th of June. 19th of June. So this is after my lord rate conversion. It's very important, my lord. My lord, then lordship, kindly see the railway board policy. Policy is very clear. My lord, kindly come to page 80 for once. Lordship, kindly come to page 80, then 81. I cannot be ousted in this fashion.
Yes.
Page 81, my lord, kindly see. In supersession modification to this is a railway board circular of office interim ad hoc measures taken by later dated such and such. It is proposed to adopt following procedure for uniformity of action over this railway in case SLR after conversion of rake from ICF. Now, my lord, procedures for dealing with ongoing lease contracts of SLRs. Compartment. First compartment, if it is leased, it has already been leased. Lease contract is to be continued.
No, in supersession of modification of the office interim
Ad hoc
measures taken by, it is proposed to adopt the following procedure.
Yes, that is
For
after reconversion.
Uniformity of the action.
Yes.
So procedure for dealing the compartment FSLR.
Yes.
What is your compartment?
Compartment is the first brake van.
What is your compartment? FSLR?
FSLR.
Yes.
If first compartment is leased,
Ah.
what will be the scenario? Lease contract is to be continued.
Continued.
So I have already entered into an agreement with the railways, which has a tenure of 3 years. So it has to be continued.
So when the tender was issued to you?
Tender was issued on 19th of June.
19th of
June.
No, this is a tender. You're telling that tender. No, where is the work order? Is the work order?
Yes, my lord. Work order is at page 19.
90.
Yes, 19, 191. Work order is 190. Kindly see, everything is stated here. All details. Contract number, SLR front.
This is a work order.
Yes. Contract start date.
The work order start on 3rd of July 2026.
Grateful, my lord.
And it is up to 29.
Grateful, my lord.
So it is the model allotment 19 June auction.
Yes.
So 19 June auction that has been taken into consideration of the 2nd June conversion rule.
Yes.
Then,
Then thereafter, my lord, violating everything.
Hmm.
Page 9.
So this is your contract is up to 2nd July 2029.
Yes.
Then what has happened?
Then, my lord, what has happened? Going against the railway board policy, they have floated another tender in respect of the front brake van. That is at page 90.
90.
90, my lord. Kindly see. It has been floated on 20th of July. It is going to open today at 12. Kindly see chain number
13105.
13105 front SLR.
FSLR.
Then, my lord, kindly see the closure date of time. That today, 20th of July, 12:30. Now, my lord.
So this is also your same.
This is same.
No, the 19. That is prior to come to the 88. 88, the first tender.
88 is of 19th of June.
That is the first tender.
That is the first tender.
In which you are participated.
I become the highest.
That is the train number, okay, 13105.
Yes.
SLR front 2.
Front
But is the front 1.
As per the railway board policy, only one will survive. Lordship, this is, I made a representation before the authority.
Just a minute. So first is the front 2, Shalda.
Yes.
Correct.
Yes.
And now it is the front 1.
Front 1.
Yes.
Front. But
Correct.
only as per railway board policy, one will operate, another will not.
Why?
Because of the rake conversion policy.
Why? Where is it said that?
Yes, rake conversion policy. Kindly see, Lordship. Page 75.
Yes.
Page 75. It has been stated here. Kindly see the revised LHP composition. Under the tabular form, my lord, under this head, revised LHP composition. LSRD1, LSWRRM1.
Yes.
Well, here only 2 brake vans will operate, one at the front, another at the rear. Under revised LHP composition, Lordship has found, under revised LHP composition, only one will operate at the front and another will operate at the rear. So I have already undertaken an agreement.
No, your agreement is with regard to the front.
Yes, there were initially, my lord, prior to rake composition, prior to rake conversion, 2 front vans.
Where is prior rate conversion?
That is also here. That is also here prior to existing composition. Existing composition, my lord, will find 2 at the front, 2 at the rear. Total 19 coaches.
Total 19 coaches.
After rake conversion, it comes to 17 coaches.
Correct.
So 2 goes out. 2 goes out. 1 remains at the front, another remains at the rear.
Correct.
I have already given 1 front. So there is no occasion to give anybody.
So why it is not the back rear? Because
rear it cannot be given.
The 70, 90 kindly come to the 90.
Page 90.
Yes, 990.
My lord, rear cannot be given because of the reason there is an Honorable High Court's direction of interim order. It is already stated that.
And come to 90.
90.
Read.
Lot number such and such 13105 SLR F1 Shialda. Now, my lord, this was the front one, F1,
Correct.
but this cannot exist.
Why you are telling it is no, it cannot be
It
exist?
cannot, because after reconversion, there cannot be two front break vans.
Where is your reading? Where is your interpretation? How you are interpreting
My
that?
lord, kindly see the railway board circular first.
Yes, I have gone through circular. You have shown me. Where is that?
Yes, railway board circular.
How you come to that interpretation?
Yes, my lord, just give me a few seconds. My lord, railway board circular is at page 80.
Page
80. 80.
80.
80.
Yes. Relevant circular, you have mentioned that page 81.
81 is the starting. Page 81 is the starting. This has been done that how.
So where from you got the interpretation of F1 and F2?
Yes. My lord, here subject procedure for leasing SLR compartments is train number converted to LHB.
Subject.
Yes, kindly see the subject. What is the procedure to be adopted after
procedure for
conversion?
leasing SRR component to LHB.
Yes. Now, Lordship, kindly come to trains having no reversal en route and converted to LHB rake.
Trains having no reversal in route converted into LHB rake.
Yes.
No problem.
Now, if one compartment is leased, then that lease contract is to be continued.
Correct.
I should be continued.
Correct.
Now, if only both compartments are leased, first contract in FSLR high rate and first contract to be given in the rear second high rate with direction to the leaseholder that he will be accommodating railway booked luggages, reserve passengers only up to 10% of carrying capacity. So, my lord, there can be only two break vans from this interpretation. There cannot be third break van.
Correct. So you are only one.
I have one.
Yes.
The railway can only give one.
Yes. So
Kindly
now you are coming to second. Where is the seizing that they cannot go for the second?
My lord, this is the recently headquarter. I have made a representation. They have also said the same thing.
This is the problem with all of you.
My lord,
Hearing you coming out supplementary, you coming with another document.
my lord, kindly have a look. My lord, kindly have a look.
Yes. What is there?
It is stated that reference above a representation has been received by this office regarding allotment of lease contracts in such and such consequent upon LHB conversion. The matter has been examined by this office and following observations are made.
Yes.
Notification on conversion of rake was issued on 3rd June 2026.
Correct. No problem.
Auction of FSLR 7 days in a week was published on 2nd of July 2020 with commencement of contract schedule 5th of August 2026. At the time of publication of auction, two contracts were already in operation in chain number such and such. At the time of publication of auction, it was already known that the asset would remain available only for limited period 5th of August 2026 to 10th of August 2026. In view of the above, it appears that the lease contract was floated despite prior knowledge of limited availability of lease assets. Such situation may lead to unnecessary disputes and litigation. As desired, the matter may be examined and reviewed from all relevant perspectives, and suitable corrective measures may be taken to ensure that no litigation arise in future on this account.
Correct.
So, my lord, they have also apprehended that if there is a second tender over the front SLR, then I will be terminated because I am at present the highest bid, and as per the railway board circular, I cannot be outstayed in this fashion. This is also been taken note of by the headquarter. If railways are appearing, if they say that they will protect me and they will not terminate me, then I am not going to press this.
How it can be? And your authority letter, you are having letter, 14 July letter?
Yes.
Go
I
through,
don't know, my lord, what is produced.
go through the 14
My
July
lord,
letter.
prior to that, my lord, kindly consider that identical issue, at least 4 matters I know. Identical issue that has been moved before the Group 7 bench. And one of that order is also annexed herewith. And my lord, my humble and respectful submission that your lordship, my lord, the determination is Group 9.
My lord, I have challenged
Learned
the
counsel for the respondent submit that this court
My
is
lord,
not
I have-
having the
I have
determination
challenged the
according the matter is released from the list. This court the liberty to
I have challenged the tender.
yes.
I have not challenged
Liberty to the
anything. I
parties to
have
mention
challenged the
before the
tender.
appropriate court. Yes. Next.
My lord, I have challenged the tender. Lordship is taking tender matters pertaining to railways.
You have mentioned our 4 matter other court.
No, this that is
Yes.
completely
Call-
different matter. My
call
lord,
the-
impose cost upon me if I have. My lord, kindly visualize one thing, my lord. I have not, I have
Who is
only
for the
asked,
9?
my lord, kindly
Who is
visualize.
appearing for 9?
Well, I am for the state, my lord.
But this is that flat plot which the tenant plot has.
Yes.
willing to
I received
vacate.
instruction, there are no police posting anymore, and the CCTV footage and all that has been taken care of. My lord, they have filed a report, my lord. The officer is also here. Huh?
When have you withdrawn the pleas?
আমাদের ছবি আছে, যে আমরা যখন মুভ করেছি পুলিশ ছিল।
7 দিনের আগে ছবি
দেখাও ছবিটা।
আমি দিয়ে দেবো, হ্যাঁ?
পুলিশে রিপোর্ট দেবো, নাহলে কালকে আবার অন্য সেক্রেটারি এসে লোক বসে
এটাকে ছেড়ে দেন, হচ্ছে যখন রেকর্ড করে দেবে।
Yes.
Lord, kindly record that, Lord, they have removed the police and they will not, Lord, obstruct in removing the furniture fixtures and whatever, Lord, the tenant wants to remove. And Lord, kindly, Lord, also give a direction that, Lord, we will be free to vacant possession from respond number 5.
They have recorded no objection, my lord. They have recorded no objection.
The petitioner has filed the present date application praying for a direction upon the respondent number 124. 124. To desist or forbear from any manner obstructing, hindering, or preventing the vacation of the demised premises, and to deliver the vacant and peaceful possession of the premises in question by the respondent number 5 to the respondent number, by, respondent number 5 to the petitioner. Full stop. Yes, yes. To the petitioner. You are for the respondent number 5.
And my lord.
No,
No,
I am for 5.
Five
Is the
Who is for the respondent number 5?
I am for appearing for
Respondent number 5. You are ready to give the possession to the petitioner?
always from the very beginning it was our intention to give the vacant and peaceful possession, my lord, but because of some unforeseen some forces we could not.
Leonard, counsel for the respondent number 5 submit that due to the unforeseen reasons and the deployment of the police, the petitioner, the respondent number 5 was not in a position to vacate the premises and to hand over the same to the petitioner, though the respondent number 5 is ready and willing to hand over the vacant peaceful possession of the premises to the petitioner for taking appropriate steps by the petitioner for leasing or the premises to any other purpose, any other persons, or to utilize the said premises by the petitioner themselves. Full stop. The Leonard ASGI has submitted an email wherein the
Email dated July 12, 2026.
dated 12th July 2026, wherein it was informed that the enforcement directorate has conducted search proceeding under section 17 of the PMLA 2002 at the office premises of the Indian Pack Consulting Private Limited on 8th of January 2026, which resulting in nil seizure owing to certain external interference. He submits that enforcement director has no objection if the premises is vacated by the Indian Pack Consulting Private Limited and furniture and fixtures removed, subject to compliance of the order dated 15th of January 2026, passed by the Honorable Supreme Court in writ petition within bracket criminal 16 of 2026. The who has filed this respondent number? You are appearing for respondent number?
And for 3, my lord.
Huh?
3.
Respondent number 3 has filed report wherein it is mentioned that the respondent number 3 has also no objection if the premises is vacated by the Indian Pack Consulting Private Limited and the furniture and fixture removed subject to compliance of the order passed by the Honorable Supreme Court dated 15th of January 2023. Consider the submission made by the counsel for the ASGI and the Land Council appearing for the respondent number 3, report submitted by both the authorities and the order passed by the Honorable Supreme Court. The Honorable Supreme Court, by an order dated
Next to my report, Lordship.
by an order dated 15th of January 2026, directed the respondents to preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8th of January 2026. It is submitted by the Learned Counsel for the respondent number 3 that in compliance of the order passed by the Honorable Supreme Court, the respondent number 3 has preserved the CCTV cameras and other storage devices containing the footage of the both premises searched on 8th of January 2026. Considering the submission made by the counsel for the respective parties, perused the report and the judgment passed by the order passed by the Honorable Supreme Court, the respondent number 5 is a liberty to hand over the peaceful and vacant possession of the premises to the petitioner within
By tomorrow, my lord. My lord, at least for within fortnight, my lord.
within a week from date.
Lord, I have to, Lord, I have a corresponding obligation to hand over the possession.
Within
Lord,
a week.
on within a week, my lord. Lord, kindly give them 48 hours, Lord, kindly. Lord, we have lost, Lord, more than a month. From 31st May, they were supposed to hand over. This June gone, July gone, Lord, and it is your.
Nothing will happen within 1 week from date. Within 1 week from date, and not taking possession of the premises by the petitioner. Petitioner is liberty to utilize the same or to let out the same for the convenience of the.
Lord, your lordship has recorded, Lord,
accordance.
that the CCTV footage is in the custody
Already
of.
recorded. Already recorded.
Because I don't have a copy of the report, that's why, Lord, I'm
Already recorded in the order also.
much obliged. And Lord, if necessary, they will break open the padlock, Lord. No further excuse on.
Peaceful possession and vacant possession be handed over to you.
I'm much
Anything?
There is just apprehending that I will keep it on Monday for blood compliance or not blood, only that.
Come. 1 to 6. So आए नहीं जब बुलाया. They are not come. They are not come. Go out of the list.
My lord, 10 I am late by Mr. Chakraborty, my lord. It is appearing online, my lord.
Oh, the report सबको उसमें लगते हैं. Yes.
My lord, item number 10, today morning I receive information from the railway that there is no engagement, till date I have no engagement. Only 2 days accommodation may be given.
Yes.
Because I have
not
been.
Appearing online.
Yes, he is asking time. As per the prayer made by the council for the railway, the case is adjourned. Let the matter appear on 7th August.
Same, my lord.
Next.
Same heading, my lord.
7th August.
Same heading, my lord. Bring
Let us see. We can't say. You lost your chance.
my lord,
What
I
can be
am
done?
appearing, my lord. I have
So while your chief is not here, not moving,
my lord, she is appearing, my lord.
what can be done? Yes, call that matter.
My lord, may I submit one thing, my lord?
Online, you are not moving the matter. Court will sit here. Yes, call the matter.
Item number 11, I am appearing on behalf of the petitioner. Before my lord takes up the matter, I shall indicate one thing to your lordship. My lord, this is a surfacey matter. But after filing, it came to my knowledge.
Release.
My lord, it came to my knowledge that
What is the prayer? London Council for the petition submit that the matter relates to the Surface Act, and accordingly WPA number 17041 of 2026 released from the list of this court with the liberty to mention before the approved court having determination. Next.
12, my lord, I'm opposing this application.
My lord, I appear for the petitioner. My lord,
I appear for the respondent.
Well, I have a preliminary objection. The writ petition is not maintainable. This is an abuse of process of law and court. My lord, may I
May I
explain
start?
why?
May I start? May I start? I have not even started. Well, Lordship will
I'm
kindly
taking a
take volume-
preliminary objection, in which case
May
I
I
get.
start and may I start it and then my learned senior friend can take all these objections. And kindly takes volume 8.
What is the
Lordship will
plenary
recall.
objection?
My lord is asking, my lord,
Objection, Mr. Sarkar?
My lord, kindly consider, my lord, last week, Lordship had considered this matter. This concerns the Triveni Engineering DVC project, where the matter had gone to arbitration. Lordship disposed of the writ petition by holding that we are abiding by our undertaking, that we've called a tender but we will not induct any third party but into the premises physically till the joint measurement is over. Lordship disposed of that matter. Now, Lordship, we have come out with a tender for a completely different project, nothing to do with this petitioner. They have challenged my tender. But they are not even participating in this tender. They have nothing to do with this tender. This does not concern their project at all. It's been challenged, Lordship, by making a false statement that this is part of the project where they were participating. That is not correct. This project has nothing to do with the petitioner.
yes, my lord.
Yes.
This has my
But,
lord.
my lord, may I say, my lord, Lordship will kindly have your Lordship's order. The previous order is at page 1086. Kindly takes volume 8.
10?
86 volume 8, your lordship.
86. 1086 is your Lordship's order of 13 July 2026.
1086.
तुम लोग सब कोर्ट में आने से पहले सब नहीं कर नहीं सकते यहाँ तो
দীপক এটাও তো দেখানো উচিত না
सुबह से आगे करते क्या रहते पता नहीं which volume?
Volume 8, your lordship. Page number 1086.
Yes.
ডেলিভার্ড হচ্ছে
Yes, then?
ডেলিভার্ড হয়ে গেছে মেসেজ
Yes, Mr. Dasgupta, then what happened?
My lord, I am appealing for the authority concerned respondent. Taken specific instructions for the tender which has been challenged. This writ application is not unconnected with the order which my lord has on the last occasion. It is completely a distinct identity concept.
But
Situation.
I'm so sorry, my lord, I got disconnected, my lord, for some reason. My lord,
Where is the tender notice, sir?
My lord, volume 7 and volume 8, my lord. It starts at volume 6, your lordship. It starts in volume 6.
Yes.
CSF complaints.
But may I indicate to your lordship that lordship has have your lordship's order for of 13 July 2020. I was disconnected, my lord. I'm so sorry. I for some reason there was some internet connection. That 13 July 2026 order, the second paragraph, lordship has lordship has recorded the project name. Lordship will kindly have second paragraph of your lordship's order of 13 July 2026 at page 1086.
Yes.
Lordship will
Yes.
see the previous tender was with regard to residential and non-residential buildings included such and such for RTPS Township Phase 1 in CISF area. That was the project. Now, my lord, if your lordship kindly takes the after your lordship's order at page 1092.
Correct. Now,
This is the new tender.
where is the present tender?
Present tender is at page 1092.
my lord, subject to my lord's consideration, my lord, this is a new tender, not
The present tender.
Yes,
Lordship.
One
The tender which the tender which we are challenging is at page 1092, volume
Yes.
8.
Yes.
Kindly seize the subject.
Yes.
This civil work for township, including CISF complex at DVC RTPS. This, according to us, Swarad, is the same project, same subject matter. It's the same residential and non-residential township in which the arbitration reference is going on between the parties.
Correct.
Now, in your Lordship's previous order, Lordship will see the respondent had submitted that they will not induct any third party till such time the joint measurement of the complete work and incomplete work is completed. So that was on the basis of that submission, Lordship disposed the previous writ petition of. If your Lordship kindly takes paragraph 7 and 8 at page 1089.
That is correct, sir. I have gone through your order. You tell
Yes.
me how you connecting with this order along with the other previous work order.
yes.
We are only concerned with, since the joint measurement is going on. Now they cannot
Yes,
induct any
correct.
third
That I
party.
understand. I pass an order. I have gone through the order. Now the present tender is civil work for township, including CISF complex and DVC. And the other tender is with regard to the balance work of the construction. Whether
Yes.
this is the same, they are telling that this is not the similar work. You are telling the similar work. How the court can decide in the
Site is-
jurisdiction?
The site is also different. May I
Sure.
take your lordship if your lordship allows?
How it can
Yes,
be
well,
done?
I may led by Mr. Shengupta, Lordship will kindly allow him. He's in
Lordship
court.
allows me, your lordship.
He
may I
has a
take
right.
it? 1092, your lordship, is the project, your lordship, in the same site.
Correct.
Now, in the same site, if they induct a third party, my joint measurement, your lordship, will be finished.
See, kindly come to 735, the earlier tender.
Yes, your lordship.
Correct. And the
735.
present tender.
Yes, sir.
And the order,
735.
this court's order at page 190, 180, 190. How it can correlate? All the work can be correlate. These are the three documents to satisfy how the work can be correlated.
Yes, your lordship. Our contention here, that NIT which was given it to us, your lordship, that is in connection with the entire work, civil as well as electrical.
Correct.
Now, your lordship, page 1092, because in that particular site, your lordship, there was no other contractor. We were doing the entirety, civil as well as criminal, civil as well as, your lordship, the electrical.
Correct.
Now, page 1092, your lordship kindly seeks, is a civil work for township.
But whether the same work, how it can be?
Lordship,
Who can identify?
only one thing, your lordship, kindly
How this
appreciate.
court can
Well,
assess
it is a different township, Lordship.
But
This is an
I-
existing township where the petitioner had nothing to do.
there? Kindly come to the page 1092.
Yes,
Page
lordship.
101, page 735, read with this court order. That is with regard to the
735.
township of phase 1 in the CISF area.
Exactly.
But this does not really reflect with regard to the phase 1.
No, your
Grateful,
lordship,
Lordship. The
This is-
CISF area has multiple, more than one township. This concerns a different township.
now, your lordship, there are three, your lordship, tender which is in dispute. First tender which was given it to me, that is in connection with the civil and electrical of the entire, your lordship, of the project,
Correct.
of the entire. I can show your lordship the NIT. Now, 735, your lordship, what your lordship is considering, that is in connection with the balance work.
Correct.
Now, which they have given, your lordship, is 1092, is covered, your lordship, in connection with the work which was given to me.
Okay, let the file an affidavit then.
Well, we'll clarify. We'll show this is not even the same township.
Yes, my
It's
lord.
not even the same township. I don't know what my learned friend is
No
submitting.
problem at all, your lordship. They will not, your lordship, kindly appreciate, they will not induct any third party in connection
No,
with.
Lordship, there is
No.
absolutely, this is a different township. Malad kindly appreciates.
The order passed by this court and the order passed by the arbitrator.
Yes, my lord. Yes.
This court has categorically held that unless and until the survey report is filed, the
Lordship.
total special officer will conclude the third envelope will not be open.
Yes, your
Third
lordship.
envelope is
I am
the
protected. I am
correct
protected. to
price
that
bid.
extent. Yes,
You
your
have been protected.
Yes.
Now you are telling that now to avoid the order passed by this court as well as the arbitrator, now they have changed the work, but the place is the same.
That's my contention.
Malad, I am submitting the place is completely different. It's not even the same township, Malad.
You come and sit here.
My lord, I'm sorry, Lordship. There's a lag, my lord. I couldn't hear.
So now who will identify? They are telling that this is not the similar work. You are telling the similar work. Let them file an affidavit giving the total schedule. Let them file the schedule that this schedule is not coming. And where is the schedule in the return in your tender? Where is the schedule? You give the schedule in both the places, then the court will decide that.
Yes, that should kindly take page 1147 is the BOQ. This is your lordship, the BOQ, we have got it.
1147.
Because the site is same, that's only the problem. Your lordship is not the same. We have taken instruction.
Okay, then they come with the schedule.
No problem, lordship.
Both the schedule.
My lord, within a
Verifying that this
yes,
schedule is
acceptable. Yes, no problem. Lordship, my only concern is if during the joint inspection, suppose a third party is inducted, the entire joint inspection will go.
Correct. Well, let the file.
Yes, let them show.
Tomorrow or day after tomorrow.
My lord, today we are on Monday, my lord. Within Wednesday, my lord, we are going to.
10 days going to open.
20th.
20.
My lord, this has been extended pursuant to my instructions. My lord, this has been extended, and my lord, within Wednesday we'll file a short affidavit.
When this tender will be open?
My lord,
It'll be a single bid tender.
My lord, I'll take instructions.
Single
Just
envelope tender, not the 3 envelope tender.
yes, my lord. Yes, my lord.
Then
My lord, I'll just take instructions for once. My lord, just give me half a minute. I'll just.
where is the schedule of where is the schedule? With regard to the opening of the
My
tender.
lord, this is extended till 27th of July 2026, my lord.
27 July.
Yes, my
I
lord.
will record your submission.
Yes, my lord, taken instructions from my client. My lord, the bid opening date, that is envelope 1 and 7th of July 2026.
1 and 2.
No, single name. My lord, envelopes, my lord, this is, yes.
Only see 192.
BOQ.
Single listed, single envelope basis. How you can say that?
My lord will kindly, my lord, pursuant to my instructions, my lord, 27th of July, my lord, within Wednesday, page 1146. The big opening date, your lordship, is mentioned in the. Yes, that has been extended pursuant to my instructions. Page 1126.
Record is submission. I will.
Yes, your lordship. Page 1146. Bid opening date is 20th July 2026.
Lordship, kindly records the submission we are submitting that it's been extended. My lord, my learned friend cannot have any problem with that.
The grievance of the petitioner in the present writ application. That there is a dispute with respect of the balance work of construction in the integrated township of residential and non-residential building, including water supply, sanitation, electrification, firefighting, etc. for RTPS township within bracket phase 1 in CISF area, RTPS, district Purulia, West Bengal. With respect to the said work, the arbitrator has passed an order by appointing an special officer for joint inspection. And on the basis of the order, passed by the arbitrator, this court disposed of the writ application being WPA 16239 of 2026 dated 13th of July 2026.
Page 1086.
2026. Directing the respondent authorities not to open envelope 3 unless and until the special officers appointed by the tribunal will complete the inspection of the incomplete work in question. Land counsel for the petition submitted that in spite of the order passed by this court as well as the arbitrator, now for the similar work, the respondent authorities have issued a fresh tender under the Subject, civil work for township including CISF complex at DVC RTPS. He submit that the said work is overlapping the earlier work, which is the subject matter before the learner arbitrator. Learner counsel for the respondent authorities raise objection and submit that the earlier work in which the arbitration proceeding is pending and special officers were appointed for inspection of the premises, for inspection of the complete and incomplete work is totally different from the work in the present tender. Full stop. Though there is a dispute with regard to whether the work of the earlier tender and the work which was the subject matter of the earlier tender, and now the proceeding is pending before the learner arbitrator, and the tender issued by the authority and the present work in which the respondent authorities have issued the tender are similar, the respondent authorities are directed to file a short affidavit giving the schedule of the work of both the works to justifying whether the work of the earlier tender and the work of the present tender is different from each other. Land Council for the respondent further submit that the opening of the bid, the date of opening of the bid is extended till 27th of July 2026. Accordingly, respondents are directed to file their report by 23rd of July 2026. List the matter on 23rd July under the same heading for filing report by the respondent.
Deeply obliged, my lord.
Grateful, Lordship. Grateful, my lord. Grateful. We'll come back with the affidavit.
But the point of maintainability, if my lord subject to my lord's can consider.
This is
Because this is arbitration.
Respondents have raised the point of maintainability, the same is kept open.
Grateful, Lordship.
I'm grateful.
Next.
But I appear on behalf of the petitioner, my lord.
Yes.
I beg to appear for the pollution control.
But today,
I'm the pollution control.
everybody is late, my lord, because of yesterday's match. Because of yesterday's World Cup final, somehow Messi magic did not work, but Lordship, my lord, sat before time. My lord, may I file the affidavit of service? My lord, the subject matter of dispute in this matter is an order of the pollution board, my lord, whereby the pollution board held that noise level of my factory premises is higher than the permissible level.
Yes.
Now, my lord,
you are running the factory with noise pollution?
If that is the case, my lord, I am out. But what they have done, my lord, there was an earlier order, and that was set aside by your lordship. They did not comply with the total non-compliance. And secondly, my lord, finds things are contradictory. Kindly, my lord, comes to your lordship's order at page 115. I will not trouble your lordship much, my lord. 115.
115.
Yes. Earlier also they did that, and lordship set it aside, my lord. On what basis, my lord, and what are the grounds, I will show you. My lord, lordship has got this order dated 9th April 2000. May I, my lord, place it? Affidavit of service and supplementary affidavit filed by the petitioner be kept with record. The petitioner, kindly, my lord, skip over, my lord.
And you come to paragraph 7.
Yes, absolutely, my lord. Paragraph 7. In view of the above, this court is of the view that the petitioner is entitled to get an opportunity of hearing first. Thus, the impugned order dated such and such, passed by the respondent authorities, is set aside and quashed with the liberator authority to decide the complaint filed by Mr. Anup Kumar Bhattacharya by giving an opportunity of hearing to the petitioner and supplying the copy of the complaint to the petitioner. And if the authorities are relying on the report, the copy of the report be also forwarded to the petitioner. The authorities should complete the entire exercise 12 weeks. Now, what they did not hand over the complaint. They did not hand over the report. They proceeded again. Now, my lord, they issued a notice. On the same day, another inspection was carried out. And, my lord, finally, when the order was passed, and that was, my lord, sent to us with the registered post, they provided me the copy of the report. So I did not get an opportunity at all, my lord.
The inspection was carried out?
My lord, that lordship will find at 122.
26.
Page 122.
Yes.
My lord has got it.
Yes.
Kindly see at the bottom, my lord.
On
26 May 2000, 26th, the notice was issued
26th. So when the 26th May between
on the same day. First. Now, my lord, kindly comes to the order impugned. Yes, page 123.
123.
Yes.
Yes.
Lordship will find the notice whereby they intimated my client about the date of hearing. At the top, Lordship will find this we had received on 23rd of June.
You remain informed before the hearing, 24th June at 11:15 p.m.
A day prior to the hearing, I received at the top.
23rd. 23rd on.
Yes. However, I attended. Now, kindly see the finding, my lord. Lordship will be shocked to see this.
So you are attended the inspection?
Yes, I did, my lord.
Inspection?
No. Yeah, inspection I attended, but report I did not get.
Did not get?
No. And this is the second inspection. Lordship's order says you hand over the report.
Yes.
They did not consider. Very good. Second time inspection carried out, but they gave us the report when they circulated the order. So I didn't get an opportunity. And secondly, my lord, findings are contradictory. How, my lord, I will show you, Lordship. Page 125. One Mr. Unup Kumar Bhattacharya, same complaint. Lordship will find that complaint was also not given prior to the date of hearing. It came to us when they served the order. Now, my lord, kindly, my lord, comes to the introduction portion. I will not trouble your lordship to go through the entire order. Introduction. This is the engineering and fabrication unit of This is the engineering and fabrication unit of two-storied building and located opposite road about 15 feet wide. Side of the complainant's flat. The area of the unit is mixed area. Kindly take note of it. Mixed area, that is residential and commercial area. The unit is engaged in the manufacturing, then such and such, the nature of the business that is being quoted, my lord. I am not troubling your lordship. Then, my lord, observation. Lordship has noted the mixed area, then the observation. Kindly see the violation and the noise level. The third one and the second one. Noise level measured inside the unit work zone area when all grinding and drilling machines were running and also all doors and windows of the unit were closed. Now, kindly see, they have indicated 87.07. Next one, noise level measured from the complainant's flat when all the grinding and drilling machines were running and also all the doors and windows of the unit were closed, 75.02. Lordship has got it. Now, my lord, kindly comes to page 51. The first order, which was set aside by your lordship. On what basis they have came to this finding, I do not know. Kindly comes to page 51.
Page
50. The first order, which was set aside by your lordship. By the order dated 9th April.
Yes.
Page 50. First paragraph, if lordship kindly sees, brother.
Yes.
My business comes under white category. There is no dispute. There is no dispute that clearance is required. I am not on that. Then, my lord, the second sentence, my lord. But it reveals that due to the activity of that unit, it generating noise inside the work zone of the factory and with all machinery in operation measured at 94.24. Then the noise level at the building of the complainant measured is 9.
Where from you're reading?
My lord, first
Yes,
paragraph,
the
which
noise-
lordship
yes,
has got it, my lord. The last sentence and the sentence
Noise
before
level
that.
Building complainant 90.44.
Yes, and then the noise level at the building of the complainant measured as 90.44.
Yes.
Now, my lord, kindly comes to page 126. Third one, noise level measured from the complainant's flat when all the grinding machineries,
So
same
it-
position,
come
75.
down.
What is the
It has
basis? I
come
do
down.
not know. Maybe it is favoring me.
It
Then,
has come down. Yes.
kindly, my lord, comes to the remarks and recommendation then. The unit does not install any acoustic insulation panels and noise barriers, use of rubber pads for reduction of noise level, which is a violation of the previous direction of the record of the proceeding dated 6 March 2026. How could they rely on this when that was set aside by your lordship? 6 March is a day prior to your lordship's order, and lordship considered this and set it aside. They have relied on this again. Then, noise, lordship has got it.
Yes.
Then, noise level measured during inspection, and it was noticed that the noise level measured from the complainant's flat when all the grinding and drilling machines were running and also all the doors and windows that the unit were closed is 75.02. It's a contradictory, and that was 90. Whereas the ambient noise level is 60.82. On what basis? I don't know, because report was never given. Hence, the noise level has exceeded 10 dBA above the ambient noise level, which is violation of the circular issued from WPCB dated 17th October 2023. Now, kindly comes to the circular ones. 135 is the circular. Lordship has seen it's a mixed area mentioned, measured and residential and commercial.
135.
135 is the circular which they have relied upon heavily.
Yes.
Lordship has got it, my lord. The heading,
Yes.
circular, then circular of standard operating procedure for organizing domestic or community festival celebration pujas in the state of West Bengal for ensuing environmental norms. Now, my lord, it has been indicated. Kindly comes to the category of area. That is very important. Industrial area, commercial area, residential area, silent zone. Where is the mixed area, my lord? No mention. You rely on a circular. You say you have...
Mixed area.
It's not there. I didn't find it.
Yes.
Now, my lord, one more. Page 127.
Yes.
First, second, third, fourth, fifth paragraph. From the inspection report dated, I had shown your lordship the inspection was carried out on the same day. We understand Mrs. Manna Engineering Works will not be required to obtain consent. Very good. I am not required to, it's a white category. Fall under white category. It further reveals that sound level as measured during inspection, indicating a bit high. What does it mean, bit high? That of the statutory limit. You did not point out. And most importantly, you relied upon a report. That report you did not serve me. Again, there is a violation. First, finding contradictory. You don't provide me a copy of the report, the second report, so to say. And then kindly see the last line. What is the measure that has been suggested? The officer in charge of the police station is required to oversee the compliance and in violation to take steps, to take appropriate steps in accordance with law. And they came to my office and they closed down. Yes. This order, my lord, cannot sustain. And one more thing, my lord, kindly, my lord, sees, my lord, first, second paragraph, the complaint. Lordship has said in the order, the complaint has to be given. Complainant's name is there. That was also not given. So this order, my lord, cannot stand.
Yes.
With greatest of respect.
My lord, in terms of your lordship's last order, my lord, I bow down before your lordship, my lord. The copies of the complaint and the inspection report were to be served upon the petitioner, which was not done, my lord, admittedly. I have been verbally instructed that the complaint and the copies were disclosed at the time of hearing, but I'm not making that submission, my lord. Insofar as, my lord, going into the merits of the sound level and everything, my lord, if your lordship kindly
How your authority can rely upon the earlier order which has
cannot, my lord, cannot. This cannot be sustained, my lord. I cannot submit against my client, but it has to. This order has to go.
So what do you suggest?
Then
They have reduced some machine as per order 126. Some machines are new. That's why they are level as reduced, but not up to the level. That's why there's the recommendation for closing of that. That's also recommendation, my lord, to avoid nuisance, which may be page 126, my lord. If you call for noise, adequate noise.
Now come to the circular. Come to the circular. Page 135. As per your order, this is a mixed area. Where is the mixed area limit?
Mixed area is not here.
So how you can ascertain? Your industrial area okay, commercial area okay, residential silent zone. Correct, but here is a mixed area. How can you ascertain mixed area?
Commercial and residential.
Mid portion. So if mid portion also, then it will be reduced.
Let them revisit, but it can't stand.
Then it will be reduced. If it's 75 minus 75, 65
Absolutely.
within what? It will be 60.
Absolutely.
75, 60, 75, 65. What is the middle? 60? 75 and 55. What is the middle? 65?
68. 67.5.
So, okay, they're admitting that they are not given. Let I am setting aside, remanding it, give the complaint, give the report, inspection be carried out in presence of before it, 2 days before the notice to be given, and all this sound is to be
Complaint and the report.
taken. The petitioner has filed the present writ application challenging the impugned order dated
My lord,
24th of June 2026.
125, that's dated, my lord,
24th of June
24th June.
2026 by the who has filed
By the
Request
assistant
for-
environmental engineer, respondent number 6.
by the respondent number 6, directing the officer in charge Shipur police station to oversee the compliance of this order. In case any violation of this order, he is liberty to take necessary action in accordance with law. Learned counsel for the petitioner submit that in compliance of the said order, the officer in charge Shipur police station came to the premises of the factory
Yes, my lord.
workplace of the petitioner and closed the work of the petitioner. Counsel for the petitioner submitted this is the second round of litigation. Earlier, the petitioner has challenged the order passed by the respondent number passed by the assistant environmental engineer dated 6th of March 2026, but by an order dated where is the order of this court?
My lord, 9th April at 115. Page 115, first
order
order passed
dated
by your lordship.
9th of April 2026, this court has set aside the impugned order and directed the authorities to decide the complaint filed by the complainant by giving an opportunity of hearing to the petitioner after supplying the copy of the complaint to the petitioner and the report, if any, relied by the authorities. It is a specific case. The petitioner submit that the inspection notice was issued on 26th of May 2026, and on the same day the inspection was carried out. Subsequently, the hearing was fixed on 24th of June 2026, and the notice was only issued on 23rd of June at 3:50 p.m. Though the petitioner has appeared before the court, it is a specific allegation of the petitioner in the present writ application that in spite of the order passed by this court, in spite of the direction passed by this court, the respondent authorities without supplying the copy of the plaint and the copy of the report on the basis of which the impugned order is passed is not served to the petitioner. This petition also brought to the notice of this court that while passing the impugned order, in the impugned order, the respondent authorities also relied upon the proceedings of dated 6th of March 2026, which this court has already been set aside and passed. It is also the contention of the petitioner that as per the circular dated 17th of October 2023, there are only 4 categories of areas, that is industrial area, commercial area, residential area, and silent zone. But in the present case, the authorities have admitted that the factory of the petitioner is situated in the mixed zone. Mixed zone?
Yes, mixed area.
Mixed
Page
area.
127, first
Mixed
panel.
area, that is residential cum commercial.
Gotcha.
But in the circular dated 17th of October 2023, there is no mentioning of the mixed area. Mixed zone. Mixed zone. Full. But the authorities have held that the petitioner held that
page 126, my lord.
Held that the noise level inside the unit is 87.07 dB within bracket capital A, and noise level measuring from the complainant's flat is 75.02 with dB within bracket capital A. Now, counsel for the petitioner submit that if there is no mixed zone, is mentioned in the circular, how the authorities have decided with regard to the said noise level.
Area, mixed area.
Mixed area.
Sorry.
decided this noise level. Full stop. Land Council for the state. Land Council for the state submit that after the order passed by this court, the authorities have given an opportunity of hearing to the petitioner, the petitioner has appeared before the authority, and as the petitioner cannot say the opportunity has not been given. He further submitted that on the inspection of the premises in question, it was found that the petitioner has violated the noise level as per the circular, and as such the impugn order is passed. Learned Council appearing for the respondent number 5.
Pollution Control Board.
Pollution Control Board submit that though the inspection was carried out and the hearing notice was given to the petitioner, but admittedly copy of the complaint and the report was served to the petitioner only at the time of passing the order. Considering the above, this court find that the respondent authorities have passed the impugn order without complying the direction passed by this court. Accordingly, the court, by supplying the copy of the complaint as well as the report to the petitioner before the hearing of the matter before the authority. Accordingly, the impugn order is set aside and quashed, the respondent authority directed to supply the copy of the complaint and the report relied by the petitioner, and the petitioner's liberty to file their objection to the complaint and the report within a period of 2 weeks after receipt of the same to the concerned authority, and on receipt of the objection, if any, filed by the petitioner, the respondent authority shall dispose of the same in accordance with law by passing and reason in a speaking order within 2 weeks thereafter.
Well, Lordship last time gave 12 weeks, but Lordship has seen how they have acted. So probably they need some more time, my lord.
That is.
I do not know whether they will be able to do it in 2 weeks.
2 weeks?
4 weeks, my lord, would help.
4 weeks, and last one.
And my lord, Lordship has said, my lord, respondent number, my lord, is
5.
6 and 8, because there's a mention of the respondent.
Okay, I will see to that.
Both the authorities.
6 and 8, huh?
6
not 5.
Taito.
Next.
I'm grateful. My lord.
Disposed of.
My lord, 14 my lord, we have for the.
Yes.
My lord. On last occasion,
To take instructions, my
on last occasion, my lord, we have raised the point of territorial jurisdiction, and my esteemed friend also submitted some documents.
Yes.
And my lord, we have got the instruction regarding that document also. So my lord, kindly allow me to first, my lord, to complete this argument regarding the territorial jurisdiction. My lord, I shall only submit 3 decisions only, and thereafter, my lord, I shall reply to the.
Lordship.
14.
Yes.
No. My lord, he was thinking the matter was item number 15, my lord.
Okay. Yes.
So my lord, last occasion, regarding territorial jurisdiction, my argument was that the petitioner office at Calcutta, manufacturing unit at my lord, the Jharkhand, and one RDSO office is Kolkata, and my lord,
Office of petitioner is
petitioner.
office of the respondent. What
Petitioner office is my lord, Kolkata. My lord.
what is the first submission? Office of the respondent is
Office of the RDSO, my lord, the headquarters that is at Lucknow.
at
At Lucknow. Although in the petition that is stated at my lord, the Kolkata, my lord, that is not correct. My lord, at the cost title that is stated, my lord, at 17 Netaji Subhas Road. My lord, this is not correct. Their office is Lucknow.
it is not. There is no office in Rajesh Subhas Road.
No, but regarding this Railway Board office, my lord, Ministry of Railway.
No.
And one, respondent number 1.
The address mentioned in the cost title with regard to respondent number 1, the address is not correct.
Not correct. That is at New Delhi. And my lord, that address is correct. 3 address is correct. 4 address is also correct. But my lord, the respondent number 4 has no connection with the wagon manufacturing. My lord, regarding that, I have submitted an documents on last occasion, my lord. That is the executive director, my lord. That letter was
No
sent.
connection with manufacturing factory. No connection.
Manufacturing of wagon, my lord.
Yes.
Actually, my lord, what happened? The respondent number 5 directly placed order of manufacturing of wagon upon the petitioner, my lord. And my lord, so my humble and respectful submission, whatever may be the jurisdiction, that is either, my lord, not within the territorial jurisdiction of your lordship. My lord, one letter was shown annexed, my lord, that is at page 70, my lord, of the
These
writ
are the
petition.
two.
My lord, I
With
have
regard to address, these are the two. Office one is not correct and 4 is not the
yes,
authority.
gratefully.
Yes, next.
Yes, next, my lord, kindly see judgment, my lord.
Yes.
My lord, that is, my lord, reported in 2007-11 SCC, page 335.
Yes. Page number, paragraph.
11 SCC, page 335, alchemist. And my lord, the paragraph 35 and onwards, my lord. Kindly come, your lordship. Negativing the contention of upholding the order passed by the High Court. Your lordship got paragraph 35. This court ruled that passing of a legislation by itself does not confer any such right to file a writ petition in any court unless a cause of action arises. Therefore, the court stated, paragraph 2, the distinction between the legislation and executive action should be borne in the mind while determining the said question. Referring to the ONGC, it was held that all necessary facts must form an integral part of the cause of action. The fact which is neither material nor essential nor integral part of the cause of action would not constitute a part of cause of action within the meaning of clause 2 of article 226 of the Constitution. 36. The National Textile Corporation Limited versus Hariworks Sutherland, referring the earlier cases, this court stated that the mere facts that the writ petition carries on business at Calcutta or at the reply to the correspondence made by it was received at Calcutta is not an integral part of the cause of action, and therefore the Calcutta High Court has no jurisdiction to entertain the writ petition, and in the view of the contrary taken by the division bench cannot be sustained. 37. From the aforesaid discussion and keeping in the view the ratio laid down in the catena of decisions by this court, it is clear that for the purpose of deciding whether facts averted by the appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such facts constitute a material, essential, or integral part of the cause of action. It is no doubt true that even if a small fraction of cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain the suit petition. Nevertheless, it must be a part of cause of action, nothing less than that. In the present case, the facts which have been pleaded by the appellant company in our judgment cannot be said to be essential, integral, or material facts so as to constitute the part of cause of action within the meaning of Article 226(2) of the Constitution. The High Court, in your opinion, therefore, was not wrong in dismissing the petition. So, my lord, some correspondence in between the Delhi office or the Lucknow office to the Calcutta office of the petitioner, that does not create any cause of action. And my lord, the second thing, that is also, my lord, the reported 2004 AIR SCW page 2067. And my lord, other various judgment, it was also recorded. My lord, the relevant paragraph 11 and 12, my lord.
Yes.
2004 AIR SCW 206. National Textile Corporation. Paragraph 11. The question of jurisdiction was considered in considerable detail in Oil and Natural Gas Commission versus Utpal Kumar Basu and others, and it was held that merely because the writ petitioner submitted the tender and made representation from Calcutta in response to an advertisement inviting tenders which were to be considered at New Delhi, and the work was to be preferred in Hazira, Gujarat, and also received replies to the fax message at Calcutta, could not constitute facts forming an integral part of the cause of action. It was further held that the High Court could not assume jurisdiction on the ground that the writ petition resides in or carries on business from a registered office in the state of West Bengal. 12. In the present case, the textile mills are situated in Bombay and the supply of cloth was to be made by then X factory at Bombay. According to the writ petitioners, the money was paid to the mills at Bombay. The learned single judge, after a detailed discussion of the matter, held that the Calcutta High Court has no jurisdiction to entertain the writ petition. The division bench had reversed this finding on the ground that concluded contract had come into existence which could be cancelled only after giving an opportunity of hearing, and consequently the question of revocation of the contract at its Calcutta address would constitute a cause of action. In our opinion, the view taken by the division bench is wholly erroneous in law. It was nowhere pleaded in the writ petition that the appellants herein had initiated any action under section 11 of the Act by issuing a notice to the writ petition for cancellation of the contract. In fact, it is stated in para 18 of the petition that the central government did not follow the procedure prescribed in section 11 of the cancellation of contract. Regarding the jurisdiction of the Calcutta High Court, the relevant statement made was in para.
Yes.
So, my lord, these two judgments, my lord. And my lord, last occasion, your lordship, my learned friend, senior friend was produced one documents, and in reply to that, your lordship was direct me to take the instruction, my lord.
Yes.
I have that, I have taken. Last time. My lord, that is the letter dated 16/4/2026.
Yes.
That letter was given to the executive director by the petitioner company. My lord, regarding my lord, I am just last two paragraphs. In this connection, it is hereby clarified that the correct prototype wagon for inspection and conformity audit in BCC wagon.
Where from you're reading?
My lord,
Where from you're reading?
the last, my lord, the second paragraph, my lord, from top.
Second paragraph, page second.
No, first page. That is letter dated 16/4/2026.
Correct.
First page.
At page 79 of the writ petition.
Yes, yes, that is also at page 79. My lord, I have shown last occasion also, my lord. My lord, this is, my lord, we therefore requested you to kindly ignore the earlier mentioned BVCM wagon and consider our request for nomination of a team of inspection of a prototype BCC wagon along with confirmatory audit for G105 complaints. My lord, just one thing, my lord, earlier occasion, one 3-man team was inspected, my lord, their factory premises at Jharkhand. My lord, that team has come from Lucknow office. Not Calcutta has no connection. Thereafter, my lord, kindly come to the next page. My lord, that letter was produced, my lord. And my lord, kindly come to the last letter, last page. My lord, that is the instruction of the second page, my lord.
Yes.
My lord, that is the letter dated 17/7/2026. That letter was issued to the Ultratech Cement Limited. My lord, who was, my lord, that is the respondent number 5, who produced, my lord, who submitted the, my lord, the for purchase order to the petitioner, my lord. My lord, kindly see. Subject, procurement of BCFCM wagon, compliance with the LSFTO agreement. That letter was issued by the Railway Board from New Delhi. Reference, agreement executed between the Indian Railway and Messrs. Ultratech Cement Limited under the Liberalized Special Freight Train Operator LSFTO scheme. to RDSO's letter number such and such, wagon limited such and such, dated 21/4/2026. Reference is invited to the agreement executed between the Indian Railways and Messrs. Ultratech Cement Limited under the Liberalized Special Freight Train Operator Scheme. Article 5.4 of the aforesaid agreement stipulates that the operator shall procure, operate wagon of RDSO approved IRS design manufacture by an Indian wagon supplier holding a valid G105 certified issued by the RDSO or by an overseas supplier considered suitable by RDSO, subject to compliance with the prescribed technical specification and designs. It has come to the notice of the Railway Board that a purchase order of manufacture of BCFC M1 wagon has reportedly been placed on a manufacturer not holding a valid G105 certificate issued by RDSO. Such procurement is not in conformity with the provision of Article 5.4 of the LSFTO agreement. Messrs. Ultratech Cement Limited is therefore advised to take immediate corrective action to ensure compliance with the provision of the agreement. In case a purchase order has been placed on a manufacturer not holding a valid G105 certificate, the same shall be cancelled forthwith, and the production over order shall be placed only on a manufacturer holding a valid G105 certificate issued by RDSO. An action taken report clearly indicating the corrective action taken in compliance with the above contractual provision shall be furnished to the Railway Board within 15 days of the issue of this letter, following which appropriate action be deemed fit under the provision of the LSFQ agreement and other applicable rules shall be considered. And my lord, that letter was issued by the Director Mechanical Engineer, Trade, my lord. So my lord, on the very first day I have submitted that the placement of order by the Ultratech, that is the respondent number 5, upon the petitioner, it is not correct at all. And because, my lord,
it is not?
My lord, it is not legally, my lord, correct.
What?
My lord, as because, my lord,
which is not correct?
Not because, my lord, that was wrongly placed.
Which is not correct?
The placement of order by the of wagon, manufacturer of wagon, by the respondent number 5, Ultratech, upon the petition. Because, my lord, that the petitioner's company, they are, my lord, the not certified company under the G105 for manufacturing of the wagon.
Correct.
And, my lord, accordingly, the Railway Board, my lord, they issued that letter.
Correct.
And, my lord, one thing.
Railway Board issued the letter?
That's
when the Railway Board issued the letter?
That's 17/7/2026, that letter just now.
After 16 July, for clarifying that.
Yes.
That's why this court is not giving the time to the respondents to fill up all the lacuna.
And my lord, regarding that,
made up of your own defense subsequently.
No, my lord. Why?
See, on that day, 16 July letter, how can you see this? Read the 16 July letter.
My lord, regarding the 16 July letter, my lord, that letter kindly I am on that day I have also raised objection. That letter was internal document.
Maybe, but your Abhay Kumar has issued.
Yes. I am not denying the existence.
He changed the stand.
Yes, my lord.
Yes.
I am not denying the existence of the letter. My lord, my submission was.
The court is asking one thing. Your officer can change the stand before the court and before the internal correspondence. That is the question. Can the officers of the railway authority can change the stand before the court, which was the stand internal between the authorities? Explain me. Otherwise, I will issue the rule to you, to this Abhay Kumar, to misleading the court.
Yes, ma'am. My lord, kindly consider that.
Give answer to me first.
Answering to that. My lord, kindly consider. My lord, admittedly, that the petitioner manufacturing unit at Jharkhand, my lord, they were not certified under the G105 by the RDSO. But even then, my lord, the order was placed by the Ultratech upon the petitioner. And the petitioner without, my lord, it was, my lord, knowledge of the petitioner company that they are not the certified company by the RDSO under G105.
Who are not the certified company?
Petitioner's company.
Hmm.
That is, my lord, JK, my lord, that company.
What is the tender? What
No
is the
tender, no tender was.
What is the work order?
My lord, what happened?
What is the work order? Tell me what is the work
Work order, that has no directly connection with the railway. My lord,
What is the work order? Tell
work
me.
work order was placed by the not work, that was placed by the respondent number, issued by the respondent number 5 upon the petitioner.
Correct.
For manufacturing of the wagon.
Correct.
So, my lord, the wagon.
So Ultratrack can.
My lord, that has no connection with the railway. That is directly without any approval from the railway. That was, my lord, suo motu placed by the respondent number 5 upon the petitioner company.
Okay.
My lord, when, my lord, both the respondent number 5 as well as the petitioner, it was known to them that they are not the certified company under the G105. Even then, the Ultratrack placed the order and the petitioner company accepted.
Correct.
And my lord, kindly consider that when the order was placed, that for manufacturing of tender, without any approval, nothing. That was placed on 9 September 2025.
Correct.
My lord, kindly consider that date. Order was placed on 9 September 2025. But the
9 September, 17 September. 17 September.
17.
Page 50. Page 50.
Which?
50 of the writ petition. P4.
17.
Yes, my lord. Then, my lord, kindly consider on that day whether the petitioner company has any certificate for manufacturing of wagon.
Then what about the page 59 P5?
59.
Yes, page 59. If it is only between the Ultratrack and the petitioner, so why the RDSO are coming
Yes.
picture page 59?
My lord, kindly consider the last paragraph.
Yes, that's why you can read.
Further, while later under reference above from has requested for adding such and such flat wagon, BVCM brake van, covered wagon, special wagon under category 1, 2, and 3 in the existing initial audit certificate on the basis of reports submitted by the nominated audit team, confirming additional requirement of M and P, etc., according to the G105 standard for manufacture of subject wagon at your work.
Correct.
Magma versus Messrs JK Wagon Limited, Dhanbad approved is hereby granted in additional of BRN 22.9 flat wagon category 1,
Yes.
BVCM brake van category 3 and BCFCM1 special wagon under category 2 in your existing initial certificate valid up to 22nd January 2026.
Correct.
So that was valid up to 22nd January 2026.
Correct.
My lord, kindly consider that. My lord,
I place this notice to your information. You have stated that railway has nothing to do with the work order issued by the Ultratrack to the petitioner.
Yes.
Correct. So why you RDS have come in picture? Why the RDS could have been said that on December 2025? See, there is a dispute between you both of them. You solved it. I am not, but here RDS has clarified here.
Yes.
Then,
my lord, kindly consider.
And now the railway authority can say.
Who are the RDSO, my lord? They are the authorized by the railway board and the ministry to approve, my lord, the design and, my lord, entire, my lord, the safety, security and other aspect of the wagons. And, my lord, for this reason, my lord, the issuance of certification, provision of issuance of certificate is there. My lord, my humble and respectful submission, apart from, my lord, the territorial jurisdiction point, that at that time of, my lord, the procurement of order or placement of order in between the petitioner and the respondent number 5, that certificate was not there. And not only that, my lord, that certificate for my lord, that is the field verification, that is the unit verification certificate, that unit is manufactured for like that. My lord, thereafter, my lord, they have
then come to page 77.
yes, my lord, 1 minute.
Come to the page 77.
77.
77.
Yes, my lord.
Then this has been
77,
written
that
by the
letter
railway board.
dated 8/4/2026.
It is written by railway board.
Please refer to a letter under reference number 1 in the light of PO permission to procure and depositing the requisite charges communicated via letter under reference number such and such above. Respectively, now it is communicated that the wagon number of 62 number of BCFCM1 with one number BVCM wagon procured by the Mrs. Ultratech Cement Limited and manufactured. My lord, how they are manufactured, my lord, manufacture was not done, my lord. Manufactured by, yes, my lord, manufactured by Messrs. JK Wagon Limited under LSFTO scheme has been uploaded in the Indian Railway Wagon Management System IRWMS.
Correct.
And my lord, it is advised to get in touch with the RDSO for further inquiries in this regard. My lord, that letter was issued by the Railway Board upon the petitioner company. So, my lord, their last line kindly consider
So
it is
not
advised.
see, instead of going here and there, why the solution should not come? Because whatever the order was issued, it is within the knowledge of the RDS, the railway authority, RDS. So you are telling that the RDS, so they are telling that to get in touch with them. Let the matter
My lord,
solve.
why get in touch with the RDSO? Because they are the approving authority in both the manufacturing unit as well as the prototype wagon.
Correct.
So, my lord, admittedly, prior to placement or procurement of the order, that certificate was not there. That was subsequently obtained, and it is also not.
That's why their material has not been accepted unless and until the material, and that is not the total material. They have been only the prototype. It has been, but it has to be certified. Yes, the prototype which they have produced, that is covered under the G105 scheme, so that they can continue. Then they can continue with the
When they will
process.
be covered, as soon as they will get the certificate, an entire certificate provision, my lord, including the prototype.
Correct.
Prototype wagon, my lord, that prototype wagon certification was till date, my lord, not there. For this reason, my lord, the Railway Board issued the latest letter dated on 17th, my lord. 17th of July, my lord. I have also handed over the 3 copies of the letter. And one is, my lord, already
20 July order is some dangerous thing. You have changed your total stand, then the 16 July letter, and prior to the letter, you have taken the U-turn from the 17 July after taking the view of this court.
Your lordship, my lord, I am also surprised when, my lord.
That is very dangerous. That's why the video conference, this online procedure.
So, my lord, I have asked the director at DSO.
Why the Abhay Kumar has changed his view from 16 to 17?
My lord, this is there, my lord. My lord, why
Same
they have
officer?
changed? They have changed, my lord, because, my lord, probably, my lord, that certificate procedure is not completed. And, my lord, what I am placing, my on my
16 July, what the 16 July says?
16 July.
Yes,
He has to get the certificate from under the scheme.
Yes, 16 July later, my lord, kindly see that.
Nothing else. See, 16 July, nothing else. And you are totally changed in the 17.
Yes, ma'am. That is the executive director to the, my lord, issued to the, upon the executive director to the vice
RDSO.
director, Railway Board.
RDSO.
RDSO.
He has given the RDSO. Why you not stick on this letter?
In the, my lord, last line, in the view of the above, RDSO is advised to take further necessary action strictly in accordance with the extant provision of guideline G100.
Correct. But this is not the RDSO 7. RDSO is not refusing. No, I cannot do that because they have not taken the prior approval of the RDSO. This is not.
And my lord, thereafter, the latest instruction has come upon the RDSO. That is the 17 July letter.
This is not the RDS.
This is your railway board.
Yes.
This is the railway board.
That's I'm again and again telling why Mr. Abhay Kumar has changed the stand within 24 hours.
And my lord, regarding 16 July letter, my lord, kindly see, they have also raised complaint, my lord, before the authority.
Who?
Regarding the 16 July letter.
Who raised the complaint?
That the RDSO, to the director RDSO, to the executive director RDSO, Wagan.
To save his skin, to save this skin, he has a pass.
Because my lord, this is the internal, I have submitted my lord on that day.
It requires the investigation, sir, now. Now it requires the investigation. Now it requires the investigation. This officer has to.
Yes, yes, my lord. Definitely. I shall grateful, your lordship.
Who is appearing for the RDSO? You are appearing for the RDSO also.
Yes.
Ultratech?
My lord, I have received the instruction, just I am placing before your lordship.
No, that's, I am not telling you. I am not telling you. You're all.
My lord, my RDSO officer is also surprised. My lord, how this is my lord, they are the internal communication, my lord, that they are very serious thing. My lord, not only this Wagan, various the safety aspect is also involved with the, so my lord, if this way, if they have gone, my lord, that was got to the, my lord, they have received the petitioner. My lord, this is very dangerous.
Yes. Anything further? Anything further on merit? That's all.
My lord, this letter has been handed up to your lordships. My lord, I will, my lord, show that this is a deliberate attempt to, my lord, circumvent these proceedings. Kindly see, my lord, the date of the letter at the top is 17 July 2026. Now, my lord, kindly see who it is addressed to. My lord, Ultratech Cement. My lord, who is, my lord, the respondent number 5.
Yes.
And my lord, hearing concluded on Friday before your lordship at 4 p.m. Kindly see when it is sent, the digital signature of Abhay Kumar, my lord, 5:34. After, my lord, the hearing, this has gone. Now, my lord, one by one. My lord, when the matter was first opened, my lord, I had shown your lordship, my lord, their stand, that, my lord, the, my lord, G105 guidelines did not apply to LSFTO scheme. And that sought a clarification from the railway board. Now, my lord, here what is being done, my lord, kindly have a look at, my lord, this letter. My lord, I just want to place, my lord, references invited to the agreement executed between Indian Railways and Ultratech Cement under liberalized special freight train operator scheme. Now kindly see, my lord, their first case was G105 doesn't apply. Article 5.4 of the aforesaid agreement stipulates that the operator shall procure, operate wagons of RDSO approved IRS designs manufactured by an Indian wagon supplier holding a valid G105 certificate issued by RDSO or by an overseas supplier considered so and so. Then it has come to the notice of the railway board that a purchase order for manufacture of BCFC M1 wagons has reportedly been placed on a manufacturer not holding a valid G105 certificate issued by RDSO. Then, my lord, kindly see the penultimate para. Ultratech is therefore advised to take immediate corrective action to ensure compliance. In case a purchase order has been placed on a manufacturer not holding a valid G105 certificate, the same shall be cancelled and production shall only be placed. Now, my lord, kindly see, my lord, how. So first, my lord, I am showing, my lord, like shifting sands. My lord, this is a shifting case. Now, my lord, 105 they said does not apply. Now, my lord, they paraphrase 5.4. I want to show your lordship what 5.4 says. My lord, kindly have a look at. My lord, 5.4. না না agreement টা যেটা রিলাই করেছেন আপনারা চিঠিতে না না agreement এ যেটা রিলাই করেছেন 17 জুলাই আছে না নেই বলুন লিখে দাও। নেই। এইটা নিয়ে আমারটা এখানে page 23 তে। My lord, kindly see 5.4. The SFTO shall procure operate wagons of RTSO approved IRS designs manufactured by an Indian wagon supplier holding valid G105 certificate issued by RTSO or by an overseas supplier considered suitable by RTSO, provided that all wagons procured by SFTO must comply with technical specifications and design prescribed by RDSO. In case a SFTO procures new wagons using the design and drawing of RDSO, RDSO design loan charges shall be payable by the operator to RDSO at rates as applicable at the time of manufacture of such wagons. Now kindly look at the purchase order. My lord, procurement will only happen after my lord RDSO approves. Kindly, my lord, have a look at, my lord, the purchase order, which is at page 50. Well, there's a deliberate pressure on now Ultratech, you please cancel. You cancel it within 15 days. Now kindly have a look, my lord. Page 50. My lord, this is 17 September 2025. Now, my lord, kindly take, my lord, the item, my lord, item 10, indent number, date, so-and-so, wagon model so-and-so, consisting of 59 wagons plus 3 wagons. Now kindly see. As per latest RDSO drawing. Lordship has that, my lord? Yes. Now, my lord, it doesn't stop there. My lord, kindly come to page 54. My lord, these are other terms and part of other terms and conditions. My lord, it's all part of clause 9. Kindly see, my lord. Third, my lord, hashtag, my lord, wagon and brake van, construction and supply as per RDSO approved latest design applicable to so-and-so wagon type brake and wagon type. Material rating and strength testing are as per RDSO. So it's all subject to RDSO. And we have been extending, my lord, this validity of the purchase order because our, my lord, request for, my lord, 105 certification and approval of prototype, my lord, is pending. My lord, there is no procurement happening, my lord, till such time as this happens. Correct. Now, my lord, kindly see, they, my lord, said nothing in this matter. Now, kindly come to, in spite of being aware of, my lord, the purchase order. Now, my lord, I will show your lordship first, my lord, page, my lord, 60. Kindly have a look at, my lord, page 60. My lord, this is 2nd December 2025. Addressed to, my lord, RDSO, my lord, in Lucknow. My lord, first paragraph. We are pleased to inform you that purchase order for manufacture and supply of 62 numbers along with so-and-so has been placed by Ultratech so-and-so. Vide purchase order number so-and-so. Copy of purchase order is enclosed. Not only that, last paragraph. In view of the above, we kindly request you to provide us the estimate of design and loan charges, drawing approval charges, inspection charges, and other RDSO consultancy charges applicable for manufacture of supply of so-and-so wagons and so-and-so. Your guidance is, etc. So, my lord, we indicate purchase order, and as per 5.4, we say you please give us your design loading. Now, my lord, page 62. My lord, kindly, sorry, my lord, page 61.
61, charges.
61. My lord, this is, my lord, addressed, my lord, to, my lord, JK, kindly see where it, you're diverting me from the point. Kindly come to, my lord, page 61. My lord, this is addressed to, my lord, us at, kindly note where, Hay Street, Kolkata. Well, I'll deal with jurisdiction separately. This is what it comes. Now, my lord, in reference to above charges for so-and-so, so-and-so, my lord, it is all indicated, etc. Comes to this. This is the code. Now kindly come to 62. This is very important. My lord, there, my lord, letter. And my lord, kindly see, my lord, who it is, my lord, addressed to. My lord, Coilerhut Street, RDSO. From my lord, Deputy Director, Wagon, RDSO. Consultancy charges to manufacture and supply of 62 number so and so against Ultratech Cement purchase order so and so. And my lord, this my lord figure, my lord, is my lord given. Now, my lord, kindly come to page 77. I'm showing your lordships, they are aware of my Ultratech purchase order. Never once have they said 5.4 has been violated. They know, my lord, that procurement is done in line with 5. See, again, heading, my lord, subject. And kindly see where it is addressed. My lord, the railway board addresses this. Issue of wagon number 62 number so and so procured by Ultratech and manufactured by so and so forth. Now, my lord, kindly see reference, my lord, item 2, purchase order, that very same purchase order. Then, my lord, 4, RDSO's letter dated 22nd December, which I showed your lordship. And then, my lord, the body, please refer to your letter dated to procure and so and so, so and so. Now it is communicated for wagon number so and so procured by Ultratech Cement and manufactured has been uploaded. So wagon numbers have also been uploaded in accordance with purchase order.
Yes.
Now, my lord, kindly come to my lord page 70. My lord, 6th of March 26, I missed out this document. My lord, kindly see, my lord, page 70.
Yes.
My lord, here they give us permission to start, my lord, manufacture of BCFCM1. Now, my lord, who issues it? Kindly see the bottom.
RDSO.
RDSO Kolkata. RDSO Kolkata, my lord, issues it. And my lord, kindly see the reference. And item 1. Ultratech Cement purchase order number so and so. And my lord, what is the permission being given for? In line with 5.4, clause 4. Above permission is so and so to for start of manufacturing prototype wagon only. Series production should not be started till approval of prototype wagon and permission for series production from this office. Now, my lord, what is happening here, my lord, is first they come and say on instructions, I don't blame my learned friend at all, that well, look, to this G105 doesn't apply. My lord, why do they say it? Because they have written to Railway Board to that effect, RDSO, and Railway Board answer is, my lord, awaited. Now, my lord, what happens? Railway Board answer comes, my lord, on 16 July. My lord, which I handed up to your lordship, my lord, at 4 p.m.,
Yes.
1600 hours,
Yes.
where they say that, my lord, G105 guidelines, my lord, does not say it does not apply to any scheme or is only meant for particular schemes. So you are directed to take steps in accordance with G105. This is what they were to, my lord, get instructions on. Now they come, my lord, with this letter addressed to Ultratech saying, oh, we've known about your purchase order. We have given prototype manufacturing permission under this purchase order. We have charged design load consultancy charges, my lord, 32 lakhs odd, which has been paid and for this purchase order. And we are also doing a G105 under this purchase order. But now, Ultratech, you have violated 5.4, therefore you cancel it. Render this writ infructuous. My lord, this is, my lord, the, my lord, conduct. So, my lord, in my respectful submission, my lord, with the greatest of respect to my learned friend, my lord, it's sad that a statutory authority, my lord, whom, my lord, has to act fairly, my lord, is taking this stand. My lord, this is the most unfortunate thing.
Yes.
বলেছি তুমি ছেলে না ভাই আমি আগে দেখে নাও বলেছি কিনা then my lord the next thing is my lord jurisdiction. My lord, I'll just give you a lordship. Yes, now my lord, first point they've made is Railway Board does not have an office in my lord Kolkata. My lord, kindly have a look, my lord, at their website.
My lord, my submission was this regarding this railway board office at New Delhi.
No, question is whether they at all have an office. So railway has, so my lord, they do have an office, my lord, at 17 Nether, but my lord, more importantly, my lord, kindly take, my lord, exactly 6 documents, one by one in chronological order. I'll show your lordship. My lord, your lordship's already open, my lord, at page 70.
Yes.
My lord, this prototype action carried out under this permission is being sought to be rendered infructuous. Kindly see, my lord, who has issued it, RDSO Kolkata. So, my lord, this is the first document, which is part of, my lord, the cause of action. Then, my lord, kindly come to page 72.
Yes.
Kindly see, my lord, to whom it is addressed and where. My lord, this is, my lord, extension of time for confront. My lord, addressed to us in Kolkata. Now, my lord, last 2 paragraphs. Now, V-Day reference, JK has requested extension of timeline for conducting, that is up to 22nd July for manufacturing a prototype and confirmatory audit under G105. Request has been examined in the context of reasons and has been decided to extend the timeline for conduct of confirmatory audit under G105 standards. Accordingly, is advised to intimate details, etc. Then, my lord, kindly come to page 77.
Yes.
My lord, Railway Board writes, my lord, on 8th of April 2026 to, my lord, JK Wagon in, my lord, Kolkata, refers to that, I placed this already, purchase order, Ultratech, my lord, everything, and please refer, in light of purchase order, permission to procure and deposit requisite charges, V-Day so-and-so is communicated that wagon number so-and-so has been uploaded in the, so, my lord, it's part of the railway system on the basis of. And now, my lord, kindly see, my lord, copy, my lord, has been given
To all.
to all RDSO Kolkata as well.
Yes.
Serial number 4 and, my lord, copy to Ultratech serial number 10.
Yes.
Now, my lord, kindly come to page 82. My lord, 2nd July 2026, addressed to, my lord, JK Wagons in, my lord, Kolkata. My lord, this is, my lord, denial of, my lord, our confirmatory audit. The second para, the existing provisions of G105 standards issued in 2011 refer to procurement under Indian Railway orders or so-and-so schemes prevailing at the time. Since your request involves manufacturing of wagons under the current long-term SFO scheme, which is not covered under the existing so-and-so, and accordingly the matter has been referred to Railway Board in para 1 point, further action for. Now, my lord, Railway Board has now indicated letter of 16 July. They denied it. They denied, my lord, a confirmatory audit. Now, clause 5.4, Ultratech shows 105 and Railway 16 July has said conduct that audit. Then, my lord, the last, my lord, document, penultimate document, page 85. Kindly have a look. My lord, this is, my lord, 9th December 2025. It should have come, my lord, earlier. My lord, where they indicate what charges have to be paid. And, my lord, the letter demanding this sum, my lord, is addressed to, my lord, JK Wagons, my lord, in, my lord, Kolkata. And now, my lord, lastly, my lord, page 90. Kindly have a look at this. In fact, before 90, my lord.
88.
Yes, your lordship's right, my lord, 88. Koilaghat Street, Kolkata. Then, my lord, page 90. issue of wagon numbers, my lord,
Yes.
8th April 26, addressed to JK Wagons with reference to this purchase order. And now they're telling Ultratech, please cancel the purchase order. Now, my lord, the two cases which my learned friend has cited. My lord, kindly take, my lord, the decision, my lord, reported in, my lord, 2000, my lord, the case is actually, my lord, your lordship will find, my lord, Alchemist case, my lord, which related to, my lord, tender, my lord, which had been issued in, my lord, Alchemist for, my lord, offering, my lord, a partnership. Now, my lord, para 35 onwards, my lord, was read. Now, the most important aspect of the matter is, my lord, para 37, kindly, my lord, have a look at what the law is. My lord, national textile is referred to, my lord, in, my lord, which was also cited by my learned friend in para 36.
Yes.
So, my lord, both these cases, my lord, national textile is considered, and kindly see from this. From the aforesaid discussion and keeping in view the ratio laid down in a catena of decisions by this court, it is clear that for the purpose of deciding whether facts averred by appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such fact constitutes a material, essential, or integral part of the cause of action. It is no doubt, now this is also very important, it is no doubt true that even if a small fraction of the cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain the petition. Now, my lord, what are the causes of action here? My lord, first is, my lord, they have, my lord, extended the timeline for carrying out a confirmatory audit. I have to prove that. They have, my lord, given me permission, my lord, to go ahead, my lord, with, my lord, the manufacture of prototype. Third, my lord, they have denied me, my lord, the, my lord, final audit of G105 on specious reasons. All those, my lord, communications, the demand for payment, my lord, which was made to me to pay the loading charges, everything within. Now, I have to show that I have done this, my lord, to, my lord, be entitled to relief. If I show that I have not paid, then, my lord, they will naturally not conduct, my lord, an inspection and approval of prototype. My lord, if I can show, my lord, that they, unless I show their demand for G105, my lord, refusal, G105 is, my lord, not warranted, then, my lord, I will again. So I have to prove those. Those are all, my lord, before your lordship, and he does infinitesimal part of cause of action, my lord, is, my lord, good enough. What are they dealt with? It's dealt with here.
Yes.
My lord, and my lord, second, I'm not dealing with separately because it's dealt with, my lord, here itself. It's referred to, my lord, para 36, which is then dealt with.
Okay. Thank you. What is the prayer?
Yes, my lord, sorry, my lord, I should have shown that. My lord, kindly come to, my lord, the prayers. Page 27, my lord. Outline in name. My lord, kindly have a look at page 27, my lord.
Yes, got it. Page 27, read with 78.
Yes, my lord, prayer B, my lord.
Inspection.
Yes, my lord, they should do it for G105. Conduct inspection on the basis of the letters issued by the petitioner. Because, and now, my lord, they also have, my lord, the direction from the railway board to that effect, that's 16 July. And, my lord, the second is, my lord, complete the prototype inspection and confirmatory audit. B and C, my lord.
Yes.
Yes. And, my lord, anything which, my lord, is contrary to this, my lord, I have an omnibus prayer, my lord, for certiorari. Any, my lord, which seeks to deny, because all this is coming up now.
Just only one thing, my lord, regarding page 50. My lord, that
Page 50.
Page 50 of the writ petition.
50.
50. My lord, that order was placed on 17th of September 2025.
Correct.
My humble and respectful submission on that day, my lord, nothing, no inspection, no, my lord, that was not done. Prior to that order was placed, and one thing, my lord, whatever may be the audit charges or inspection charges, that was made to the RDSO Logno. And my lord, third thing, my lord, either your lordship, my lord, satisfied regarding the submission of my learned friend or my regarding the jurisdiction point. Whatever may be the your lordship satisfaction, kindly issue the appropriate direction regarding the 16th July letter, man. That is very serious thing, man.
Okay, I will observe that.
Yes.
No problem.
Great.
Thank you. Hearing concluded, CAB. Judgment loose paper আছে হ্যাঁ Yes, next.
Can I represent this CLPM report? My lord, I am praying for an accommodation. Mr. Devashish Saha is appearing for State Bank of India. But the matter has come up suddenly.
Learned counsel appearing for both the parties press for time. Let the matter appear on 7th August 2020. Next. 7th August. Next. Who is 16? Where is our affidavit service? Not served. (28) Let the matter appear on 28th under the same heading within 10 minutes. Yes, next.
17, my lord, I am for the petitioner.
Arm license.
Lordship.
Yes. Have you served the notice? Notice served?
Yes.
To whom?
Delivered.
Delivered. To all?
Lordship.
All?
All.
Yes, anybody is appearing for the state? No.
But actually, the issuing authority is DM.
Yes, what is the matter?
My lord, the petitioner before lordships is a government employee. Previously,
petitioners. How many petitioners?
One petitioner.
Petitioner, yes.
Petitioner. Previously, his father was a reputed businessman. My lord, he secured unsecured feeling to the made an application to the authority concerned. One armed license be given to him.
To the father of the petitioner.
Father of the petitioner made an application to the authority concerned.
For his personal security.
Lords.
Yes, next.
Nothing done. Thereafter, he brutally.
License was given to the father?
No. Thereafter, he brutally murdered.
Who?
On apprehension that his life is in danger by the miscreant. That's why he made an application to the authority concerned to issue the arms license to him. But that was not given, and thereafter he brutally murdered. After the said murder, the family feeling unsecure. The present petitioner herein made application to the authority concerned.
What he is doing? What the petitioner is doing?
He is a Panchayat Kormi.
Panchayat?
Panchayat Kormi.
He is working. Government servant.
Working.
Then
the DM, District Magistrate Nodia, issued a notice and took hearing. First hearing, nothing done. Thereafter, everything is according to the requirement to get a license. That was done. Police authority also gave no objection. Second, thereafter, when the first hearing, they did nothing. Thereafter, made one after another representation to the authority concerned. Second hearing was taken by the order of the district magistrate. The additional district magistrate hearing was taken, but no fruitful result. Thereafter, 2-3 times he made application. And he is also attacked once.
Why so enmity?
No remedy is.
Why so enmity
Malad, I
of
don't.
this family?
Family lordship is not at all. They are family of the.
Why time and again there is an attack? His father has been murdered. Now he has been attacked.
Malad, due to the Malad, he is a reputed businessman. He is a rich person. That's why.
So now he is not a businessman. Son is not a businessman.
His father.
His father died.
Lordship.
Then, so what do you want now?
Now, my lord, I made after 2 hearings taken by the authority concerned, nothing was done. Again, petitioner made application. So many licenses given.
Where is the application for grant of license?
My lord, if your lordship the.
Where is your application? When you made the application?
My lord, application made. First application made via petition. On the 12th June 2019, page 25. Thereafter, inquiry was made 29 July 19. The Superintendent of Police, Nodia, issued a letter to the officer in charge, submit the report. That is page 27. Have you not report?
Yes.
Thereafter, officer in charge Nakashipara sent inquiry report to the Superintendent of Police, page 28.
SP submitted report.
Thereafter, on the notice the petitioner for hearing.
Yes.
Regarding issuance of license, page 29.
Yes. Then
my lord, certificate was also given to the local MLA.
What certificate?
And
what certificate?
Life is my lord in danger.
Okay.
Prisoner has also my lord the certificate from the concerned training center to operate the gun, page 32.
Yes, record or not. Initially, the father of the petitioner has made an application for grant of license, arm license, but the same could not be granted. But in the pendency of the said application, the father of the petitioner was murdered, and accordingly, case has been initiated against the miscreant who were involved in the murder of the father of the petitioner. Subsequent to the death of the father of the petitioner, the petitioner has made an application before the concerned authority for grant of arm license in the name of the petitioner. On receipt of the application, reports have been called for, police authorities have submitted the report favorably in favor of the petitioner. On receipt of the report from the police authority, hearing notices have been given to the petitioner as petitioner has appeared before the authority at the time of hearing. Subsequently, again, the police authority have called for the report and the Superintendent of Police and the Nakshipara Police Station, the officer in Nakshipara Police Station has submitted the report to the Superintendent of Police, informing that the petitioner is not involved in any criminal activity and is not supporter of any political party. After receipt of the said report, again a notice was issued to the petitioner for hearing. But in spite of the hearing, till date, no final order has been passed, either rejecting the request of the petitioner for grant of license or allowing the petitioner for obtaining arm license. Thus, the petitioner has filed the present writ application. Had the learned counsel for the petitioner, this court find that the father of the petitioner was apprehending danger of his life and has applied for arm license. But before granting the arm license, the father of the petitioner was murdered. Subsequently, the petitioner has made an application for grant of arm license. The petitioner also getting threatened from the miscreants from the miscreants of and his life is in danger. The police authority has submitted the favorable report in favor of the petitioner, stating that the petitioner is not having any criminal antecedent and the petitioner is not also involved in any political party. Hearing was also conducted by the concerned authority, but in spite of the hearing, till date, no decision has been taken. Full stop. Consider the above, full stop. Considering the above, this court find that no purpose should be served by keeping the writ petition pending or calling for report from the authority. Accordingly, writ petition is disposed of, directing the respondent number 3, District Magistrate Nadia, Krishnanagar District, to consider the application of the petitioner for grant of arm license and to pass license, and if necessary, the petitioner may given an opportunity of personal hearing and to pass appropriate pass a reason and speaking order within a period of 6 weeks from the date of receipt of this order. WP is disposed of. Affidavit sir. Next. ऊपर affidavit of service kept with the record. In spite of service of notice, none appears on behalf of the state.
Lord, I appear for the petitioner. Lord, we have had a discussion yesterday. We are trying to resolve it, Lord, so that we don't have to trouble my Lord. And it keeps it not the weeks commencing from 10th of August, Lord. If we fail, Lord, we'll have to come to your Lordship, Lord.
I'm appealing for the board.
It is submitted by the land council for the petitioner that a talk of settlement is going between the parties and wait for adjournment. According cases adjourned, let the matter appear on 18th August.
My Lord.
18th August under the same heading.
Lord, it is appearing within first 10 matters, my Lord. Let it otherwise.
Same heading within 10 matters.
My Lord.
Next.
Lord, I constructed the joint entrance board building. Now that it is relating to the payment of money, if they, Lord, it is sorted out.
Consider.
Well, 19, I am for the petitioner.
Yes.
But I am for the petitioner. There was a direction passed by your lordship on the last occasion. We are directing the respondent numbers 2 and 3 to file a report regarding a possession of a document. That's in terms of my prayer. But that report has not come yet. In the meantime, we have also served a copy upon intimated the authorities by a further communication. But we have not received any response from the respondent number 2 and 3 till this date. In terms of your lordship, we have already added served the copy upon the respondent number 4.
Lordship, I beg to appear for the respondent number 3. There was a direction. I do not have the original and I'm saying that on affidavit. It was with the bank. I took an assignment from the erstwhile bank being the respondent number 2. The other set of documents which had come in original, this and 2 other dates, I did not get the original. I only have certified copies. So I cannot. So my affidavit is on record.
But may a copy be served upon us? We have not received the copy.
First for the petitioner, I'll give a copy.
Yes, you served copy.
No, I have not served. I'll give it to whoever's junior.
For the official liquidator model. Your junior is not here.
Yes, junior is here. Mr. Bose, Soheli Bose is there.
You're not appearing. Nobody's there.
But I think she texted me that matter is about to be called. But I think she was still
Okay,
at entire moment.
so you take exception or you what you will go through?
I mean, I'll consider the report and come back. She keeps a very short date where I'll come back with the with my instruction. If they say that the document is with the bank is also a party. She can direct the bank to produce it here.
And respondent number 4 is also not there.
Respondent number 3 has filed affidavit after serving the copy to and counsel for the petitioner.
Well, not after serving. We have not received it. They have not given me copy till now.
The respondent number 3 has filed the affidavit. Let the same be kept with the record. The respondent number 3 is direct to serve the copy to the land counsel for the petitioner. Full stop. The petitioner is at liberty to take exception to the report, if any, within a week thereafter. Leaves the matter on 5th August.
May it retain its position on the list.
The same idea. Yes, I'm deeply obliged.
Great.
But I am appearing for the petition.
Yes.
But here, my lord, the application made by the petitioner to the bank authority for granting loan.
For granting educational loan, your lordship.
In view of this scheme. Last occasion, your lordship seen this order passed by your lordship.
Yes, what is the instruction? Let me hear the response.
My lord, the decision has been taken, but it has not been communicated, my lord. This is what I have been instructed. My lord, we will communicate the decision.
What decision?
My lord, that she is not entitled to the loan because, my lord, the college that the petitioners want to get admission, my lord, that college is not within the purview of this nursing course. My lord, one is there. Secondly, my lord, the petition lacks the educational qualification. That is why, my lord, the loan could not be disbursed. My lord, I have been told this, but since I do not have, my lord, anything in writing, my lord, let it be communicated. It should be considered. Yes, my lord.
That is the rule. Must be considered within 15 days.
The grievance of the petitioner in the present application is that the petitioner has made a request to the bank for grant of education loan. But in spite of receipt of the request of the petitioner, the bank has not considered the request, neither rejected the request of the petitioner for grant of loan to the petitioner, grant of education loan to the petitioner. Police and counsel appearing for the bank submitted that if the direction is passed by this court, the bank will consider and pass appropriate order with regard whether the petitioner is entitled to get the education loan or not. In view of the submission made by the counsel for the respective parties, the writ petition is disposed of by directing the respondent number 7. By directing respondent number 7 to consider the representation submitted by the petitioner for grant of education loan within a period of 1 week.
Lordship.
Within a period of 1 week, and to communicate the same to the petitioner within a week thereafter.
Lordship.
The petitioner is disposed of.
Grateful, my lord.
Next.
It's a contempt application.
Lordship, I am appearing for Union of India, Lordship.
If your lordships will see my lord's order at page 365. It's volume 3. Third volume. Just take the third volume, my lord.
363.
365.
Yes.
The challenge was to a delisting letter. Kindly see the first paragraph. And also the allegation was that delisting has happened without a joint inspection. Now, your lordships heard the matter. Kindly come to paragraph 6. And paragraph 10 is the operative part of the order. That my lord's direction was that the defective samples should be taken on the basis of a joint inspection. Both parties should be present, and the defective samples would be taken. Now, this is, instead of complying with this,
Lord, what they're doing, they're going on, Lord, issuing, Lord,
Yes.
Toko's notice was set aside by your lordship or saying that you do it after taking joint inspection of the defective material.
Yes.
Now, Lord, instead of doing that, Lord, they preferred an appeal. The appeal was dismissed. Now it is restored. But Lord, they are not complying with this order. They are going on, Lord, following the same procedure. Your lordships will kindly see the show cause at page 370.
Of the same tender.
Same
Tender.
different lots. Lord, the same tender, different lots. Now, Lord, when we point this out, saying that you can't do this without complying with the order, Lord, their letter, kindly see page 394. This is their stand. (394), the letter starts. Your lordships may kindly come to page 396, paragraph 4. The contention raised by your firm that the issuance of warranty rejection advice is contrary to the observation of the Honorable High Court is entirely misplaced. The court order passed by the in such and such has been duly noted and respected by all concerned authorities. Further, it is also informed that an appeal has been filed before the Honorable High Court, Calcutta, against the aforesaid order, since the direction regarding fresh collection of samples in the presence of the representative firm is contrary to and in clear violation of the applicable super check policy, so and so IR inspection, rail, etc., zonal railway board or railways inventory agency shall pick up samples jointly with the field representative in case the sample is picked up, etc. And also, the said order does not grant any blanket immunity from future technical scrutiny, warranty action or contractual remedies in the event of failure non-conformity observed during the service performance of the supplied materials. And Lord, paragraph 6, they say that they can go on doing warranty rejection without taking joint sample.
Yes. Who is appearing for the respondent?
But I'm appearing for the
Have you obtained this interim order staying the operation of this order?
matter was filed before the date.
Filed?
In August, the date is fixed.
When?
In August, August month.
Correct, but once the order is passed and there is no stay, how your authority can interpret that?
But I prefer this appeal before the court or because the compliance.
Correct. I am not. You have a liberty. You have the right to file an appeal. There is no problem at all. But unless and until if there is an stay or unless and until the order is set aside, you have to take care of the order passed by this court. You have to comply with the order passed by this court. Or either till the disposal, you not to take any further steps. That can, but you are interpreting the order, which is the ground of appeal. Can you do that till the order is intact? Then
I cannot, Malad. Kindly give me a chance, Malad, with in the 2 weeks, Malad, since the bench is not.
Correct. I am not. But how you could sustain this?
Oops, I cannot, Malad. But Malad, kindly give me a chance, Malad, to take mention the matter and to bring the appeal. Malad, the fate of the appeal, if goes against us, Malad, then.
No, against us, favoring us, you are welcome, no problem. But the problem is only till date, unless and until the court stay the order or set aside the order.
I not your lordship, Malad. Kindly give me one chance, Malad, in the month of August.
So what about this order?
Since the appeal is being.
What is the final, Mr. The court? What they stated?
No, after this we came to the court. We filed the contempt application. After the notice, the reply that we.
No, what they're asking? What they're asking?
Lord, they are now, Lord, they are going to proceed, Lord, with the rejection, and Lord, without the joint inspection is the root point, of which we actually harp before your lordship, saying that we need to be present to see which materials they are selecting and from which lot.
The notification P1, P2.
And 381, if your lordship sees, they have invoked the warranty rejection clause. Your lordships kindly come to page 381.
Subsequently, file
P1 আর P2
This is
P1 আর P8
after filing করলে এটা petition এলো কি করে? This is the warranty rejection invocation.
P18 যে সার্কুলার P18
Look, if the rejection takes place, my lord, without a joint inspection, my lord, the materials are, we do not know rejection of which material.
সার্কুলারটা স্যার P8 সার্কুলারটা সার্কুলারটা করে P8 যে স্যার যে সার্কুলারটা আমাদেরকে বলেছিল যেটা এই
At least they should stay their hands, my lord, and not act contrary to your lordship's order.
Yes.
Page 91, Malad, kindly see once, Malad. Page 91 of
91
of the writ petition, Malad.
Yes.
Page 91 was originally part of the writ petition.
P1.1, Malad.
91.
Yes, Malad.
Page 91.
In my copy, Malad, it is 91.
Which page you are telling? Center or
Should be
center?
136.
136. Malad, I stand correct, Malad. I bow down, Malad. 136.
Yes.
Malad, since Malad, kindly see P1.1, Malad.
P1.1.
Malad,
Yes.
representatives of RDSO, Zonal Railway, Railway Board, or Railway Investigating Agency shall pick up samples jointly with the field units representative. In case the sample is picked up from the field units consignee ends, and with the farm's representative in case the sample is picked up at the farm's premises. So, Malad, here, Malad, your lordship directed
This is
me.
exactly what was followed by the court while
The lordship directed us there to when we picked up the sample, Malad, they should be present. Malad, this guideline, Malad, says, Malad, when the sample is picked up, there is the farm's representative is not required to present at the time of collection of the sample, Malad. Malad, we prefer the appeal, Malad. We are seeking this just modification of this portion, so that we shall pick up the sample.
Cannot you do that? But before
to
that,
effect, Malad, kindly I am seeking. That's why, Malad, kindly give me one chance
correct. So now you not to take any further action till the appeal is disposed of, or before this, or not to take any
for the timing, Malad, kindly give a
Correct.
very short time. In the meantime, we shall take out the appeal. And
The petitioner has filed the present contempt application on the allegation of willful and deliberate violation of the order passed by this court dated 24th of March 2026, wherein this court has directed as for wherein this court has passed the following order. 368, 669. Good. And counsel for the petitioner draw the attention of this court to the reply submitted by the respondent authorities dated. What is the date?
The date is 14th of May 2026.
May 2026, wherein the respondent authorities have stated as follows. Page 396.
বলেছি এটা দেখালাম এটা কি বলছে বলছে যে তুমি
Learned counsel for the respondent contempt alleged contempt
বলেছে না date
submit that the contemptors have the alleged contemptors have preferred an appeal against the order passed by this court dated 24th of March 2026 and is pending before the appellate court and is fixed for hearing on 8th of August 2026. He prays for time till the matter is heard by the appellate court. In view of the above, this could find that the respondents, the alleged contaminants of preferred an appeal before the appeal against the order dated preferred an appeal against the order dated 24th of March 2026, and no stay has been obtained by the respondents, and the same is pending for adjudication before the appeal against. In view of the above, the respondent authorities are directed not to take any coercive action against the petitioner till the next date of hearing. List the matter appear on 27th of August 2020.
That not to take any steps based on the show cause notice, which is at page 370.
Not to take any coercive action against
Well,
the
that
petitioner
part
in
Malad
terms
cannot
of
be
the show.
modified because Malad we're staying our hand Malad till the disposal of the appeal.
12th
Malad.
January
Coercive action against the petitioner with regard to the so cause notice dated
12th January, sorry, 22nd April
22nd of April
2026.
But that
That
will
is
be
page
modified,
370.
till 27th of August.
That
Yes.
can be Malad. It is a modification that can be modified in the appeal court Malad.
Or until or the order passed by the Honorable Appellate Court, whichever is earlier.
Lots.
Or any order with regard to or any order passed by the Appellate Court with regard to the order passed by the scale dated 23rd of April 2026. Okay. This is the matter on 27th of April. Yes.
This is in 22, Your Lordship. The contempt is matter number 22. 21 is the original writ petition. Much.
Actually, contempt पहले दे contempt in WP.
Your Lordship, I'm appearing on behalf of the state.
Lord, I am appearing on the petitioner, my lord. May I hand over the evidence service?
Yes.
My lord, what happened in this matter? I have filed an preemption case before the learned civil judge junior division Paschim Medinipur. Thereafter, the matter has been settled between the parties, and I have withdraw the said application, and also file an application for withdraw the deposited money, consideration money. And my lord, firstly come to page 42.
So what you have prayed here?
My prayed here, I have made an application for withdraw that has been allowed by the learned civil judge junior division. Thereafter, all the formalities, requisite challan I have deposited in the department. But till date, the accountant.
Which accountant?
The accountant of the
court.
Not release my amount. I have repeated occasion visited to him.
So why you have filed the writ petition? Why you not filed the application before the which court you have filed? Civil Judge Senior Division.
My lord,
Preemption application was filed before which court?
No, that is application before the first civil judge junior division.
First Civil Judge Junior Division.
My
That
lord,
was disposed of.
Matter disposal and
You have withdrawn that or on compromise?
On compromise.
No, the instant withdrawal application.
Between matter has been settled. I have
Settled whether you have withdraw the case.
Withdraw the case.
Okay.
And I have also filed an application to withdraw the deposit money.
Who has deposited the money?
I have deposited the money
at the time filing of the suit.
Filing of the suit as a consideration money of the deed. That I have also made an application to withdraw that amount. That order has been passed by the learned court. Thereafter, I fill up challan, said the order along with the order to the Siristadar of the court, and also thereafter Siristadar pass an order and send all the things before the accountant. But accountant not releasing my
which court?
This is a
Paschim Medinapur.
Paschim Medinapur. The accountant, my lord, I have made representation. Kindly come to
where is the order?
Order page 40.
Where is the order of depositing the amount?
My lord, kindly come to page 42.
Page
42.
42.
As order portion, the petitioner Sheikh Nijamuddin is hereby permitted as so to withdraw the consideration amount to be such and such, which has already been deposited by the said petitioner at the time of filing of the instant case.
Where is the case? Where is the application for the preemption application?
That is, I have annexed.
Page 14.
From page 23.
Page 14. What is the page 14? Page 14 is the preemption application.
Preemption application, yes.
Yes.
This is a preemption application.
Yes. Then you deposited the amount.
Deposited the amount as
Then where is the withdrawal order?
withdrawal order. Come to page 42,
41.
41, and,
41, 42.
42.
Then you made an application.
Made a-
You have submitted the challan.
Challan.
But they are not released.
No, my lord.
Yes.
Your Lordship, as per intimation from the concerned department, the payment order and the bill is ready. So kindly grant us some time to produce before the court, Your
Which
Lordship.
department?
The District Accounts Office.
Yes.
Pedinapur.
Why the petitioner has to come to the court once the court has passed an order? Tell the accountant to come here. I will initiate a disciplinary proceeding against him.
Your Lordship, as per intimation, it is ready. So on ready.
See, the order was passed by the London Civil Judge Junior Division on
20 January.
20 January 2024.
No, my lord.
24.
26.
26.
26. So,
The left
6 months.
So, Your Lordship,
Seven.
as per the
Let
instruction,
the
is ready.
accountant come before this court. I will direct the district judge to initiate a disciplinary
Kindly
proceeding
grant us
against
some
him.
time to produce before the
Correct, but I will ask the district judge to initiate the disciplinary proceeding against the this accountant.
Your Lordship.
This is the way the district court is functioning.
Lordship, it is ready. They're saying that it's ready.
This is very unfortunate affairs of the district judiciary. The petitioner has filed an preemption application before the London Court of
Your Lordship.
London 3rd Civil Judge Junior Division at Paschim Midnapur, being miss case number 56 of 2024. Full stop. The suit filed by the case filed by the petitioner was ended with the withdrawal. At the time of filing of the application, the petitioner has deposited an amount of rupees 3,62,516. By an order dated 20th January 2026, the Learned Civil Judge Junior Division First Court Paschim Midnapur, within bracket IC in charge, has allowed the petitioner to withdraw the application. By the said order, the learned judge has also permitted the petitioner to withdraw the consideration amount of 3,62,560. Full stop. After the order passed by the learned judge, the petitioner has submitted the payment order on 27th of January 2026 in a proper format. Subsequently, the petitioner has made several requests to the district accountant posted in the district judge accounts department, but till date the amount has not been released. Today, when the matter is called, learned advocate appearing for the district for the state submit that she got the information that the amount is payment order is ready, and within a week the payment will be made to the petitioner. Full stop. Considering the above, this court direct the district judge Paschim Midnapur to submit a detailed report why so much delay has been caused for release of the amount in favor of the petitioner once the learned judge has passed an order for release of the amount in favor of the petitioner. Let the report be filed by 4th of August 2026. The petitioner is directed to submit the said to forward this said order to the learned district judge for compliance. List the matter on 4th August within 5 matters under the same heading.
I appear for the petition.
Yes.
May I kindly recall, my lord, this is with regard to the tender
Respondent.
voted by Agri Irrigation Division of Malda.
Yes.
For installation of 92 solar operated in PVC.
10.
Yes, what has happened? What is the instruction?
It was supposed to file a report.
I appear, my lord, with your lordship kindly for respondent number 10.
Who is for the state?
My lord, I'm appearing for the
Where is
state,
the
my lord, as
report?
per the instructions, my lord. I'm led by Mr. Shubhankar Chakraborty, my lord.
Yes, what is the report?
My lord, we have not.
Hmm?
My lord, will kindly take the point number 7. We have not, we have debarred them from participating in 2 consecutive tenders, thereafter suspended them for 6 months.
That's the 24.
24, Your Lordship.
The respondent number 10 has been disqualified in the tender as mentioned in point number 1. Respondent number 10 has been disqualified. Which tender?
In
24. Then?
Should necessary punitive actions have been taken up, Lordship, against them.
Later the
But that is respondent number 9 also.
proposal supplement engineer so dividing moonlight and stuff from 2 consecutive tender and send the report to the engineer department of tender proposing the 6 months proposing. So what has happened? Still under the process of proposed.
Lordship, post 6 months, Lordship, we have allowed them.
Huh?
Post the suspension of 6 months,
Huh.
so Lordship, we have allowed them.
Post of the suspension.
Of 6 months.
When he was suspended?
24.
Lordship.
25.
No. Kindly come to the 9, paragraph 9.
Yes, Your Lordship.
Later, so and so authority reconsider the proposal of the superintending engineer, tender committee, Raiganj so and so, 2 consecutive tenders, Malda, and sent a report to the chief engineer on 10th of January 2020, proposing a 6-month suspension of the from the participating in the tender. So what has happened to this 10? Second degree offense.
Lordship, then allow us to come back, Lordship.
You persons are not reading the report submitting before the court.
Lordship, we have sought for the relevant instructions as well, Lordship.
Then after 2 consecutive tenders, so and so, and the 6 months suspension period, so and so, both have elapsed. When it was elapsed? When he was suspended? You are telling that January 2020 was proposed.
Lordship,
then when he was suspended? Where is the suspension order?
Documents have been annexed.
Huh?
My lord, the documents have been annexed.
Where is the document?
Still doesn't seem clear. What is it? Not
Where is the suspension order? 2024. Submitting the above decision and participation. With the subject of submitting a priest in nothing.
Remain suspended.
Yeah, 20.
Right.
Yeah, January 2025. What has happened after January 2025? Where is the suspension order?
That, Lordship, we need to take instructions and come back, Lordship.
Well, there has to be first suspension and then debarment.
Ah.
And my lord, there is second degree offense committed by it. They are
yes.
For 3 years, my lord, for consecutive 3 years, he has to be suspended.
My lord, respondent number 9.
Hmm.
My lord, I participated in 2025. I was allowed being the.
That's correct. I am not whether you allowed, whether you have received the amount. I am only on the point because the document which the authority has produced showing that 28 January 2025. If 28 January 2025 they have taken the decision for 2 consecutive of 6 months. So where is that suspension order? Or to I was before the court?
No, Lordship. I apologize,
Because
Lordship.
he was the blue-eye baby of the authority.
No, Lordship.
Then? They are the blue-eye of baby of the authority.
No, Your Lordship.
So why you are not produce all the things?
Lordship, we have sought for the documents, Lordship. Will give us another accommodation, Lordship.
Where sought for the document?
Lordship, I'm representing the state respondents.
Yes.
Lordship.
Where is the suspension orders?
Lordship, it is the suspension, Your Lordship. They have found that the documents which were submitted, which were false, and an inquiry was initiated, and subsequently, Your Lordship, it was decided to suspend for a period of 6 months. Lordship, that step was taken, Your Lordship. And at present, Lordship, this much instruction.
That's why I'm asking which date to which date? Because last decision you have taken in January 2025.
It is in January
But
2025.
prior to that, kindly see your report is contradictory. Read the paragraph 7 and paragraph 9.
Paragraph 7, it states that the circle level committee, Raigan such and such, took a decision on 28 November 2024 to consequently
the respondent number 10.
debar the respondent number 10 from participating in 2 consecutive tenders, and that was done. It was, Your Lordship, November 2024, and thereafter the inquiry was, and there was
Then come 8.
8.
The respondent number 10 has disqualified in the tenders as mentioned in point 1.
Lordship.
Correct. Then 9.
9, then 9. Later, the administrator, chief engineer, Tista Command Area Development Authority reconsidered proposal of the superintending engineer such and such, and debarring Moonlight Construction and Star Gold Enterprise
Both
from 2 consecutive tenders.
Correct. Both had come.
Both.
2024 gone now. Yes.
Not 11th November 2024. It continues from
subsequent. Read.
And send a report to the engineer in chief and ex officio secretary WRIDD Department West Bengal on 10 January 2025. Your Lordship, only in the meantime it was a 1 month.
No, that's what.
20th November.
Then the other the proceedings which are submitted.
Lordship, and thereafter it was proposed to suspend.
The proceeding which are submitted, that is of January 2025.
Lordship, this is what is the instruction.
That's why you are not.
Lordship,
this one, there is another report.
Lordship.
Your committee has signed 7 person.
Lordship, of
8 January.
Yes.
So 8 January 2025, this decision was taken. So where is the further suspension? You are telling the 24 it was suspended. So what about the 25 decision?
Only 6 months.
Only, I did that, Your Lordship. Only 6 months.
So why? What about this 25 decision?
Lordship, that.
Have you done?
Lordship, this is.
Read.
Lordship, I have read. Lordship, I'll be very candid to this honorable court. I have read what possible instruction they could have provided us. We had a elaborate discussion that we are in requirement of the entire inquiry, entire steps which were taken. Lordship, this is all they could communicate to us. Your Lordship, in the meantime, on the last date, Your Lordship, the award is in any event, Your Lordship has stayed. Your Lordship is on with regard to the inquiry. Your Lordship, the best possible instruction we could get by this week, Your Lordship, is this, Your Lordship. If so desires, Your Lordship, grants us.
You come to total affidavit, let the responsible officer put in affidavit along with the all document and all the decisions.
Lordship.
If it is covered, it is covered. If
Lordship,
it is not covered, it is not covered.
Lordship. And in the meantime, Your Lordship has already stayed
Yes,
the work.
that will extending. How soon you will file the reply? I will.
Lordship, that will take us at least 4 weeks time to file.
No. Your stay will continue then.
Lordship, these inquiry, Your Lordship, it is of 2024, 2025, Your Lordship. They have to peruse all the records. Now it is.
Okay, whatever. I don't know, but you cannot continue if the court found that it is not.
Lordship kindly grants me a 3 weeks time.
The
Lordship, one line submission, Lordship. I'm the
so you are the persons. You were 8 and 9, 9 and 10. They have got 9. 10. You are
9.
9. So you might be knowing when you have been suspended, when you have been allowed.
That is the thing, madam. As far as this issue is concerned, I am the second lowest bidder. Naturally, I am not in a position to get the tender. That is the first point. My submission, my lord, if there is any allegations or whatever they are submitting, maybe, my lord. But as far as I have the discussion with my client, my lord, I have not been briefed up to that extent. My only submission, since it may go to adversely against him in his absence, my lord. My only submission to this extent, my lord, whatever report they are putting, copy me.
That will be circulated.
Naturally. It is against you, then you have to be answered.
So far, respondent number 9 is concerned. My suspension was for 6 months.
Correct. Let that come. The
76,
in terms of the order passed by this court dated 14 July 2026, the respondent authority filed the report. But this court finds that the report submitted by the authority is not complete one, and there are contradictions. contradiction with regard to the action taken by the authority against the respondent number 9 and 10. Land Council appearing for the respondent authorities prays for 3 weeks time to file affidavit by disclosing each and every for disclosing the document with regard to the action taken by the respondent authorities against the respondent number 9 and 10. Land Council for the respondent number 10 submit 9 submit that the respondent already taken steps against the action against the respondent number 9 for suspending the petition for a period of 6 months in the year.
And thereafter I have participated.
And thereafter the respondent number 9 has participated in
and successfully completed the work.
Consider the submission made by the council for the respective party. This find that the respondent authorities have to file their report by disclosing all the documents with regard to the action taken by the authorities against the respondent number 9 and 10. 9. Let the report be filed within 3 weeks after serving the copy to the Land Council for the petitioner as well as the private respondents. List the matter on 3 weeks. On 18th of August 2026.
The restraint order is still today. The restraint order is still today.
The interim order is extended till 20th of August 2026 or until further order, whichever is available.
Before my lord rises.
My lord.
Submission, I'm submitting my lord in regarding item number 12, my lord. So I was appealing for the authority, my lord. I have for the authority concerned, my lord, I have submitted, my lord, for my lord, that the date of opening of the bid is on 27th of July, my lord. Pursuant to my lord's kind observation or consideration that 27th of July. But my lord, because of a miscommunication in the internet connectivity inside the courtroom, my lord, the instruction is that, my lord, the bid opening is today, but we are not awarding it to anybody till the report, my lord,
Completely contrary to that, your lordship, that DVC matter.
My lord, kindly record this submission, otherwise from the bar, my lord,
Otherwise I'll press for an injunction, your lordship. Then I'll press for an injunction.
My lord, I'm the officer of the court, my lord, keeps it on 23rd at the top, my lord. My lord, I will
No, then you will open the tender. Then
my lord, we are not awarding it to anybody till 23rd of July. My lord,
Single, lordship, single memo,
my lord,
single envelope.
My lord, I will be in an
And
embarrassing position before the honorable, before the client, my lord.
Because that's, lordship, I annexed the BOQ, it is mentioned 20th at 5:30.
I was scrolling to the WhatsApp message.
I understand his, your lordship. I understand his
awarding to anybody.
I understand his submission, your lordship, may be incorrect. Your lordship, in that case, your lordship, kindly grant me some protection. May I come back at 2 o'clock?
20 seconds.
Only item number 12. Only a declaration. Only.
My lord, I'm appearing for DVC, my lord, with Mr. Proshun Mukherjee.
Yes, you persons are not taking proper instruction.
No, my lord will kindly appreciate my learned colleague was there in court. My lord, the message did not get delivered properly. The later part, we apologize, lordship. We apologize that that this has happened.
Mention the matter and submit that due to some mistake in getting the information, the petition, the respondent submit that the tender will be open on 22nd or 27th of July 2026, but the tender will be open today. In view of the above, the respondents are directed not to finalize the tender till 27th of August.
And my lord, matter to appear on 23rd the top, my lord. Well, we file an affidavit.
Fix on
23rd.
Yes, my lord, 23rd. It's already fixed on 20.
My lord, 27 July, till 27 July, lordship, we will not finalize, lordship. I believe no prejudice will be caused to my learned friends.
Till the next.
My lord, may I trouble your lordship?
Grateful, lordship, grateful.
Before your lordship,
My lord, may I trouble your lordship once?
Before your lordship, right, my lord, item 1 to 6, original documents are required to be brought for handing over, my lord. But somehow, my lord, I was waiting, my lord. There was so crowd, my lord. Lordship has fixed the matter, my lord, sometime in the month of August.
Out of list, if not appeared, then out of list.
No, my lord, only one thing, my lord. They are, my lord, to produce, my lord, the original document, my lord, they have already released for other person. Can we appreciate, my lord? Instead of, my lord,
have you produced the document?
Yes, my
lord, already the releasing order has been issued to the command hospital.
Command hospital they have emailed, my lord, to command hospital for getting the documents so that it can be handed over to us, my lord. My lord, kindly make it, my lord, day after tomorrow, my lord, so that it can be.
Item number 1 to 6. Land Council for the state has handed over the letter dated 17/7/2026, wherein the Director of Medical Education West Bengal has requested the Director of the Dean Command Hospital Eastern Command Kolkata to send original documents of the certificates of the petitioners to the Office of the Directorate of Medical Education West Bengal by 19 July 2026. In view of the above, the case is adjourned. Let the matter appear on 24th July under the same head.
The last topic, 15th order, my lord, the state advocate has not been reported.
नाम record कर देना.
May I travel your lordship?
Yes.
And the next matter, my lord, was mine. It's a 2019 writ.
उसका साथ रख देना first में. First में. हाँ.
It's 2019 writ, my lord. Next matter. My lord, possibly, my lord, I need to serve them, my lord, once again. It is appearing at my instance. May I, my lord, have, my lord's kind liberty, my lord, a direction upon me, my lord, to serve them and come back.
Which matter?
My lord, 25, item number 25.
Record करो. Land Council for the petitioners is directed. Council for the petition is directed to serve a fresh copy, serve the copy of the writ application.
Additional Solicitor General, my lord, learned additional Solicitor General.
First, to serve the copy of writ petition along with the connected document to the ASGI by tomorrow.
By tomorrow, my lord, we
By
can
tomorrow. Tomorrow.
and any day which is convenient to your lordship.
Let the matter appear on 27th.
27.
Okay. Same head. Under the same head.
May I have your kind leave. Is my
Huh?
kidney transplantation is the immediate need. That's the urgency.
Kidney transplant, but
Well, the board is yet to take any decision.
Hmm.
That is pending as of 12th May.
who is the donor?
Donor is from the outsider. That's I've seen your lordship's order.
How the linkage?
The link number.
How the linkage is to be established?
Linkage was difficult to show, but there is no other intention that I can demonstrate from the records.
Because one matter is pending.
Yes, lordship's own order I have seen in other matter.
No, other I pass an order. How it is pending with regard to the linkage? How the linkage is to be established under the rule 7 or rule 9?
They are common friends, but that I can demonstrate, and the requirement I can demonstrate. They are yet to communicate me the decision even.
Okay, what is the urgency? File it and mention it. What is the urgency?
Delay will ultimately frustrate.
Okay, you file it, mention it. File it, serve the notice and come.
Leave.
Fine, this is not all the things. You file it, come mention, I will see to that. Yes.
I'm sorry, Malad, I couldn't mention in the morning. We didn't have instructions. Malad, this writ is pending before your lordship. It's supposed to appear on 23rd. My lords had been pleased to direct to appear it on 23rd. This is challenging a forensic audit report. Now what has happened is basis that forensic audit report, FIR has already been filed and the criminal proceedings have started. And it's entirely on the basis of the forensic audit report. There's no other allegation of fraud declaration. And the FIR is entirely on the basis of forensic audit. 23rd, it is coming up. If we can have some precedence either on that date, first 10 matters, or any date prior to that, my lords.
23rd is already fixed.
It's already fixed, but it's not in the priority list. Your lordship had directed to appear on 23rd. This has those 18-20 banks are there, your lordship remembers, and then that the company has gone into CIRP. So one director is there, then there's application for addition of party directors and transposition of the RP to the defendant, because now the RP is not going to be interested. But there's the directors who have also been declared fraud basis that forensic audit. Now, basis that forensic audit report, they filed FIR against the directors. Otherwise, the whole writ will become in first. 23rd, your lordship has it.
Yes, call the list.
Grateful, my lord. Deeply obliged.
Yes. I appear for the petitioner. Unfortunately, the respondents are not appearing in this matter. Initially, my lord was pleased to take up this matter on 3rd of December 25.
Yes.
I am protected, but my lord,
nobody is appearing.
No, none is appearing. Every time, my lord, your lordship have taken up the matter, my lord, we have served notices.
Who are the respondent?
MSME Council and my lord, the complainant. Yes.
All are outside.
Yes. But contract executed here.
So what can be done? Service affected?
Yes, yes. Several times, sir. And my dear lordship was pleased to extend this interim order time and again. I think the last extension was on 23rd April, no, Rector?
No, 9th June.
9th June. I'm sorry. Yes, 9th June.
So, it will be proper in their absence. When the last notice was issued?
Last chithi cover is that.
And he made a communication last date?
Last communication was on last communication 5th of February. 5th of February 20. Activity of service file.
After 5th February, March. So I am fixing today's fixed date. Want to argue, I have no problem, but other side is...
Yes, I also don't want that something is done ex parte and then it's carried to the appeal court on that ground. Yes.
In spite of service of notice, none appears on behalf of the respondents. Accordingly, for the interest of justice, the case is adjourned. The petitioner is directed to inform the next date of hearing to all the respondents and to file a fresh affidavit of service. It is made clear that on the date fixed, if none appears on behalf of the respondents, in spite of information about the date of hearing, the writ petition will be taken up for hearing in the absence of the respondent authorities. Let the matter appear 17 September at 2 p.m. Full stop. Interim order is extended till 22nd of September.
No, it's, your lordship was pleased to extend it till disposal on 9th of June.
Till disposal.
9th June, third paragraph.
17th, na?
17th September.
17 September, 2 p.m. is specially fixed matter.
But maybe at 2 o'clock.
At 2 p.m. So the notice, if they now just come, then please.
My lord, I have an instruction to appear on behalf of the private respondents, but no copy has been served upon them. Private respondent.
Where is the affidavit?
Here is, my lord, the affidavit, my lord.
Have you served the private respondent?
My lord, one has been delivered.
One
Other
is
two have-
private respondent. All private respondents.
Not there are
How many private respondents?
3 private respondents.
You are appearing for whom?
Vivekananda Banerjee
3
has
or
been-
5.
You are appearing for
3.
all.
But my lord, according to my clients, my lord, they have not received any copy till date.
Vivekananda Banerjee has received.
Vivekananda Banerjee received. No, my specific instruction he has not.
Delivered. Okay, serve the copy.
Yes, sir.
What is the matter?
My lord, what has happened, my lord? Kindly, my lord, comes to
What is the prayer?
prayer, my lord, for mutation, my lord. Kindly, my lord, comes to page
Mutation.
Cancelling
the impugn communication.
Yes, my lord, a deed of lease was executed in my favor by the state of West Bengal. My lord, in that deed, Salt Lake property, my lord, clause 8 is there. Clause 8 states, my lord, in case of a lease in favor of 2 or more individual lessees jointly, in any one of such joint lessee will have the right to transfer his share to the other co-sharer or co-sharers.
Okay.
Now,
Who is appearing? You are not appearing. State?
My
You
lord,
are appearing.
yes, ma'am.
Okay. Land Council appearing for the private respondent submit that he has not received the copy of the writ application. Accordingly, petition is directed to serve the copy of the writ application along with the connected document to the Land Council appearing for the private respondents by tomorrow. Full stop. List the matter on.
My lord, as I find, my lord, there is no scope of an interim order. After
I am
they have
not
served,
passing any.
therefore,
But-
if your lordship passes, we want to use affidavit. My lord.
Want to use file affidavit?
It's a second round of litigation, man. That's why no.
Full stop. The respondent is directed to file their affidavit in opposition within 3 weeks. Reply, if any, they are to be filed within 2 weeks thereafter. This is the matter on 2nd September under the heading adjourn motion.
Grateful, lordship.
Next.
Seven, my lord, I beg to appear for the petitioner, my lord. My lord, it is that matter regarding passport, my lord. They charged me for some penalty where, my lord, last occasion, my lord, by an order dated 9/7/2026, my lord, there was a direction on me to use opposition. But, my lord, they served me a report where they said that some confidential documents is there, so they will not give us anything. So, my lord, it is top secret. So we did not use any opposition, my lord. However, my lord, last occasion we produced a manual. They questioned about that documents that where from we get it. My lord, I am using a supplementary affidavit only annexing that documents that it is available in the portal of the Ministry of Home Affairs. And advance copy I have served, my lord, on 15th. My lord, the issue is, according to us, my lord, our prayer is that the quantum they charged is initially 4 lakhs. Then subsequently they says that it's a technical fault. The amount would be 2 lakhs. According to our calculation, my lord, and in view of their circular, for overstaying within 180 to 1 year, they are charging me for 1 lakh. And for, my lord, non-registration is for 1 lakh.
Yes, where is the report?
And our case is that we should have
Yeah,
been
yeah,
charged
yeah,
with
yeah.
10.
The payment request, where is the hearing?
Hearing was provided.
Payment request, he is admitting regarding payment with regard to the hearing date. Your contention was that
there is no hearing.
yes, your contention that no, he has not appeared in spite of the server.
72. That my
No,
representation. to
my
them.
his representation at appearing at page 72, my lord. So far as this representation is concerned, my lord.
Say, my lord, it's not a representation. It's the reason why I didn't pay the amount at that point of time.
This basically, my lord, auto-generated thing.
Correct.
Now, my lord, I have to apply for my lord extension of this.
Correct.
Now, he has applied for extension of this. Now, my lord, he was supposed to make the payment. Once he makes the payment, my lord, then everything.
No, that is a disputed.
That is now, my lord, question is, my lord, your loss, my lord, can you visualize the scenario? Today, my lord, person is staying, my lord, in India, my lord, beyond the extended.
Correct. Correct.
Now, my lord, once the visa is expired, now, my lord, he has to apply for fresh visa.
Correct.
And at the same time, he has to apply for fresh registration.
Correct.
The two things, my lord, are different. So, my lord, one is, my lord, extension of visa, another is for registration, re-registration.
Correct.
So, my lord, the money which you are charging, my lord, 1 lakh and 1 lakh for exceeding, my lord, 180 days.
So that second 1 lakh, how it can be? Because you are extended till August 2025.
Yes, 8th August.
8th August 2025.
Yes.
Then thereafter
And my
there is
first
no 1 year.
application is
Can you
on
come?
3rd September.
Can you come to second
Yes.
II? Non-registration of foreign.
Registration of foreigners violating the provisions of section 6.
Correct.
Uh,
181 days up to 1 year, 1 lakh. But
Yes.
here 8/8/9 2025.
8/8/2025.
So 1 year has neither 120.
180 days gone.
When?
181 days. From 181 days to up to 1 year. This is not
1 lakh.
1 lakh. So like 8th August 2025 is the last.
Correct.
So from 8th August, 180 days gone. Today we are on. We are in.
Yes, that is I'm saying.
July.
If I calculate today, my lord, the amount what they are saying that is right. But my first application for extension is on September.
September.
They would have charged me 10,000 on that point of time.
September.
But they didn't do so.
That is
In contrary, page 70.
Kindly see, if you made an application and you're not considered, so how it can be?
He made an application, Lord. Subsequently, we requested him to make the payment. He did not make the payment.
Correct. See, 8 August 2025, the last action.
Yes.
Correct.
Yes.
And okay, he could have been filed before that, 8 August 2025, but he could not file. But he filed when is the your extension application?
3rd September.
3rd of September.
Yes.
That is 1 month before 1 month.
Yes.
Correct. So he has filed. But you have not taken the decision to deposit 10,000 and 1 lakh. Okay. He has not deposited. But his application is before you. So you have not taken the decision.
His application was before me. I reminded him by 9 times to make the payment. Once he could not make the payment.
Where is the make payment or request?
This envelope.
No, that is correct. Now in here.
Here, page paragraph 5 of my report. Can you see? Paragraph 5 of my report says. May I just place my paragraph on from paragraph 4. He further applied for as well as for.
Just a minute. Paragraph 5 of the report.
Report is on 29th of June.
Yes.
Now, can you see paragraph 4?
Yes.
He further applied for visa extension on 3rd of September 2025.
Correct.
However, her previous visa had expired
on 8/8.
So penalty of rupees 10,000 for was requested for further processing of her visa.
Correct.
Extension. Next, the payment request was sent to her 9 times, but every time it was auto pulled due to non-response of the applicant. So she was given the ample opportunity to pay the penalty, but the applicant did not honor the payment request. Hence, her application was finally closed. These office gave the applicant ample opportunity to comply the penalty rules and regulations. Her application was cancelled on 27th of March 2026 due to non-response from the applicant. She again applied. For
yes, got it.
Once he again applied on 12/4/2026. Earlier
I have to, because my lord, page 72 of my read petition. On December, I informed them that I am ready to pay that. Then they said that once my daughter's clearance would be there, then it would be easy for me to get that.
No,
I
that is
mailed it to
correct.
them.
See, you have submitted on 3rd of September. Immediately, when you requested the first payment. So on 8th of March 2026.
It, my lord, all probability prior to my lord December, because December I wrote them mail.
9 letters were written, my lord, from December 2025 to March 2026.
Correct. So you are given on 26 December.
No,
December
25.
Yes, 26 December 2025.
Then
You requested to deposit the amount after on receipt of the application on September. Correct.
Yes.
After 3 months.
Correct. By that time, 3 months was over.
Yes.
Then
Then they closed
thereafter,
my application.
just a minute. Then thereafter, you continue to allow to director to pay till
Was probably March.
18th of March.
Yes.
And 27th of March you are
Close,
cancelled.
close.
Then my second application is on my lord 12th April.
Yeah.
Immediately I applied.
So now, why you not
My case is
deposited?
that they, my lord, generated that fine. If they could have replied me my December 12th mail, my lord, that they are not considering that mail.
What
my
consideration?
lord, page 72 is the first objection I raised to them. Then my lord, they specifically said that at the both of us.
So that's why you see 12th December 2025 you have given the mail. But they have sent a mail to you, but you not respond. That is on 5th. That is on 26th of December.
Yes, my lord, the dispute is that they initially charged me 2 lakhs. At that point of time, they charged me 2 lakhs. But I have to stay for my lord at least 1 year. If I did
Correct, see,
180 days.
Whatever it may be.
So my fear is
Subsequently, by a letter dated, you have been asked to deposit the rupees 10,000.
That initially. They
Initially.
did not charge me for registration.
Correct.
Only for
Registration.
processing.
Yes.
Their slab says that they should have been charged me for my lord registration. They did it. I am not my lord disputing. Then my lord, when I get the 10,000 payment in the month of my lord, on the basis of my first application in the month of September, December I wrote to them that then they said. In that mail, I specifically took that averment that after discussion in the office, they said that my daughter's application should be processed first. Then I will get that extension visa.
You have requested, but
no, my lord,
okay, whatever. Why you have not get the extension by depositing the amount?
My lord, I am ready to deposit. It's not that case I am not deposit. But my lord, that registration part should have been considered by you.
The petitioner has filed.
That is my only prayer because I am a cancer patient and I didn't apply it within time, my lord. I was admitted in the hospital.
So now what is the total claim? 1 lakh and
2 lakhs.
1 lakh, 1 lakh, 2 lakh.
Lord, so far as overstaying, I am ready, my lord. So far as registration, my lord, let them, my lord, kindly consider my that aspect. Because overstaying, my lord, I can't deny, my lord. I am staying. And so far as my lord registration, they purposefully charge me for that 2 lakhs by my lord delaying
where is the communication for 2 lakhs?
My lord, in the supplementary affidavit, my lord, I have annex.
Yes, my lord, supplementary affidavit, my lord, page
15.
15. What supplementary?
That is what we can get it from the website. My lord, supplementary affidavit, my lord, filed on 23rd of June. Page 50.
2 lakhs.
2 lakhs.
But in prayer you are asking
then they increase it to 4 lakhs.
Where that?
My lord, that in the writ petition.
That is my lord, page
my lord, page 78.
There is a mistake.
Then they come up with a plea that as it's a system generated copy, so my lord, due to their technical glitch, it goes up to 4 lakhs. Then I filed a writ petition.
The petitioner has filed the present writ application challenging the demand made by the respondent authorities for depositing of amount of rupees 4 lakhs. Depositing an amount of rupees 4 lakhs for – 4 4 lakh for extension of the visa and overstaying of the petition in India. Extension of visa and overstaying of the petition in India. And counsel for the petition submit that. Petitioner submit that. The petition, the visa of the petitioner was extended till 8th of August 2025. And registration of the petitioner was also till 8th of September 2020. Subsequently, on 3rd of September, inadvertently, petitioner could not made an application for extension of the visa and registration before 8th of August 2025. The petitioner has made an application for extension of visa and registration on 3rd of September 2025. On receipt of the application filed by the petitioner on 3rd of September 2025, the respondent authorities have informed the petitioner that the visa of the petitioner was expired on 8th of August 2025, and as such, the penal of rupees 10,000 for overstaying is required to be paid by the petitioner for further processing of the visa extension. Full stop. The petitioner, full stop. Land counsel for the petitioner submit that, full stop, that subsequently the respondent authorities have issued further communication. What is the date of this mail? Further communication that page 50. What is the date?
December 12, 2025.
On 12th of December 2025, page 15.
Page 72.
Page 15.
Well, that is their system generated. I can't get the date.
Counsel for the petitioner further submit that subsequently the respondent authorities have demand rupees 2 lakhs instead of rupees 4 lakhs. 4 lakhs. Non counsel for the petitioner submit that. Non counsel for the petitioner submit that ये क्या AC चलता नहीं? Submit that as per the notification dated 1st of September 2025, a foreigner staying in India without the valid passport or other travel document in contravention of Section 3 of the Act, if it is more than 181 days and up to 1 year, there should be a fine of rupees 1 lakh. And if a foreigner violating the provisions of Section 6 of the Act more than 180 days up to 1 year is rupees 1 lakh. He submit that the petitioner had the valid visa on 8th of August 2025 and immediately on 3rd of September 2025, the petitioner has applied for the visa as well as registration and as such the respondent authorities cannot claim an amount of rupees 1 lakh for overstaying for registration in terms of the provisions of Section 6 of the Act. He submitted that only the petitioner has made an application for extension of the visa and registration within 1 month, and as such the respondents have claimed rupees 10,000, but subsequently they have increased the amount of rupees 1 lakh. 1 lakh. Land counsel for the respondent authorities submits that by mistake inadvertently the respondent authorities have claimed rupees 4 lakhs instead of rupees 2 lakhs. He submits that as per Section 6, if the foreigners overstay in India by violating the provisions of Section 6 above 181 days up to 1 year, 1 lakh rupees is to be paid. In the present case, though the petitioner's visa and the registration was 8th of August 2025, but the petitioner has made an application on 3rd of September 2025, and considering the application made by the petitioner, the authorities have informed the petitioner to pay the final fee of rupees 10,000 for overstaying for further process of the visa, but the petitioner, in spite of repeated requests made by the authorities, have not paid rupees 10,000. And as such, mm, the period of 181 days has been completed, and thus the respondent authorities have claimed rupees 1 lakh. 1 lakh. At the land full stop, land counsel for the petitioner submit that in the month of December, the petitioner has made a detailed representation to the authorities, and on receipt of the representation, the authorities have informed the petitioner that the case of the petitioner for extension of visa and registration will be considered along with the case of the daughter.
And her medical.
Along with the case of the daughter and on the medical ground of the petitioner. But subsequently, the respondents have started charging rupees 1 lakh for the overstay. Heard the land counsel for the respective parties peruse the materials on record. Admittedly, till 8th of August 2025, the petitioner was having the valid visa and foreign and registration. It is also admitted that before 8th of August 2025, the petitioner has neither made an application for extension of the visa or for registration. The petitioner has made an application before the authority for extension of visa and registration only on 3rd of September 2025. On receipt of the application of the petitioner for extension of visa and registration, authorities have processed the matter, and on 26th of December 2025, the petitioner was informed to pay the amount. But the petitioner, in spite of the receipt of the mail, no amount has been paid. Subsequently, on 8 occasions, till 18th of March 2026, the respondents have requested the petitioner for deposit the amount as claimed by the deposited the amount of 10,000 along with rupees 1 lakh for extension of visa, but the petitioner failed to pay. Accordingly, on 27th of March 2026, the application filed by the petitioner on 29th and on 3rd of September 2026 for extension of visa as well as registration was cancelled. Subsequently, the petitioner has made an application for extension of visa on 12th of April 2026. By that time, the period of 181 days is over, but it was up to the 1 year. Accordingly, the respondent authorities have claimed rupees 1 lakh instead of rupees 10,000 as claimed in the month of December 2025. Considering the above, this court finds that the petitioner has given several opportunities for depositing the rupees 10,000 for overstaying, that is within 181 days, but the petitioner lost the opportunity to deposit the said amount in spite of several requests made to the petitioner. And the application was dismissed and cancelled on 27th of March 2026. By that time, the 181 days was completed. According, this court finds that the respondent authorities have not committed any illegality. According, the petitioner is liable to pay rupees 1 lakh as well as rupees 1 lakh for the overstay. Let the amount be paid by?
I have to pay within 1 year.
That,
I have to pay within 1 year because
Yes.
if I cross 1 year, then they will charge me. for
Correct.
2 years. So, within that.
The petitioner is directed to pay the amount as early as possible so that that's why pay the said amount as early as possible so that the respondent authorities can proceed with the matter for extension of visa and for registration. If the petitioner failed to pay the amount, the respondent authorities are liberty to take appropriate steps.
As on date, he is default. He may be arrested at any moment.
I can.
On the very first day, I ask you, where
He is saying, I have.
is not if he's not depositing, what can be done?
I am tomorrow or day after tomorrow. I can relax. I have to arrange
Deposit.
because initially
What can
in one line, extension of visa and both are there. One place is my past application got cancelled. It was not cancelled, it was closed.
No, it was recorded cancel. Reports
The report they said-
report they recorded cancel.
Great.
Disposal.
My lord.
Next.
28, my lord, I am for the petitioner.
Yes. What is the can?
Can, my lord, it is my lord, the dismissed, it is my dismissed.
Huh?
Due to my lord, death of the my lord,
Can
advocate.
डिसमिसल में क्या नहीं आया, क्यों आया? मेंशनिंग स्लिप में यहाँ क्यों आएगा? कैन
Restoration and
में जाता है.
मतलब the learned advocate on record, मतलब he was died during the pendency of this case. That's
Who has mentioned the matter? Who has mentioned the matter? You have mentioned what? You have not mentioned that your final application for restoration. That's why it has come in the heading of the urgent motion. Otherwise, it could have been come and you are mentioning something and doing something.
My lord, it was just mentioned about the urgency.
Urgency of the unless and until the writ petition is restored, how the urgency will taken up? You could.
You lost it, mainly take it up in any day, my lord. It is my lord the my contention that the advocate, learned advocate, who has died.
Yes, what is the contention?
So therefore,
Huh?
it may be restored, my lord, and my lord fixed up the any day.
When it was 2023.
Huh?
Initially.
2020.
When it was dismissed. 25.
23, 45. When the matter was called on, my lord, the learned advocate was died.
No accommodation.
It is my contents. So, my lord, now, yes.
September 2025, when you made an application.
My lord, I made an application, my lord. Subsequently, and that is 31st of March 2026.
Right.
When the client came to the court, and he inquired that the advocate died.
Correct.
So that's why, my lord, I made application.
1 year client has not met with the advocate. And
so your lordship kindly consider this, my lord, case. I have stated, my lord, paragraph 7, my lord, your lordship kindly see. They want searching on the
petitioner has filed the present application being Can 1 of 2026 for 1 of 2026 for condoning the delay for filing an application being Can 2 of 2026 for recalling of the order passed by the court bench of this court, passed by this court dated 19 September 2025, wherein the writ petition was dismissed for default. Police counsel for the petitioner submit that when the petitioner tried to contact the learned advocate who was conducting the case, he came to know the learned advocate who was conducting the case was passed away, and subsequently the petitioner has contacted the present advocate, and the present advocate has verified the record and find that the writ petition was dismissed on 19th of September 2025. Accordingly, the petitioner has advised the learned advocate advised the petitioner to file the present application. Consider the submission made by the counsel for the petitioner and peruse the application. This court find that the petitioner has shown sufficient cause for not filing the application for restoration for recalling of the order dated 19 September 2025. Accordingly, delay is condoned. Can 1 of 2026 disposed of. This court also find that the petitioner has shown sufficient cause for non-appearance before this court on 19th of September 2025. Accordingly, Can 2 of 2026 is allowed. Order dated 19 September 2025 is recalled. WPA number 9701 of 2023 is restored in its original file. Please the matter in the combined monthly list of August 2026. Next. Under the
second matter also identical.
Yes, next.
Second matter is also identical. 29.
Yes.
And it is also, my lord, same situation, my lord, the learned advocate. Well, I filed this application.
18 September ho gaye.
Same order.
1 and 2, na?
Gratefully.
Both can dispose of.
Well, the matter will appear in the list, my lord.
Next.
May it please your lordship, my lord. I beg to address your lordship, my lord.
Yes.
My lord, My lord, I appear on behalf of the petitioner. The point here is extremely short, my lord. I am trying to purchase the right of reversion of a leasehold property. Your lordship kindly comes to the deed of lease. That's at page 27 of my lord's brief. The term of the lease under the deed is at page 34. Please come straight away to page 34, my lord. The term of the lease.
Page 24.
Page 34, my lord. Term of the lease, my lord.
Yes.
Now this indenture witnesses, lessors hereby, owners hereby demise to the lessee company by way of lease for a period of 99 years from 1st January 1988, subject to payment of rupees 200, etc. Now, my lord, this is, my lord, therefore the demise. This demise took place. Now, kindly come to page 27. The demise took place on 7th December 1987. Therefore, from that 99 years, a sizable part, a small part has gone and a sizable part is still left. Now, what I want, my lord, is I want, my lord, an assignment of the reversion. An assignment of the reversion. Now, as soon as I want an assignment of the reversion, it's an interest more than 100 rupees in immovable property. Therefore, I am liable to pay stamp duty and also have it registered. When I go and apply, my lord, to the stamp authorities in order to find out the amount I have to put in, I am given, my lord, an e-assessment slip of the property as if it were a freehold. Please have page 60, my lords. Page 60.
Yes.
Please come, my lord, to the e-assessment slip that has been given.
Correct.
Now, my lord, kindly look at this total registration fee payable market value, my lord, right-hand column, more or less during the right-hand quarter of the page, additional transaction declaration market value 32 lakhs 50,000, 32 crores 50 lakhs 5.
Yes.
And my lord has seen total stamp duty is 2 crore 27 lakh 50,000 and odd.
Correct.
So what they are doing is they are saying we are giving you the market value of the land, the property as it exists. You have to pay us 7.1% of the market value.
Yes.
I am saying I am not purchasing the ownership of a freehold property. I am assigning to myself the reversion. Assignment of reversion, according to me, and I have got a valuer's report to show, my lord, for my efforts at page 42. Relevant portion of the valuer's report is at page 48. Page 42 at page 48.
Yes.
According to the valuer, and he has used the methodology that is given, my lord, in the usual ratings. I will not trouble your lordship with the entire detail. 47, the calculation starts. 15 lakh of rupees is, as on the date of the valuer's report, 1st of February 2025. We proceeded a year and a half later. 1st of February 2025, the valuation of the right of reversion was 15 lakh of rupees. My lord, sees, my lord, page 48.
Yes.
Please see, total value of lessor's interest is 15 lakh of rupees. Therefore, that is what I am getting assigned to myself. The lessor's interest in a property which is under lease, not the lessee's interest. The lessor's interest in a property under lease of 99 years, balance the lessor's reversionary interest I want to purchase by way of a deed of assignment of lessor's right of reversion. The valuation of the right of reversion is 15 lakh of rupees. But they are telling me that I will have to pay stamp duty on the valuation of the entire property taken as a freehold, which amounts to.
So what you have done in 88 to 2005?
No, from 88 to 2005, I could not get the owner to sell to me. Now the owners are ready to sell to me.
Yes.
The owners.
The deed was executed between whom?
The original deed was executed between the owners and the lessee. Please have a look, my lord, at the party's name at page 27.
Correct.
The owners are Probir Kumar Mukhopadhyay, Pranab Kumar Mukhopadhyay, Probir Kumar Mukhopadhyay and Srimati Kajol Das. They are the owners.
Yes.
And the lessees are, next page, my lord, at page 28. Bhagirath Saraf Samiti, Bhagirath Baraf Samiti Private Limited. This is the lessees. Now, my lord, I am not interested in taking the interests of the lessees. I want to take from the owners the right of reversion. I am not prevented in law from dealing with a right of reversion. I can purchase.
How without executing any deed by the lessees, how the right of reversion will come to you?
My lord, the reversion is the owner's right. Reversion is the owner's right. Lessee has nothing to say if the right of reversion goes to the owner.
Where is the owner?
My lord, the owners are private respondents before
My
your
lord,
lordship.
I am appearing, my lord, for the private respondents.
There is no hide and seek here, my lord. It's a consensual transaction whereby the owner will assign to me the right of reversion. The valuation of that is 15 lakh of rupees according to my valuer. They are saying their e-Nathikaran portal does not have anything to do regarding that.
What has happened to the lease deed?
The lease deed is persisting, it's subsisting, and it will remain so. Nothing will happen to the lease. I will step into the shoe of the lessor. I will step into the shoe of the lessor. The lessee cannot stand in my way. And lessee is not standing in my way. I am stepping into the shoe of the lessor owner. Today, the lessor owner has a right of reversion. He is assigning to me the right of reversion. I am entitled in law to purchase the right of reversion. For that, I need a registered instrument stamped with appropriate stamp duty. What is the property here is the right of reversion.
Where are the lessees?
The lessees are there, my lord. The lessees are very much there.
They are a party.
Lord, I have made, my lord, the
You have made the lessor as a party.
owners, yes, from whom I am taking. Owners.
But we don't know what is the situation between lessor and lessee.
My lord, if your lordship wants, I can make the lessees a party also. There is no difficulty.
You have to lessee made a party, then let they come. Yes, they have no objection for this may be executed between you and the.
Yes. No difficulty that way. My lord, kindly. Yes. My lord, kindly at my prayer, my lord, kindly add them. I am requesting my brother to kindly speak into the microphone.
That base, my lord, kindly takes section 109 of the Transfer of Property Act, which says if the lessor transferred the property lease or any part thereof, or any part of his interest therein, the transferee in the absence of a contract to the contrary shall possess all the rights.
Correct. That's why all the rights now, as per this list, they are not having any right. So the reversion will not come. So let the lessee comes. Lessees come and say, yes, we have no problem if the ownership will change.
My lord, if this is transferred, the lessee will also, all the rights of the lessor will go to this new end.
That's the one. But this is the lessee, without the consent of the lessee, if there is a dispute, what will happen?
My lord, also a direction may be made. We want to file a composite report on the valuation part.
Let the first the added respondent come. This court find that the lessees to be are the necessary party in the present writ application, but the petitioner has not made the lessee of the lease deed dated 7th December 1987 as party respondent in the present writ application. Accordingly, the petitioner is given liberty to add the lessee of the lease deed dated 7th December 1987 as party, as respondent number.
Respondent number
10.
Respondent number 10. No, respondent number.
Yes, 10. 6, 7, 8, 9 are owners.
9 up to 9 are owners.
Respondent number 10. And to serve the notice to the added respondent and to file affidavit of service on the next date 6. List the matter on 12th of August 2026 under the
obliged. Deeply obliged. My lord, only one prayer. Kindly permit my advocate on record to make the correction here and now. Otherwise, Lord, it might take here and now, Lord. Kindly give me liberty to the advocate on record to correct the cost title by including the name of the lessee.
Petitioner, the advocate on record of the petitioner is given liberty to add the private lessee as party respondent in course of the day. ऊपर है ना उसमें ऐड कर.
Yes,
you do that.
Your Lordship, only one humble submission is that your Lordship was pleased to direct the matter to appear as top of the list, your Lordship, because earlier your Lordship was pleased to direct.
Let you first you serve then. Yes.
My Lordship, I am for the petitioner 128. My Lordship, with the intervention of this court, my Lord, the respondent, answering respondent went before the mediation, and after the mediation, around 15,48,000 has been outstanding rent has been paid by the state. Not my Lord. The interest part has not been settled, my Lord. The interest claim which the petitioner has made, and it is been reflected in point number 4, my Lord, of the mediation report.
So far, the claim and interest of the petition over the principal amount is due concern is same is agreed to be left for adjudication by the Honorable High Court.
The petitioner claimed 12% interest on the outstanding rent, my Lord, without any
claim. What is the matter?
The matter is being the respondent, a state, my Lord, has kept without any reason kept the outstanding rent with them and haven't paid from October 2019 to April.
How this court can decide with regard to the interest?
My Lord.
Then you have to file a suit. Then the special officer will be appointed. Then the interest.
My Lord, here is a judgment which I like the court to consider, my Lord. My Lord can direct the state to pay the interest, my Lord, on the outstanding any kind of area. My Lord.
Who is the party? State.
State, my
Which
Lord.
department?
It is the bank, my Lord.
Which bank?
Punjab and Sindh Bank.
For appearing.
My Lord, here is another judgment, my Lord, where the state has directed to pay the outstanding state was. It is, my Lord, in page 4, my Lord. My Lord, here it is a rent dispute, my Lord. Here the court has directed, my Lord, in page number 17 means 105. The court, this is the same rent matter, my Lord, outstanding rent.
Which paragraph?
My Lord, it is point number 16 in page number 105, my Lord. In citation 1999, my Lord.
Record and all. Land counsel for the petitioner has handed over the proceeding held before the mediator on 6th of May 2026, wherein the respondent number 224 have handed over the demand draft of rupees demand draft wherein it is recorded that the respondent number 224 have handed over the demand draft dated 6th of May 2026 for a sum of rupees 15,03,205 in favor of the petition number 1, being the total covered principal amount of rent from October 2019 to February 2026 in the said minutes of the meeting, in the said proceeding, it was also recorded that the respondent number 2 to 4 have also handed over a bank draft, two bank drafts dated 6th May 2026 of rupees 22,444 each to the petitioner, being the what is the amount? The second amount?
The second amount is 22,444 too, twice.
petitioner
And the
to
total amount is 15,48,093.
Now, what is this amount? Who has drawn this meeting?
My lord,
Whether it is clear in the
my lord, yes, my lord, it is from October to February. First one.
First is the October to February.
Second one is, my lord, from for March and April.
It is further recorded that respondent number 2 to 4 have further handed over two demand drafts of dated 6th May 2026 of rupees 22,444 each to the petition number 1 and the petition number 2. Petition number 1 only.
No, my lord. Petitioner number 2, petitioner number 1 to 8, and the money is being transferred to the petitioner number 1's account.
To the petition number 1 being the rent for the month of March and April 2026. It was further recorded that the respondent bank will continue to pay the rent for the month for the following months as per the lease deed dated 28th of June 2018. With regard to the interest for the period from October 2019 to 2026 is left open to be decided by this court. Let the proceedings of the mediation dated 6th of May 2026 be kept with the record. Full stop. As none appears for the, you are appearing for the bank. As none appear for the bank, police of petition is directed to inform the next date of hearing, list the matter on 13th of August 2026. Next.
Well, this is my everyday service. Here I have come, my lord. I am the businessman, my lord. I am running a jewelry shop, my lord. On my bank account has been defreezed by the police officer. But what happened, my lord? On 20th May 2025, one unknown customer came to my shop and purchased some jewelry. Well, they have paid the amount through UPI transaction. I have received. Your lordship, kindly come to page 2, paragraph 2, my lord. Your lordship, kindly come to paragraph 2. I have from the petitioner state that on 20th May 2026, one unknown customer came to the shop for purchasing jewelry at about 12:15 p.m. And the said customer represented himself from Hiranmoy Pahari. At the time preparing the bill, he also signed the Hiranmoy Pahari. He purchased one gent ring, total value 44 lakhs and 2 pieces of pasha. The petitioner issued the invoice mentioning the breakup value such and such, GST such and such. While making payment, the said person wanted to payment through UPI. My lord, and he requested to share the petitioner's QR code. So when I gave the care, so he came out the shop and then he said that after he went outside the shop for a few minutes and returned informing the user the payment has been credited. So I have, my lord, this is my rent receipt is there, my lord. Annexed P1, page 16. This is the receipt.
Which bank? Which bank?
My lord, Hiranmoy Pahari.
Which bank?
Bank, Indian Bank. I have served the notice. Indian Bank. This one number 6.
Not State Bank.
Yes, my lord.
State Bank is not there. Where your account is lying?
In Indian Bank, my lord. Indian Bank. This one number 6. The manager Indian Bank, Jadavpur branch. My lord, I'm relied upon the judgment. Unreported judgment. They have issued the notice, my lord. I made the representation. This is the unreported judgment. They issued the notice, my lord, page. And till now, my account has been defreezed. I went to the bank to purchase another account, but they did not open the account.
The bank is not there. Let the bank come.
My lord, I have served the notice.
Petitioner has filed the affidavit of service, but none appears on behalf of the respondents. Full stop. The petition is directed to inform the next date of hearing to the respondents and to file affidavit of service. It is made clear that on the date fixed, if none appears on behalf of the respondent authorities, including the bank, appropriate order will pass. This is the matter on 14th of August 2026. Next. Yes.
Deep down.
Original site.
Next matter is item.
Which one?
120.
112.
112. Please see the last page of your.
So what can be done? Court go there. Though the matter is listed as item number 112, but the learned counsel for the but the matter could not be taken up for hearing due to paucity of time. Learned counsel for the petition has mentioned the matter and submit that the interim order is still today and prayed for extension of interim order. Learned counsel for the state. State submit that the senior is engaged in the other court. At the learned counsel for the respective parties, interim order is extended till 27th of August 27th of August 2026 or until further order whichever is let the matter remain in the list. Yes.
The next matter is 33. If it could be given some precedence, I don't want your lordship to take up today.
33 will become tomorrow.
Complete.
But under competing circumstances, regarding item number 10 of your lordship's list, my lord, what is when the matter is called on, my lord, due to poor connectivity of the internet, my lord, the learned counsel of the petitioner could not submit anything. And the learned advocate from the respondent railway authority took time and saying that we have not taken the charge because this is a matter involving the halt contractor, appointment of halt contractor of the tender. I got leave from your lordships and your lordship was fixed to fix the matter on today. Let the matter be taken up.
No, it is today. What has happened today?
Your lordship was please the matter fixed on 7th
yes,
August.
nobody's appeared. What can be done?
Well, they appeared.
They have asked for the time.
No,
Sir, it is my rule in the urgent motion. If you are taking the chance, you come and argue or you are welcome.
Hello.
If you are taking time after the urgent motion, then you have to wait further 1 month.
Took time, my lord.
What? No. Sorry, petitioner also took time. Sorry.
No.
One, this court is not adjourning. Both the parties have kindly see the record. Both the parties paid for adjournment.
I have seen, my lord. I have seen
Let's
that.
come on August. I will see to that.
My lord, what has happened on 18th, my lord? They have taken
Because
the
in
charge.
morning hours, you all persons have made me mad. And when I am making accommodate all the advocates in my urgent motion, when the matter is called, one or the other advocates is not appearing. That's why I have made the rule. If in urgent motion, if none of the advocates is appearing, go for the 1 month. After 1 month, the matter will be listed. That is my rule. That I am not allowing any persons.
This is urgency.
But might be your urgency could have been appeared before the court. Why you are not appeared? Yes. Call the audience.
Lordship, may I permit item number 48, Lordship? Tomorrow I have some personal difficulties. I have to appear before the board, surrogacy board. Kindly
SRPC board is much higher than this court, then you appear before SRPC board. Yes, SRPC board is much higher than this high court. You are going to appear. Yes, call the
Lordship, surrogacy board, Lordship, not SRPC board, Lordship. I have appeared before the surrogacy board, Lordship, for personal, Lordship, for my personal issue. Lordship, kindly, Lordship, day after tomorrow, Lordship. I am for respondent, Lordship. Other side is also present, Lordship. Applicant is also present.
Item number?
No.
It will come tomorrow. The item number 36. Though the matter is listed item number 36 in the days list, but the matter could not be taken up a hearing due to paucity of time. Accordingly, full stop. Land counsel for the petitioner mentioned the matter and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 27th of August 2026 or until further order. Let the matter remain in the list. Yes.
Lordship,
Come tomorrow. Can two is disposed.
Lordship, kindly, Lordship, allow.
Key.
Day after tomorrow. Only I am paying day after tomorrow. Nothing.
Hey.
48, Lordship.
48.
Petitioner is also.
Day after tomorrow.
Much of it.
Original side. Appellate side not over. What is the one sending?
My item number is 106. It was item number 32 only by one chance.
Just you heard one chance you missed, then you have to wait 30.
My lord, it ended just one serial before. I did not miss it, my lord. So I can be my lord, because
Item number?
item number 106.
Okay, let's see. Let me see.
Lordship, kindly.
106 का note कर लेना. Yes, call the list.
Mentioning. May I have your lordships kindly, my lord, item 10 in today's list. The reason I wouldn't have actually mentioned, my lord, it's an MSME writ challenging the declaration of NPA divide of the frameworks, lordship knows. My lord, tomorrow, my lord, there is a 100% chance the order will be passed. I have just been waiting my turn, my lord. If it can be taken up with some precedence tomorrow, it's item 10
It is
today.
10, more than 10, I cannot do anything. 10 is there.
I understand.
Take the chance if the fixed matter will not taken, then it will call. Yes, call the.
Tomorrow, if it can be.
I don't know, sir. What can be done?
I appear for the petitioner.
Yes.
My lord may recall, my lord, this was the surrogacy matter, which resulted in my daughter's death. My donor gametes were used instead of my gametes, even though I, had elected to choose mine. We had completed submissions.
Yes.
Mr. Kaur, appearing the respondent number 5, was in the midst of his submissions.
Correct.
My lord may.
Yes.
Lord, may I submit this, my lord? I can never stand in the way of Mr. Kaur asking time. Let the state respondents make their stand known in the meantime.
Let the one party complete, then the state will come.
They've been.
Land counsel appearing for the respondent number 5, praise for time. According case is adjourned. Let the matter appear. Give the date. 25th of August at 3 p.m.
Lord, may I make one, one indulgence? My lord, may kindly make it part heard. The only reason I say this, a re-hearing will be extremely traumatic for the parent.
See, this is the way.
Very well. I can only.
Court is accommodating all of you, but you persons are not accommodating the court. What can be done? One party has argued the matter, other party is not coming. So, yes.
Only indulgence I can crave.
Item number 4, code application.
Yes. Release from the list due to lack of determination. Who is for the petitioner? None appears on behalf of the petitioner. No accommodation is sought for WPA PO 837 of 2037 or 39 key number 37 of 2025 is dismissed for default. Interim order if any stand vacated. Next.
It is your lord.
My lord, page 124 of the writ petition is under challenge.
Which for the other side?
My lord, someone was appearing, my lord, they had produced an order. My lord, I indicate to your lordship. My lord, the first step taken by the SEBI in the facts of the present case was initially, my lord, in 2016. My lord,
But other side is not here. Then again the same problem.
No, I really have no answer. Well, the only thing is, what is the problem?
Pass over, let us come. See if anybody is coming. Next. None appears on behalf of the petition. No accommodation is sought for. WPA number 919 of 2025 dismissed for default. Interim order is vacated. Next. You are appearing for?
Number 2.
Yes. Who is for the petitioner? Authority of the view the same or only
for the respondent number
the
1.
authorities are directed not to pass any final order without giving an opportunity of hearing. Yes, order dated 9 July and 12 July. Are the so-called notice or the only a communication?
Lord, this is the communication, my lord.
Not the so-called notice.
Not a show cause notice, my lord. And one thing, my lord, I need to submit is that the lordship will consider whether it is at all maintainable before this honorable High Court.
I am dismissing it, no problem.
My lord.
None appears on behalf of the petition. No accommodation is sought for. So and so.
My lord, I appear for the petitioner, my lord. In item 7, my lord, it's raining extremely heavily, my lord. Would your lordship kindly pass it over for 5 minutes, my lord? I am stuck in the other building, my lord, for 5 minutes, my lord.
Pass over.
I'm grateful, my lord. I'm coming, my lord.
Next.
I beg to appear for the petitioner.
Yes.
But I need to serve the new advocate on record. They have sent us a mail. My lord, this matter pertains to, my lord, suspension and removal, subsequent removal of a marriage register. Now, my lord, what has happened? The marriage register has, in the meantime has died. Now, GA1 is a substitution application filed by his son because, my lord, the rule provides that if during the subsistence of service, if the person dies, then, my lord, right generates in favor of, my lord, his offsprings. Therefore, my lord, if we can substantiate that this removal is illegal.
Okay. Land counsel for the petitioner is directed to serve the copy of the writ application along with the document to the office of the government pleader.
Lord, advocate on record, my lord.
Case adjourned. Let the matter appear on 11th August 2020.
Your lordship, item number 4, your lordship.
Item 9. Who is appearing for 9?
I am for the petition, my lord.
Yes.
Lordship.
Yes, what is the matter?
Lordship, the matter relating to Lordship, I have submitted a deed for registration, Lordship. And that kept it pending for a long period of time. And after that, I came before the Honorable High Court. High Court directed them to consider my representation and dispose of the matter. And Lordship, after that, they have assessed the valuation as a very huge amount, which my humble submission, they cannot do this, Lordship, because they kept the pending and they have limited resource, Lordship. Lordship, kindly take up this matter any day, Lordship, because
after the prayer made by the counsel for the petition, the case adjourned. Let the matter appear on 20th August.
Much, Lordship.
Next. देख अर्जेंट था अब नहीं है कहाँ है
It is 11, my lord. Mine is 11.
None appears on behalf of the petition. No accommodation is sought for. WPA number WPO 11 of 2026 dismissed for default. Interim order is 10 vacated. Next.
I would not miss that opportunity, my lord, especially after mentioning before your lordship.
You mentioned the 10. Now you're coming in 11.
No, 11. I incorrectly said, my lord. But if I may tell your lordship the facts in a nutshell. I am an MSME company.
from State Bank of India, I obtained loans. Loans were under some pressure. Without informing me of any of the mandatory criteria under the RBI circular, I am declared NPA. I write to them time and again. This, my lord, the State Bank of India branch is the SME branch which grants the loan. The loan sanction letter itself says that you are an MSME and those benefits are provided. But when it comes to declaration of NPA, there is no communication. But I've served, my lord, the affidavit of service.
When the NPA was done?
Yes, my lord, it was done.
When your company was declared NPA?
I'll just tell your lordship, my lord. The 13-2 notice, my lord, your lordship will find page 156. NPA's declaration date is 29th December 2023.
29 December
2023.
Page?
I am communicated that, my lord. Page 165, if your lordship sees volume 2.
165.
165.
Yes.
This is, my lord, a letter dated 3rd April 2024, where for the first time they tell me that your account has become NPA at page 166, second paragraph. Unit was unable to repay such and such, which resulted in slippage 29th December 2023.
These are 2023.
This is 2023.
When you informed your bank, 24. You have
24, my lord.
Yes, April 24, it has been informed to you.
Yes.
So when
before
you,
that,
when you give the reply that you are in the MSME.
My lord, before that is the 13-2 notice. Kindly see their conduct. 21st March 2024 is the NPA date, page 156.
Correct.
13-2 notice, they are saying NPA is on 29th December.
Correct.
Such and such, you invite your objections. I write 13-3A. Kindly, my lord, takes my 13-3A, page 188. I'm sorry, my lord. It's 167, my lord. Right after that, 167.
167.
This is my 13-3A, 17th May 2024. This is a long letter of 21 pages. I'll take your lordship.
Reply to
13-2. Reply to the 13-2.
13-2.
Yes. My lord, I'll show your lordship 3 pages out of these 20 pages of the letter where I have specifically said that no SMA 0, SMA 1, SMA 2, nothing done. Kindly, my lord, takes the internal page 6 of that letter, which is page 172. May I place paragraph 18, my lord? Subsequent to the aforementioned events, the bank, despite being urged to facilitate us in regularizing the business and restoring the tea garden to a suitable and operational state following the unrest, declared the loan NPA on 29th December on grounds of purported irregularities. It is imperative to emphasize that I did not receive any prior reminders regarding regularization of the loan accounts before they were classified as SME and or designated as NPA as mandated by the Reserve Bank. This is instance 1. Now may I invite your lordship's attention to page 180, paragraph 40. And my lord, I am not for a moment saying, pausing here for a moment, I am not for a moment saying that I am not going to take any steps. You have to start from scratch. My lord, the 2015 circular read with the 2016 circular and the judgments your lordship knows of Pronitz and Shisai, they are considering the 2015 circular. My case, my lord, as I have attempted to make out before your lordship, is on the 2016 circular revised, which limits from 10 lakhs to 25 crores. I fall in that category, admittedly. There is no dispute. Not para 40. I affirm that in the course of categorization of the loan accounts as non-performing assets, the bank disregarded the directives established by the Reserve Bank, ostensibly designed for the mutual benefit of the bank and customers' interests. I am dedicated to ensuring that your authoritative and domineering conduct does not escape appropriate consequences. Last paragraph, paragraph 50, page 182. We've been long-standing customers. This has never happened before. It is noteworthy that prior to the alleged declaration, I have not received a comprehensive statement of accounts from your esteemed office. Throughout this duration, I have left uninformed and lacking clarity, a situation which has persisted regretfully. Furthermore, your performance in discharging duties has notably failed to adhere to the standards outlined by the Reserve Bank. Now, my lord, kindly takes the reply. Kindly takes the reply at 188. Those three paragraphs I will show how the bank has dealt with it. That was paragraph 18, 40 and 50. This is, my lord, 27. Lordship has page 188.
Yes.
27th May 2024.
Yes.
Reply of representation dated 17th/5, which is my 13th/3.
Yes.
Now kindly see, my lord. Kindly comes to para 13 at 189. The first paragraph that I had shown your lordship was para 18. The way they've dealt with para 18, bank has given you reminder notice for regularization. That is a demand notice.
Where from you're reading?
I'm sorry, my lord. Paragraph 13 at page 189. The way they deal with my 13(3)(a, it is a clear admission that I will not follow RBI circular. Bank has given you reminder notice. You have failed to regularize that account.
Correct. So
This is not, my lord, at this stage, my lord, after 13(2), 13(3)(a, we are not at the demand stage. My lord, I am an...
No, demand stage. They are telling that the bank has given reminder notice to you time to time for regularization of the account. But
My
you've
lord,
not done so.
The reason I'm harping on this paragraph is, para 18, what did I raise? Please follow the RBI circular. I am entitled for the...
What the RBI circular says.
RBI circular says for the borrower, it is voluntary.
Correct.
For the bank, it is mandatory.
But the bank has informed you, you're not coming forward, you're not giving what the bank will do.
My lord, now may I tell you, lordship?
Government take all the documents from you.
No, that is not the case I have made out.
That is the case made out in the paragraph 13, which you're telling this is against you, sir.
Well, it is definitely against me, my lord. Lordship will not kindly take me amiss. I am just trying to place this paragraph to say that their objective, my lord, is rightly recovery. Surfacey, proceeding going on. Now the issue is, am I not entitled to SMA 012? Because for my lord...
Why? That's I'm telling. Okay, the bank has issued the notice to you. Your case is that only under notice under section 13(2), the bank has informed you that in the month of December 2023, your account has become NPA. This is your case.
Great.
And you have made several allegations several averments in your reply. In the reply, they have given the reply to you. In the reply, they are telling that no, sir, bank has issued reminder to you time to time. If the bank has issued reminder to you time to time with regard to the NPA, so what is the fault of the bank now?
Twofold submission on this. One is it does not rid them of their obligations and mandatory directions in terms of the framework.
Mandatory direction, tell me.
For an account, as per the 2016 directions framework, for an account which is SMA 012, within 5 working days, they have to submit a corrective action plan. It is mandatory. May I place that circular, my lord? My lord, kindly takes 17th March 2016 at volume 1, my lord. Volume 1 at 110.
Page?
Page 110. First paragraph, if I may, 2 or 3 pages I'll place, my lord, in bits.
110.
Page 110.
Yes.
2015. The reason I'm placing this circular is, my lord, the previous judgments are only on the basis of the 2015 circular. My case is made here, and if I may be bold enough to submit, my lord, slightly better. My lord, 4th line from the right. However, it talks about the 2015 circular. However, certain changes in the captioned framework have been carried out in consultation with the Government of India, Ministry of MSME. My lord, page 110.
Certain correction, yes. Then?
So the 2015 circular needed some more focus, which is brought about by the 2016 circular. More clearly mentioned, my lord, in the next paragraph, in terms of the prudential norms, 4th line, the revival and rehabilitation of MSMEs having loan limits up to 25 crores has to be this circular. That is what it says in para 3, 4 and 5. Now, my lord, most important, what I'm relying on, page 112, if your lordship kindly has.
112. Yes.
Till point 2.1 is the same as the 2015 circular. The difference is next, right after the heading before 2.2. On the basis of the above early warning signals, the branch maintaining the account should consider forwarding the stressed account with aggregate loan limits up to 10 lakhs as referred in para 3.3 within 5 working days for a suitable corrective action plan. Same, different. Forwarding the account to the committee for corrective action plan will be mandatory in cases reported.
You have not read the judgment of mine.
Yes, my lord.
Then you have to give an affidavit. You have
For
to
the
give an
corrective-
affidavit. You give all the things record, then it will be submitted.
My lord, that is
It is
2015.
not, Pranit, you have not read.
Pranit's-
Not only the
Pranit's-
bank, it is only also the borrower.
My lord, if I may say on this point, I have lost also before your lordship
Then-
says, but this is slightly, my lord, different.
Not different,
2015,
nothing. Just recently I passed the judgment.
in my case, my lord, also in the month of March, I believe there was a judgment, my lord. But the other thing is here, the forwarding of the forwarding of the account to be referred. This is the bank's obligation. My lord, may I only submit?
That's correct. I am not denying that. But you are also sleeping. You have not submitted within the format. How the bank, if the bank will done, so
This is, my lord, I haven't, my lord, may I have my lordship's leave?
May I just try to show, my lord, why this affidavit may not be required? Lordship kindly takes a look at the 15th circular. The 15th circular has this requirement. Lordship kindly sees page 98, 98, it starts at 104, 104. 104. This is applicable to concerns having debt of 25 to 50 crores, 25 crores and plus. Kindly see 104.
yes.
104 lordship possibly referred to paragraph 1, subparagraph 2, 3 and 4.
Correct.
Identification by the enterprise.
Correct.
Paragraph 1, 2.
Yes.
Any micro, small, medium or any voluntary may voluntarily initiate proceedings under this framework if enterprise reasonably apprehends failure of its business or its inability or inability to pay its debts. Now, 3. The application for affidavit of the proceeding for initiation of proceedings under this framework shall be verified by an affidavit of authorized person.
Correct.
When such a request is received by lender, the account shall be processed as SMA 0 and the committee under the framework would be formed immediately.
Correct.
So affidavit is required. This is the 2015 guideline.
Correct.
But she kindly comes to the 16 guideline at page 110. At page 110, paragraph 2. Paragraph 2. By this it says 15th circular is confined to 25 crores and above. Paragraph 2. While the prudential norms on income recognition, asset classification, and provisioning pertaining to advances will continue to be as per the instructions consolidated in the master circular on IRAC dated 1st July 2025 and as updated from time to time, the revival and rehabilitation of MSMEs having loan limits up to 25 crores will be in terms of these operating instructions.
Yes.
And now this does not happen. Kindly comes to paragraph page 112. This affidavit submission is not there in 112. Or paragraph 2.1.
Yes.
Before a loan account of 2.1, because that is somewhat akin to 1. Paragraph 1 of the 2015 circular. Before a loan account of a micro MSME turns into a non-performing asset, banks or creditors should identify incipient stress in the account by creating 3 subcategories. On the basis of the above early warning signals, the branch maintaining the account should consider forwarding the stressed accounts with aggregate limits of above 10 crores, above 10 lakhs to 10 to 25 lakhs to the committee as referred to in paragraph 3.3. So no need for an affidavit. Now apropos this, kindly see
paragraph 4.1 first, my lord. So with whether affidavit, that is if my loan was above 50 crores. 4.1, page 114.
Yes.
Any lender
Yes.
on identifying an MSME account as SMA2 or suitable for consideration under the framework or on receipt of an application. So it could be either on receipt of an application or if lender on identifying its shall forward the cases having aggregate loan limits above 10 lakhs. So if it is SMA2, then lender is under an obligation, mandatory obligation. Apart from SMA2, other cases, when the borrower makes an application. So 4.1, the first sentence has two parts. Any lender on identifying an MSME as a SMA2 or suitable for consideration under the framework. Then I jump the next phrase, shall forward the cases having aggregate loan limits above 10 lakhs to the committee. So that is borrower's obligation. Or the other part is on receiving an application. So and unlike the 2015 circular, an MSME committee is always there.
The another judgment you have gone through, the latest Supreme Court judgment.
Samarth. Swami Samarth, Lordship kindly sees Swami Samarth's case. That is the 15 case. Well, may I just... Yes, Swami Samarth's case. Yes. Now I can. Swami Samarth's case. Yes, Lordship kindly sees the very first, very paragraph 2. Paragraph 2 of this judgment.
Yes.
The petitioning enterprise had executed a loan agreement with NKGSB but had failed to pay so and so. Next sentence. The authorized officer of respondent number 2 issued a demand notice the 13th March May 24 under section 13(2) of the Surface Act, calling upon the petitioner to pay so and so. It does not appear that from the petition filed on 14 July that the petitioning enterprise objected to classification of its account as NPA as well as issuance of the demand notice on the ground that the action of respondent number 2 was in violation of notification dated 29th May 2015. 29th May 2015 is the 50 crore, 25 crore and plus. So this was the Supreme Court was considering 29th May 2015 circular. And there Lordship sees paragraph 5 now. Paragraph 5 of this judgment, the notification detailing the framework, more particularly paragraph 1 and its subparagraph, have to be read together to make its terms effective and meaningful. Although in the sequence of the framework, identification by banks or creditors comes first, it is immediately followed by identification by enterprise in terms of subparagraph 2, any so and so. Last 4 lines of this paragraph. Paragraph 5, last 4 lines of this page. For initiation of proceedings under the framework, 2015, the application has to be verified by an affidavit of an authorized person and upon receipt of a request, the lending bank. So that is 2015 paragraph 1.
Correct.
Now we are on the 20 because my loan is much less than 25 crores.
But so you have to also to inform to the bank.
That is with the knowledge of the bank.
No,
that
you
is
have
the
to inform the bank.
Lordship, that is.
If you're not informed the bank, how the bank has. That's why I'm telling the bank has already stated that time and again he requested you. You could have been informed the way, see, sir, you cannot proceed. Where is your reply that you cannot proceed and you go with the 2016 notification?
That may not be there, but Lordship kindly sees page 53. Their sanction letter knows that this is MSME.
That is not issued.
That is a MSME concern, they know.
But Mr. Mitra, once the notice has been issued, so
under 13(2).
13(2).
That is post NPA.
Correct.
Post NPA. But this guideline requires 2016
Correct, but
before NPA,
once
SMA.
it was informed to you. Okay, leave aside the affidavit is not required, but once it has been informed to you with regard to your account NPA, so you know that once the account is NPA, then the bank will take appropriate steps. So you have to inform the bank, sir. Sorry, you have to follow this 2016 guidelines. This is this. So I may be given my case may be sent to the committee for consideration in terms of the guidelines. Where is that request to the bank?
Well, page 172 is the reply where we said that maybe
You have said so many things.
not in so many words, MSME. That is no, I can see. I cannot so many words, but
That's
it's
why I'm asking you.
not so
You have
many
said
words.
so many things, but that
No,
what
what
is to be said that you're not said.
no, that is not there. That is not there. My junior place, but the fact is that it is a bank's obligation, absolute obligation, anyways. When it's an MSME account.
That's correct.
So, Lordship also sees Pronit's judgment in that case. The Pronit's judgment.
The Pronit had given the both.
Both.
It is the duty of the petitioner, the borrower, and the bank.
And the bank. So that's
it cannot be said that the bank is only responsible.
But there also, Lordship will see that was also possibly a case of 2015 circular.
That's correct. That's
15 circular. Even then, it was said that it is.
That's 15 circular. There's no dispute on that.
But even then, the Supreme Court said that it is the obligation of the bank. That is the paragraph. What paragraph? Paragraph. Can you give me 1 minute? Or should kindly come to paragraph 17. Even paragraph 17, while considering the 2015 notification.
That's correct. That it is not that is 16, 15 also.
So, and, yes, paragraph 15 also. And paragraph 18 says very clearly, we may hasten to add that under the framework,
bank or creditor are required to identify.
Because under 15 guideline, it's a must. But Lordship's my lord's judgment in Duas, which was then modified by the after final hearing and made conditional. Division bench then sends it back by saying, do not look at the subsequent judgment, but go to the DRT. On that basis, my client is still Lordship sees DRT judgment in the division bench judgment from the doer's final order. Lordship kindly notes this. So my lord's order was restored. My lord's order was restored. Lordship, because the 17 was already pending. Paragraph page 2. And I've got my lord's judgments. Page 2, the third paragraph.
Since the appellant seeking withdrawal of the appeal as
Next paragraph. Yes, withdraw the appeal as also suit and could, because in the meantime, now next paragraph. It is clarified that the parties are at liberty to raise their respective contention for the DRT will not be influenced by any of the observations made by the learned trial judge in the impugned judgment. In the impugned judgment, my lord's order was modified. So it was said that without being influenced by the impugned judgment. So my lord's order was fully restored. My lord's order is very much there. Well, we can give a copy of my lord's order. We don't. So the obligation, if my lord is absolutely right, I don't want to join issue on that. It was not said in so many words. But my lord's judgment in the doer's case, internal page 13 of the judgment. Present case, admittedly, the plaintiff is under the MSA. Here our sanction letter says so. And the guidelines are squarely applicable to the plaintiff. The defendant says it is the time of grant of credit facility. The plaintiff was not under the MSME. Subsequently, the plaintiff has been registered under MSME. In our case, it was given from day one. Now, last paragraph. As per the case of PRONITS, the Honorable Supreme Court has held that the central government by notification 29th May in the exercise of its power under section 9 as revised by the of 16 and the master direction so and so issued by the RBI so and so has statutory force and binding to all scheduled commercial banks. So they can't say because you reply to 13.2 you did not say you are an MSME and take recourse to that possibly.
Yes.
So after considering that, Lordship.
Yes.
And that is the order remaining. My lord, so what stage is it?
Where is the notice? My lord? Where is the notice under 13?
13.2, my lord.
Yes.
156, volume 2.
156. So now what is the stage now?
What stage is it? We have taken possession. They have not yet taken possession, my lord. They have not yet taken possession of the assets, so that is.
Why you have come late?
There also, I really do not have a complete answer, but the Doer's case of a statutory obligation, possession not yet taken. That's all I can say. There is.
So what is the prayer?
Well, the prayer. Setting aside the NPA declaration, possibly they may want to file affidavit. This page 20.
Yes, yes.
I'm taking the point of mentioning of because, my lord, 13.2 notice, they are challenging 13.2 notice as well as 13.4 notice.
We have not challenged that. Have we challenged?
The declaration, the account as a NPA.
No, we have not challenged 13.2.
That means they are challenging 13.2 notice. So whether, my lord, the REIT court has the power after issuance of 13.4 notice, and more so, they have also filed a surface application before the DRT. So that is still pending. So now whether your lordship will enter into this writ petition because the surface application is pending, they have challenged that 13.2, 13.4, everything is pending. Now we have issued 13.4 notice, my lord, we have yet to take the position. So that is the whole today as on date.
But if it is a MSME, okay, whatever it you initiated the proceeding, how you can go by the circular of the Reserve Bank of India of 2015 and 2016? If it is a MSME?
Yes, we can issue 13.2 notice.
Notice.
Lordship, the surface act is applicable to that also.
But ignoring the provisions.
No, we have given repeated opportunities. We had.
That's a show when you have given the repeated opportunity.
Lordship, kindly gives you a moment, my lord. If your lordship takes page 76. Lord, this 76 page, my lord, your lordship takes, this is his letter. In furtherance to a previous mail dated such and such, we note that excess interest to the tune of rupees has been charged to our account. Such as high interest on the industry with stress is pushing the unit further into closure and downgrading the asset. Hence, we request you to kindly look into the matter, arrange for immediate refund of the excess interest charged over the above interest at 10% point. Now, my lord, thereafter we had replied to this. Lord, will it be my lord's pleasure to take it up tomorrow, my lord? Actually, my brief has not come. Lord, there was some.
Tomorrow is date fixed.
No, nothing has been fixed. Nothing has been fixed. No, they are challenged.
Tomorrow is the date fixed.
No, that is not correct, my lord.
For the DRT.
No, DRT, they have challenged. They are filing the surface application.
You have filed the surface.
Yes. We have not taken any.
So,
kindly, my lord,
take these points.
Very well. Kindly pass it over once, my lord.
Very well. Let it be tomorrow, my lord. I will take an adjournment by lordship records that there is that the hearing is going on.
Learned counsel for the petition argued the matter at length. Argued the matter. Police counsel for the respondent bank prays for time. It is adjourned. Let the matter appear tomorrow.
Will your lordship record that I shall be making a prayer before DRT for the adjournment? prayer গুলো oppose করবো।
আমাদের oppose করতে হবে। আমাদের oppose করতে হবে। Get through it.
If your lordship calls the specially fixed matter, if your lordship calls the specially fixed matter, we have a humble prayer. I had item number 4.
Item number
4.
But
we could not reach because people kindly reconsider that for today.
Now I have to take some strict orders because now I find from the bar they are taking it granted to this court, mentioning the matter in the morning hours, losing my tempering for the half an hour. When the court is taking the matter in the list, the advocates are not appearing. That's why I decided if nobody is appearing in the appellate side, I will take after 2 months or 3 months. In the original side, I will dismiss.
But what happened was,
maybe there, here. You know, the list has been published 24 hours. This is of 48 hours before. You could have been making
completely by mistake.
We were ready, my lord. Just
come. An application. Yes, call the list. Yes. Where is Asika? Asika is there. You are not there.
Blood of the last occasion.
I am there online today, my lord.
Last occasion, if whatever the substance, summon substance of what I submitted in the lordship, we have made that offer. Otherwise, that we are not standing in the way. If my lord SEBI is my lord called upon and they will not express no problem, we are not standing in the way. In your lordship, one line, your lordship records after hearing the
Yes.
day for today, that will be the lord.
Yes, Mr. Ray.
বলছিলাম yes. On the last occasion, my lord, I had taken the point, my lord, first of that the arbitration clause not being there, my lord. As a matter of fact, I refer to a judgment of this court only, my lord, which is held on these grounds, my lord, that if the arbitration, that's the sine qua non, the first point in a section 9. If you can't produce that, then, my lord, no orders can be passed. Now, next, my lord, sorry, my lord.
That you argued that.
I've argued. No, I'm just starting off from it. I'm not repeating, my lord. Well, the next point which I had taken was the pleadings in the section 9 application, my lord. Pleadings in the section 9 application, but I'd also shown, my lord, paragraphs which refer to, my lord, primarily, my lord, saying that the share prices have gone down. Well, that is something which I said that has not been particularized in the manner as required under Order 38 Rule 5, or for that matter, my lord, it is affirmed true as a submission. And, my lord, this point has already been dealt with by, my lord, our client, my lord, in its opposition, my lord, where we have shown that the price of the shares, my lord, as on date, my lord, remains same or else or my lord, a bit more than what it is. So, my lord, today, my lord, while this was being done, my lord, while that order had been passed, my lord, and I was also trying to pursue that Ashika sells it off, my lord. My learned friends filed another application. I'll first place their application, then I'll go to my defense, my lord. But your lordship will kindly take up AP 857 of 2024. My lord first kindly takes the sorry.
Yes.
My lord first kindly takes the prayers at page, my lord, 316. Well, this was primarily, my dear lordship will find, this was vis-a-vis another company.
300?
My lord, 16, my lord, only 16.
316.
No, my lord, no 3. Only 16, my lord. I'm showing the prayer.
Yes.
But here, my lord, they file a application, my lord. This one is for Hiranmoy, my lord. The shares of Hiranmoy. What do they say here, my lord? Kindly sees, my lord. My lord, this is where I was joining issue also, my lord, with my learned friend on the next occasion. My lord, kindly comes.
What is the stage of the arbitration now?
My lord, there also a section 17 has been filed. And my lord, we have filed a section 16. Obviously, my lord, now since that.
My learned friends are taking the point of section 16 before your lordship and before the arbitrator.
No,
also.
I cannot take the point of section 16 before
Exactly,
your
but otherwise, my lord, my learned friend is arguing that there is no arbitration.
I'll point out, Mr. Shah, we have learned a lot from you. In an injunction application, I have to first show that there is no prima facie case. And when I can show that there is no application, I'm sure you would be the first one to jump up and say there is no prima facie case. So I've learned all these things from you Mr. Shah, please.
Okay.
And my point of jurisdiction, obviously, I have to take there. And I've taken it as a point of jurisdiction. As a matter of fact, that is going to be heard, I think, at the end of this month. Oh no, 10th of August. So it will be heard on 10th of August. Section 16 will be heard first. And then, section 17, more or less the same prayer, again asking for a security there. So, that was also a consideration before your lordship. But I said that I will first take these points and then I'll show your lordship that whether your lordship will take it up. But because it's a judgment of, I think, the same judge who's the arbitrator, but she had held while in the Supreme Court that if the matter is there and has been considered at length, then your lordship can continue. But it's a discretion. I came before lordship and said that the same prayers. Now the arbitrator is sitting. It's not that the arbitrator is not sitting. Therefore, I said your lordship will kindly consider. But then Mr. Shah wanted to do it on the merits. I came on merits.
Okay.
But obviously, I think this will be subject to the result of the section 16. Has to be. If the section 16 goes, then this will also have to. But if I'm successful in the section 16, this will go. Because that's again, that's the initiation of the entire proceeding. So, now kindly sees, kindly comes straight away, page para 5, page 5, para 8. Para 7 onwards. And kindly see, in the meantime, by a BTA, 16th August, entered into between the said SIFL and petitioner, the lending business SIFL to transfer to the petitioner, resulting in the petitioner being considered the lender for the entire loan facility of Power Trust, together with all underlying promises, securities and undertakings standing in favor of the said SIFL. Although the trustee of the said Power Trust failed to create pledge of the shares as promised. Now, kindly see, they say there is no pledge of the shares. Now, these shares have already been, injuncted by your lordship. They subsequently executed in favor of the petitioner hearing a deed of hypothecation and deed of undertaking. This was in a hypothecation charge. Kindly comes to 9. Payments were made. Then, straight on. Para 10. Here they say that we were directed to sell. May I just pause here for a moment? Direction to sell is something which they are trying to derive from the order, from the agreement itself, which is not as an interim prayer. There is no award as on date.
Correct.
So, the direction to sell was an attempt by both the parties, and that's why at the very beginning, we said that if it can be sold, let it be sold, and then that money can be kept aside. It's not as if they're going to get the money. So today, they already have a security in the form of an injunction.
Correct.
So another prayer, which they have made in another application, they now sell it, make a receiver, appoint another receiver. These are not, that's why submission, legal submission, not in aid as of an interim order. Unless today there is a liquidated finding that yes, this is the amount, then they cannot ask me to sell it. If they're secured, they're secured.
Correct.
So that's the injunction they've already got. Now, in
this 857.
91. Oh, I'm on the 91. Okay,
no, not required to take this 91. There is an injunction for selling of the share through the special officer. Correct.
No, injunction on the shares and the direction that
Correct.
if you can
Injunction on
two,
the share.
both of them are there.
Injunction on share and special officer
To sell.
to sell. But nothing was happened. But
Cannot be
injunction
sold. There for some
there.
reason it cannot be sold. Though
Whatever it
Mr. Shah is attributing it to me, I don't know.
Correct. Now, then second, 857.
Yes.
Now 857 to sell and deposit.
No, well, 857 is for Hiranmoy.
Hiranmoy, that's why.
No, first one was not for Hiranmoy.
Okay. Yes.
First one was for Konta share. First one. Well, just give me a moment. Well, the first one
is the power trust.
Power trust.
Is the power trust.
Power trust.
And here is
Indian Power Corporation Limited. No, sorry, Malad. Power trust is the respondent. It's the IPCL shares. Now, why I'm on this, Malad? This is made at a time when, Malad, there was an injunction on the IPCL shares. And nothing had been showed at that point of time, which showed that the price has gone down. Your Lordship will kindly see here the pleading. Malad, straight away comes to Malad, para 15 onwards.
Para 28.
28 is also 15. I wanted to show. Malad, there is so much of dispute today. Malad, kindly does not take my MS here. But Malad, the question whether I am a trustee or not. Malad, this fell before your Lordship at the instance of my learned friends, the petitioners. Now, Malad, they have sued me as the trustee. And they agree that I am the trustee. Now, after your Lordship has held that I may not be the trustee, Malad, kindly sees my names are still there. Malad, today they have identified me as the trustee. If I was identified, Malad, Ashika, Malad, that couldn't have been the case. Then they came and said, no, they are not the trustees. Ashika is right. But
no,
Malad kindly appreciates.
With regard
But
to
who are they suing? I want to know that first. Is it Ashika? Is it me as the trustees here? Or now the trustees have changed? Then they should make that earlier trustee another party. Malad, it's all going because the problem is, Malad, today, Malad, they are only. Sorry, Malad was trying to say something. I'm sorry.
No.
Malad, whatever is happening today, Malad, there is a third party who has been involved. Now, this issue, Malad, since I'm in the final hearing, that's why I'm opening up everything. Yes. Because as a matter of fact, the appeal court also said, please go and take it up full with the learned single judge. That's why I'm before your Lordship. I'm taking these points. But now Ashika's point is there in a separate suit altogether, which I had filed against them. Now there, Malad, these points would be germane, but they come up here and then they say that this is the point, they are not the trustees, they do not fulfill whatever they want to say.
No, they are not telling they are not the trustee. They are telling that
it was not
to prove that the trustee with regard to the documentation is not proper.
That is the problem, Malad. I have provided the documents.
That the document as per the procedure, it is not conformity with the law, so that it cannot be treated as the trustee.
Malad, what I wanted to say was, Malad, conformity of the law, Malad, again, I'm going to another suit itself. Because, Malad, this is not the first place where they have been directed to sell the shares. It was in the suit that such orders were passed. Now, Malad, we have to understand one very simple thing, Malad. This proceeding, Malad, section 9, is only limited to what they can get from me. Now, the question of sale or not sale, Malad, that's why I'm targeting that itself. That whether it is in the interim or it's something final. Then, Malad, that would have been decided whether I can get it sold or not. If not, Malad, it doesn't really matter. What Ashika is saying, with humility, I say. If your Lordships are sitting in an execution of an award, Malad, your Lordship will direct whether SEBI likes it or not. That is good enough.
So, what is the prayer in the arbitration claim? Claim filed? No.
Yes, they filed the
statement. What is the claim in the arbitration?
That entire amount? 660. The total? 663 crores. Now I think it's gone up to 1200 crores, I think. But being a financer is an art. May I just say, but I just got a moment. But I have a car which is running on a loan. So I am supposed.
You are having car on loan?
Always. But I always take cars on loan. But I've got 2 or 3 installments pending. So I gave them a letter that I want to foreclose. So they told me that amount left is, I think, around 2,05,000. And then they tell me, because you are foreclosing, 15,000 extra. But so I don't understand. I am foreclosing. I give the total interest, and then you cannot pay
15,000 extra.
So I don't understand the finances. They have a separate calculation altogether. So whatever it is, yes, they have paid for the entire thing. But Ashika is not a party there.
No,
And
Ashika is been made party here because of the selling of the
I
stock.
understand.
Not
Arre,
with regard
token
to,
those দিচ্ছি না, তুই থাম।
not with regard to any claim against the Ashika.
Now,
Ashika has come with regard to.
May I just say this? What is the effect of your lordship's imprimatur? Your lordship has held that I am not the trustee. Now in the arbitration, I am the trustee. So that is why I said that this prayer should not be adjudicated before your lordship. This becomes a finality. Your lordship is only to see whether they are secured or not. First, in the section 9, they have stood secured. Your lordship, the application was in the nature of an execution. But execution with humility, I say, execution of order. That is what I am on, whether that can be done. And next one, I'm showing the second application of Hiranmoy. Why? What for? Why second security? I'm asking myself this question. Now, what they will say, they were harping on that last day, which is, I don't think is on record, that IPCL, I think, has gone into CIR. I don't know what is the effect of IPCL going into CIB, what is happening there. But again, now they are going to say that the IPCL and Hiranmoy are both in IPCL. Sorry, in CIRP.
CIRP.
If it's in CIRP, but what will the effect then? I'm being very candid,
Then you will be the king.
But I am also out.
You will be the king till that. All out.
So, that is why I am submitting. These points are something which are to be decided at the finality. Today, your lordship will find whether there is insecurity. On the face of it, the shares are there. Your lordship has a second consideration. Hiranmoy also, your lordship has injunction. Now, what is the other prayer they are wanting at this stage?
Now the amount.
That becomes a finality.
The step by step they go.
I would prefer to come before your lordship and deal it as a suit. I don't have a problem, I don't have a problem.
Okay.
It's their choice. But that's why I'm trying to show. Kindly see the application now, 857. Now, kindly see para 25. They say, petitioner come to learn that the said power trust is the owner of 74% shares of Hiranmoy. Also in London, the said trust is holding 19.6 fully convertible Hiranmoy Energy shares. In this kind of notice that the said Hiranmoy Energies had defaulted in repayment to its lenders, rural electrification, for the said lenders initiated proceeding under Section 7. Has 26, respondent has proposed to settle with the lenders of Hiranmoy Energy. This obviously they stopped by other ways that was stopped. I don't have to go there. But it kindly comes to 28. It is thus evident that while the petitioners' dues continue to remain unpaid, the security of the petitioner are in jeopardy. The shares of IPCL do not show any immediate realizable value despite best efforts. Where are they getting this from?
That is the main case they have made out. That
No.
is the case they have made out.
Where is the case made out?
Correct.
Once they say this, again, once they say this, they have to give some particulars. I will show I've given the particulars in my opposition.
Yes.
Should have called the Then kindly sees, as will appear from the loan agreement of 15 January 2018 executed for the loan granted to said power trust, the petition has a charge on all movable assets of the trust. This is contrary if a lordship finds. There was no pledge on the shares, they have themselves pleaded. Where are they getting this from? They have not shown this to your lordship. On all movable assets of the trust, even otherwise. Now see, even otherwise, The given facts and circumstances of the present case, it is essential that necessary interim order of the past in respect of the assets of the respondent trust. But they are aware that there is no such charge. And then they say that therefore interim orders are passed in respect of the assets which are presently in the process of being diluted, the petitioner's prejudice and detriment, entitled to security for its outstanding dues which are not in dispute. Now kindly see Malat para 31 just in the middle, Malat. Stuff here, isn't it? Malat, just in the middle, as the shares held, Malat, if your lordship gets
Yes,
it,
yes, got it.
said trust in Indian power have apparently no realizable value and have not been sold despite orders of this honorable court. Petitioner is entitled to secure its claim against the said trust, and the respondent by restraining the response on dealing with or disposing of the HCL shares presently in the process of being diluted to repay the indebtedness of the said hereon. As the petitioner is entitled to security for its unpaid dues in the absence of any other realizable asset, entitled to prevent the dilution of HCL shares. Now your lordship has passed an order on this. Now, Malat, they will say.
See, you have not challenged the order passed by the Justice
Yes, yes,
Bhattacharya.
Malat. I had. Then, Malat, that order was received that all points are kept open by Justice Madhuresh Prasad. My advocate record is today, I think,
Yes, yes.
not
Justice
here, Malat.
Bhattacharya.
I was just trying.
No, that, not that, my order.
Your lordship,
My
sir.
order. Justice Bhattacharya order.
No, that you have not challenged.
Correct. So if the
Malat, that we did not. Sorry.
no, if the Justice Bhattacharya order is not challenged,
Malat.
in that injunction and sale.
Yes.
Injunction and sale. So what would be effect of this or that order? That's why on the basis of that order. So because when it went for the sale of the share,
Malat.
when the matter went for the sale of the share, so the dispute arose with regard to the trusteeship.
Malat, yes.
Correct. Ashika has come, so the Ashika has been given an opportunity to sell, but Ashika has called for the record for the trust, and trustee should be declared as a trust, whether they are the proper persons of the trust or not. To so, but you have not produced the document. As per,
whatever I could, I produced.
As per the case of the Ashika. So if that order has not been complied with,
Malat, complied with maybe a bit harsh on me, Malat, because I have sought to comply.
not you. If it has not been complied with selling of the share,
Malat,
I am not telling you.
That is the interim order which my learned friend had got.
Correct. The interim order which he got, securing of the shares
That
and
is the-
selling of the shares.
Yes, Malat.
Correct.
That's the interim, Malat.
That is the interim. And that
I'm here before your lordship in the final, so I'm taking that point now.
that's why the sale has not completed
No.
because of whatever it may be.
Whatever reasons.
Now they, in the meantime, they find that it is not been sold out, and there is now the Hirma has come in picture.
Yes.
Correct.
But again, I say, Malat, my injunction on IPCL shares still remain.
That I am coming. So that share is still remain either there or here, whichever it may be. So
what shares are being held?
No share.
IPCL as well as Hiranmay.
Correct. Hiranmay.
Both
shares are
both
there.
shares being now injuncted.
Correct. Injuncted.
That is what I want.
So both share has been injuncted.
To what value?
What value?
Malat, a person may be injuncted, but Malat, double injunction, as in a double security. Malat, I cannot be penalized if the sales has not gone through.
So if suppose today the order is confirmed for selling of the Hirma share, what would be effect of the earlier order?
Malat, if the order has not been complied, whatever your lordship will pass, that will become the final order. And or else, Malat, obviously the interim order will get merged into the final order. And that is why, Malat, the division bench said, I'll take all.
If suppose this court will pass an order. Yes, Mr. Shah is also there.
Yes, yes.
If this court pass an order in both, confirming that.
Confirming the order.
What would be effect of the arbitration?
The arbitration will, the section 17, I think, we will then go and say that there's already been an order.
Leave aside section 17. What would be the main claim? What would be the main effect of the main claim of the arbitration?
Malat, here your lordship will pass an order securing, but Malat, ultimately whether I'm entitled to the money or not, that will have to be decided in arbitration.
And who has Malat, quantified this amount? Why I say, Malat, this was a Supreme Court judgment order, Malat, in this matter itself. Well, that is where I was a bit, my advocate record is not here. What has happened, my lord, they have filed a special leave petition, my lord. There was a special leave petition in respect of Hiran Mohiman, where my lord IPCL was seeking to put in money. Now, my lord, what they did, they filed an application before the Supreme Court saying that whatever money has been deposited in the Supreme Court, you secure it and give it to me, as in my learned friend's client. My lord, that has been set aside by that has been rejected by the Supreme Court, saying that this needs to be first quantified in the arbitration. Then
So
only.
what has happened to that amount?
That has been given back to the parties.
Parties.
Malad, there we had taken a point. I must give the entire picture. That money I had bought, IPCL had bought from other sources. So that money has been directly to be given back to the sources. Okay. But there also there is a finding that first quantify crystallization has not happened as yet. But I will be referring to that judgment. Malad.
Continue. How much time will take?
Well, I'll take.
This matter is a very short matter, my learned friend.
That's what I'm telling. That's why I wanted to cut short. That's why. So make it
half an hour. Well, then can I come back next day and do a half an hour, because then I can show because
I can finish on the same day. I can take 15 minutes and finish it. Then your lordship. Unnecessarily, we are troubling your lordship with this matter.
Complete it, whatever it may be. What is the law point? See, facts, there is no requirement further. Now you come.
Not on it, Malad.
No, come to
but what I am on, Malad, are two simple things, Malad. What is the scope of this application?
Correct.
Is it interim in nature or is it not interim in nature? First.
Naturally interim.
But no, the application is not interim in nature.
Okay.
That is what I'm
okay. If the order is passed, whether it should be okay. Yes. Got it.
So, Malad, is beyond the scope. One. And second, Malad, I've taken the first point that there is no arbitration clause. So that is.
If it is not the arbitration clause, how you proceeding with the arbitration also?
I'm not. That's why section 16.
16 you file on this ground.
Yes.
No agreement.
No, absolutely. But they've not been able to show. I've shown your lordship the agreement, Malad, before your lordship. What they gave as a redacted agreement, Malad. There is not a single whisper. They should first overcome that, and then I should make submissions. They have not made any submissions. First they stopped. They said we are not going to give it. Then the tribunal they should.
Arbitrator appointment under section 70 and 11.
11. Keeping all questions open. Malad, that is my major point, Malad. Because SFIL has no arbitration clause with it. I've showed a judgment, Malad, also to your lordship, Malad. Then whether they can even be considered as a veritable party. They are not a veritable party either. They were not there from the beginning. There's not a single agreement. Then what they do, Malad, they refer to the deed of hypothecation. But I'll show that.
Yes, sir. Your
lordship has seen. Malad, the deed of hypothecation contains an arbitration clause. But here there's no invocation of that. Malad, just because you are a financer, you can't come and take whatever points you want. You had invoked the loan agreement. There is a hypothecation agreement, which has a separate arbitration clause. You cannot now say the common loan agreement has got no arbitration clause, but the deed of hypothecation has. Malad, this is not in the nature of a writ petition. Here, Malad, these are private agreements. They have not been able to show that.
Yes. That's all.
Malad, no, that's not all, Malad. Now, Malad, what to call him now? The pencil doctor. Yes. But kindly sees page 47 of the common loan agreement, Malad. And kindly see 3.4.
Page?
Sorry, page 47 of the common loan agreement. Petition, the first petition, 91.
What? Yes.
But if there was any shortfall, to the security provider, they were supposed to give notice. But they've never given any such notice. Then that means, they know that the security is good enough. This is the common loan agreement. 3.4, if at any time financial lenders are of the opinion the security providers have become inadequate to cover the obligations, the lenders advising the borrower to that effect with a notice, the borrower shall immediately provide and furnish in favor of for the benefit of the secured parties. The lender satisfying such additional security as may be acceptable to the lenders when the security by the security provider shall be the satisfaction of secured parties. Well, there is no such notice. Then kindly has a look at clause 8 point.
Yes.
3.2. They have a right of security interest, because this is under the they are asset reconstruction companies. So they could have taken steps. They have not taken any steps. 8.3.2. And now kindly comes because they have referred to this clause, the arbitration clause at clause 10.4.1, page 78. The supplementary agreement বের করো তো ওরা সব কোথায় গেছে আজকে কোথায় গেছে সবাই কি অদ্ভুত ব্যাপার
Yes.
Clause 10.4.1 Malit.
Yes.
.4.1 kindly in the just in the middle Malit. Or including an event of default between the parties here to Malit has got that.
Yes.
Then the parties hereby agree to refer such dispute or to arbitration. Now what do they say Malit with regard to this clause? Malit kindly sees.
What are the parties?
They were trying to take the benefit of this parties, Malat, but again, Malat, MNOP. And at the very beginning of this, Malat, your Lordship will find the one is me, Malat, that is not a problem, Malat.
Power trust.
And Malat, and person set forth in schedule 1 from whom the borrower shall avail financial assistance as set forth in schedule 1A.
Yes.
Here too. Individually referred to as lender, Malat, the next part Malat, that has been shown, which expression shall unless it be repugnant to the subject or context thereof, be deemed to mean and include all or any one or more of them as the context may require or admit. Other than that, Malat, kindly then their respective successors and also any other banks or financial institutions or any other persons to the rights and obligations of all or any one or more of the aforementioned lenders are assigned, novated and transferred to the second party. Now 1A is Malat at page.
Where is 1A?
Just gives me a moment. Page 89, Malat. And kindly see, Shrey stroke original lender. So SIFL is not the original lender. So the party is only SREI.
Yes.
Now to say that 10.4.1 includes them, Malat, cannot be the case. And also, Malat, I have shown, Malat, in the Malat, the agreement, Malat, which they have shown now, the business transfer agreement. There also, Malat, this does not form a part of the continuing litigation. It's not there.
So as per your case, the business partners agreement, there is no clause at all.
Malat, there are only two clauses. One where they identify my
correct
this portfolio, and there is one which says about running litigations, which I will talk about more. And the rest are all black, so I don't know what is there. So there has to be something today. Once they came, ACFL came, then they withdrew, then now SIFL. But I am only this sine qua non first point, it has to be shown.
Okay.
Now Malat kindly comes to my opposition, Malat, very quickly, Malat. No. Well, kindly takes my opposition.
Of 91.
Well, 91. But I have that kindly straight away comes to Malad. And I just want to show that the point has been taken, Malad. Just gives you a moment, Malad. I have specifically taken the point. Just can't find it. Yes. But at para 10, I have challenged the locus of the petitioner to maintain this application. And then Malad will kindly have a look.
Para 10.
Malad, this is affidavit and opposition on behalf of the respondents, Malad.
Yes.
Para 10 at page 14, Malad.
Achha, yes. Yes.
Malad, para 14, I have disputed the amount which they were claiming. Para 14 and para 16, Malad. Now, Malad, para 18, Malad, your lordship will kindly, excuse me, Malad. Deed of hypothecation prepare kar do.
Yes.
Malad, I have also said that there was a specific deed of hypothecation also. Malad, that, Malad, page. Malad, this is at page 152, volume 2, CP 90, AP 91, Malad.
Yes.
Volume 2 volume 1. Right. 152. Malad, kindly comes to page 152, Malad. This is the deed of hypothecation.
Yes.
But kindly sees this has been made between Power Trust and SCFL, who is before your lordship. Here, my lord kindly sees F, my lord. If your lordship kindly sees F, clause F at page 155.
Yes.
The borrower currently holds 32.37 crore shares of IPCL, which are of substantial value. Now the borrower is intending to sell the IPCL shares as per the order of the Honorable High Court and transfer the sale proceeds against repayment of the loan facility to the lender. Now, Malad, that is what they're trying to enforce before your lordship. And Malad, this is not the invoked agreement. Now kindly see G. Hence the parties have mutually agreed that the borrower shall create charge on the sale proceeds arising out of sale of the G. Malad got that, Malad?
Yes, yes.
Malad, hence the parties have mutually agreed that the borrower shall create charge on the sale proceeds arising out of sale of the IPCL in favor of the lender after adjustment of necessary expenses incurred for the sale. So, Malad, that was the deed of hypothecation, which has not been invoked. So, Malad, the security which they are claiming, Malad, is pursuant to this, and that was the agreement. Now, Malad kindly sees this deed, Malad, Malad has the arbitration clause.
Page?
Just a moment. Page 167. আজকে এই থাকার পাচ্ছি না লর্ডশিপকে ক্ষমা চেয়ে নি ভীষণ গরম লাগছে
Yes.
And in the event of any dispute, or difference arising out of in connection with the interpretation and implementation of this deed, or out of in connection with any breach or alleged breach of this deed, between the parties here have agreed to refer such dispute to a sole arbitrator.
Yes.
So if it's a breach of this deed, and what is this deed? Sell of the IPCL shares. So, Malad, what they are trying to do, Malad, by invoking the common loan agreement, they're basically trying to get the order out of the non-invoked, Malad, deed of hypothecation, which is a separate arbitration clause, and that's a dispute which has been referred to, Malad. So, Malad, if there is a dispute, they should have referred it, rather than coming before your lordship and trying to get it executed. But I am saying this cannot be an interim measure vis-a-vis the common loan agreement and the disputes between the parties.
Yes.
Well, it kindly gives me 15 to 20 minutes another day. I'll finish. I'll just show the judgments and complete it. Other than the 22nd or 22nd.
Yes.
Other than the 22nd.
22nd?
Other than the 22nd. Anything.
That's in the 22nd.
And 2nd to 5th. And 2nd to 5th. 22nd of July and 2nd to 5th of August. Kindly excuse me.
Then at counsel for the respondents are argued the matter at hand.
I'll take 20 minutes when I finish.
But due to paucity of time, hearing could not be completed.
Your Lordship.
This is the matter on
Your Lordship, the interim order.
19th August at 3:45. Interim order extended till the next date of
19th August.
Gratefully.
That Ashika has offered that SEBI be notified.
Learned counsel for the Asika submits that if the SEBI will notify with regard to the petition Respondents. With regard to note, with regard to the compliances for sale of this by this court, Muhammad Yasika is ready to comply with the same. Comply with the same if parties are objection. If the parties to the present application and
The Lordship has been extended the interim order.
yes,
extended.
Lordship, a very small indulgence, Your Lordship. Your Lordship, I've been, Your Lordship, item number 4, Your Lordship, Your Lordship, I've been in the court every day, Your Lordship, since past 1 month, Your
I
Lordship.
am
Only,
also every day.
Your Lordship, only today, Your Lordship, I've been patiently waiting for my matter, Your Lordship. Only today, Your Lordship, because of rain, Your Lordship, it has been raining heavily since morning. I was stuck in traffic
But
since
there,
past
there is no
2
running.
hours.
See,
Your Lordship, I was in NCLT in the morning. In the second half, I was supposed to come here, Your Lordship. Since past 2 hours, I was stuck in traffic. Your Lordship, I apologize, Your Lordship. May kindly humbly allow, Your Lordship, may kindly keep it as not today, Your Lordship. If Your Lordship agrees, then Your Lordship may kindly shift it to the next month. Your Lordship, I have no original side. Your Lordship, may kindly allow, Your Lordship. Your Lordship, it has been raining heavily, Your Lordship.
Any day.
Your Lordship, humble request, Your Lordship, may kindly allow.
of rainy day, not today.
Oblige, Your Lordship.
Last in
Oblige, Your Lordship, very.
rainy day
Bumper.
benefits. Beautiful.
Oblige, Your Lordship.